Good morning. It being after 9 o'clock, we're going to start the public hearing this morning. If you would all please join me in saying the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. At this time, I'll recognize the prime sponsor, Representative Mannion. Which one? For HB 32. Are you here for that? Okay, Speaker Shurtleff.
Thank you, Mr. Chairman. With my scribbling, I don't wonder why you had a problem knowing who was going to speak first. For the record, my name is Steve Shurtleff, and I represent Merrimack District 15, which is Ward 1 of Concord, the village of Pennacook. And I'm here this morning, Mr. Chairman, to introduce to the committee House Bill 32. Let me just say, as the former chair of this committee, it's nice to come home again. And I can honestly say my two happiest years in the House were on this committee.
And the committee welcomes you back. Thank you.
Oh, thanks. Mr. Chairman, in 1990, the federal government passed the Gun-Free School Zone bill, and it was the assumption of law enforcement in local school districts that that bill would cover them in New Hampshire. And a few years ago, before then Attorney General Gordon MacDonald was elevated to Chief Justice, he issued an opinion to local law enforcement that said, no, you cannot really enforce the federal gun-free school zone bill. That has to be done by federal agents. And so for the past 3 years, we've been somewhat in a gray area as to what to do. The bill I'm proposing today would be the New Hampshire's version of gun-free school zone. And let me just say, Mr. Chairman, I speak today as someone who is not anti-gun. Believe it or not, I've been a licensed hunter in New Hampshire for 60 years now. Yeah, I'm really that old. And all during my working career, I carried a firearm. 3 years in the military, a year in Vietnam as a Concord police officer, then 26 years with the U.S. Marshals. I was a past member of the Alderbrook Sportsman's Club. So this isn't any anti-gun legislation. The purpose of this is to keep guns out of school that shouldn't be there. I tried to, in developing this bill, take into mind the fact that when I was in high school, I used to go deer hunting after school, and you bring your gun to school and you go hunt. This bill allows for people to bring a vehicle on the school grounds with a weapon in it. It's just got to be secured. The same with someone visiting the office. They can have their gun secured in their vehicle and they're fine. I tried to put the penalties as minimum as I could. First offense is a B misdemeanor. Second offense is an A misdemeanor. And then if you're a third time, you obviously don't understand, then it elevates to a felony. I introduced this bill because I've got 2 kids and grandchildren in school. My 17-year-old daughter is in high school, and my 12-year-old grandson is in middle school. I can't understand why any responsible gun owner and concern into any student that sees them thinking, is this going to be the day that I die because of the national violence we've all seen? So, Mr. Chairman, I know you've got a lot of work today. I'm going to end there. I hope the committee will support this bill, and I'd be very glad to answer any questions I can.
Representative Mannion.
Thank you, Mr. Chair, and thank you for taking my question. I don't see any time restraints on this, so if it's 2 in the morning and you're driving within 1,000 feet of a school zone, this applies to you as well?
If you're driving through a school zone?
Yeah, does this apply to you as well within 1,000 feet of a school at, say, 2 in the morning? I don't see anything in here that allows it, that restricts it only during school hours.
Exactly. I think a lot of times school activities can go for great periods of time. From high school proms and dances to basketball games, things of that nature. If you're driving past the school, you're fine. It's when you're stopping at the school and you're going to go, you're on actual school property that the law would take effect, that you've got to secure your weapon.
Follow-up?
One follow-up.
Am I understanding it wrong? It says within 1,000 feet of a school? So that would mean beyond the school's actual physical property?
If you are in a field the bill makes an exemption, for example, a local homeowner or somebody traveling through, going from point A to point B, driving by the school. It's when you stop and park down the street, and we've seen that. Sadly, we saw that in Texas recently, where the perpetrator parked probably a quarter of a mile away and then walked to the school with his long gun. That's when the law would take effect. But if you're going from point A to point B, or if you're a homeowner or a business, then you'd be exempt from this law.
Thank you.
Thank you for the question.
Thank you for introducing your bill this morning.
Thank you, Mr. Chairman.
At this point, the chair recognizes Tom Mannion. Mr. Tom Mannion. Thank you, Representative.
Thank you. Thank you, Mr. Chair, members of the committee. My name is Tom Mannion. I represent Hillsborough 1, Pelham. I'm here to testify in opposition to HB 32. It's a common expression I use when discussing why I carry. When seconds count, the police are only minutes away. This bill prohibits the type of personal rapid response in a crisis situation anywhere near a school. It creates a publicly advertised soft target. In other states with similar provisions, this is the exact type of area where mass shooting events occur, places where there is the least amount of resistance from law-abiding citizens that obey these ordinances. The bill shifts responsibility of defense of life entirely onto law enforcement. And while it's more comfortable to think that the Uvalde Police Department is the only department that would wait outside the school for hours and tase you if you try to enter to do their job for them, I'm not confident that would be the case. You see, courts at all levels have repeatedly affirmed that law enforcement are under no obligation to risk their lives to save yours or the lives of your loved ones. I know the reaction to mass shooting events is to do something, and I agree, but this is not the right something to do. The solution to this problem is not to prevent teachers, janitors, counselors, or parents from on-site from being the first to respond in a crisis situation. Frankly, I'm of the opinion that more teachers should take firearm training and carry. To me, it is akin to any other emergency situation, learning the Heimlich maneuver, CPR, automatic defibrillator usage, what to do in case of a fire, etc. I don't believe in mandating carry, but administrations being more encouraging for it and including training courses for those that are interested would be nothing but beneficial. With that, I ask you to ITL HB 32, and I'm willing to take any of your questions.
Thank you for your testimony this morning. At this point, the chair recognizes who's on. Mr. Anders Schiller. And just for anyone wishing to testify, if you have a pink card, please turn it in now. Not hold it to the end. At this point, I'm not going to limit testimony, but if it gets too much, I'm going to have to put a time cap on them so that we can all get out of here before the sun goes down, hopefully. So if you have a card, please bring it forward, and you may commence. Thank you.
I just want to quickly testify that firearms are a source of protection for kids that are in schools. It's not something kids be afraid of, and possession of firearms should be fully legal on campus. Another thought, I don't know if you heard about some of the news of teachers doing adult content on school campuses. This is a deterrent for that kind of behavior, and also a source of help in case there is some sort of dirty behavior going on schools. That's all I wanted to say. Thank you, sir.
Thank you for your testimony. The chair calls William, last name starts with an R, the rest I can't decipher. Yeah. Sir, push the button. And if you could say your name for the record, just 'cause-
William Rogers,
Thank you.
Winchester, New Hampshire. I'll tell the sponsor why I would carry a gun in a safe school zone. If I was going for my grandson or my granddaughter, I'd want to protect them because it's well documented that quote unquote safe zones, gun-free zones, are targets for criminals because there's no guns there and they can do what they want. That is why I would carry a pistol to pick up my granddaughter or my son or my grandson or any of them. That's why. To me, a firearm is just a tool for protection. It's also a tool of enjoyment for marksmanship and hunting, but in that case, it's for protection. That is why I oppose this bill. Thank you for your time. Also, thank you for everything you do. It's the second day I've been to these meetings. You guys are like saints. I don't know how you do it, listen to the stuff all day long, but thank you.
I think my third grade nun would disagree, but thank you anyway. At this point, the chair recognizes Mr. Brian Blackton. What's this?
I ask ITL this bill, does this bill indemnify a person who has a legal right to be in proximity to a school who may be a witness to an active shooter and take appropriate action with his or her legal firearm to neutralize said shooter in order to save lives? Or are they merely supposed to call 911 and watch as carnage unfolds and do nothing? Thank you.
Thank you for your testimony. At this point, the chair calls Mr. Skip Bernian.
For the record, I'm Skip Frederick Berrien from Exeter, New Hampshire, former member of the House and vice chair of the Children's and Family Law Committee.
Allow me to correct it then, the Honorable Mr. Frederick Bernian.
Thank you. I'm a retired pediatrician. 8 years ago, I testified before the Commerce and Consumer Affairs Committee in the shadow of the massacre of 20 children in Newtown, Connecticut. Nicole Hockley, mother of Dylan Hockley, was one of the 6 children who was murdered in 2012. She appeared here before this committee on that day, asking this state to take action to prevent a similar episode from occurring in New Hampshire. The killer in the Newtown massacre was born in Exeter and spent part of his childhood here in New Hampshire. Sandy Hook could have been Main Street School in Exeter or any elementary school here in New Hampshire. Now, 8 years later, what have we done to reduce the risk of this kind of school massacre? I say nothing. Instead, the legislature has voted to prohibit enforcement of federal protections in the case of firearms threats in New Hampshire schools. Our children are educated in fortress-like structures where children practice hiding from armed intruders. With the continuation of school shootings, no wonder our children are experiencing more angst and mental health deterioration. HB 32 is one of many necessary steps to acknowledge that there are millions of guns in this state, some of which can get into the wrong hands, and create mayhem in our schools. HB 32 provides a modicum of protection for our children and may provide our children with reassurance that we are looking out for them. HB 32 does not restrict anyone's guns rights. or except on school premises where they cannot possess a gun. I urgently urge you to vote OTP on HB 32. Thank you.
Thank you, Representative. This time, the chair calls the Honorable John Burt.
Thank you, Mr. Chairman and fine committee members. I am former Representative John Burt. I served 12 years in this House, and I'm taking a small break. Mr. Chairman, I would guess you would know I'm opposed to this bill. This bill is not needed. I've had dozens and dozens and dozens of teachers call me when this bill was before us when I was serving as a state representative. And they also opposed this bill because bottom line, we have teachers carrying in this state. New Hampshire has never had a school shooting, and there's a reason. Because the nuts out there understand that our teachers are carrying guns. Also, that the citizens are carrying guns in our schools. So I hope that this bill will be ITL'd. Mr. Chairman, let me tell you about Parkland, Florida. There was a school shooting down there, pretty bad one. It was a gun-free zone. Mr. Chairman, guess what it is today? It's not a gun-free zone. They've armed the teachers because they said they don't ever want to see what happened that dark day. The teachers in Parkland, Florida are currently carrying guns. It is the only way to protect our children. Because as Parkland, Florida, and that school in Texas showed us, the police do not have to go in and protect the children. They can hide outside and beat up on the parents that are trying to get in to protect their children. So I don't understand how anybody could vote for this knowing those two schools had police officers, Parkland, Florida, they hid outside. The Texas, Uvalde, Texas, they were pushing the parents back not to go in there to protect their children as children were being shot. New Hampshire has never had a school shooting, and I believe, again, it is because our teachers and our citizens carry guns in our schools. We've never had a problem, so I don't know why this bill is needed. But as I said before, Mr. Chairman, on the House floor, as a state representative, that I served proudly for 12 years to fight these bills, what I said is if this bill passed, there will be a school shooting in New Hampshire. And there'll be dead children and dead teachers. And the blood of those dead children and dead teachers will be on the hands of whoever votes for this. So I hope that every one of you understands that we don't have a problem in New Hampshire. We're one of the safest states in the country. So I ask you to ITL this and ITL it fast. Thank you.
Thank you for your testimony. This time, the chair calls the Honorable Maria Perez.
Good morning, members of the committee and everyone in the public. Thank you for taking the time and coming and testify on this bill. I'm here in support of this bill. Let me tell you why. I'm going to give you a little bit of background. I grew up in El Salvador. Before I moved here, I used to hide underneath my bed. We used to go to school with white towels, anything white, just to try to protect our life. Guns, violence, that was everywhere. When I was 6 years old and my sister was 7 years old, we went to our school. We found our principal of our school killed in the girls' bathroom. That was the worst traumatized thing that I ever seen in my life. We found a body and blood everywhere on the floor. I don't wish any kid to go through what we went through. We don't need guns in the schools or around schools. I can tell you that guns in the school is not going to make us safer. Guns around school is going to make us scared. And for a lot of us who've been traumatized with things like this, it's going to open scars. I'm not here to take away anyone's right to have a gun. That's not what I wanted to do. But I just want a safer and a better environment for the children and for everyone who have been through the things that my sister and I went through. I wish my sister was alive so she can be here to testify like myself, but she's not. She passed away 13 years ago. All the scars and traumatized that she went through because of the gun violence. She passed away not the way that I wish I can tell you that she did. But she started using drugs, and then she died from HIV. But gun violence, it was a scar that she had all her life until she passed away. So I asked the committee to support this bill. For people like my sister, that she's no longer here, she doesn't have a voice anymore. And for many of us, that we still walking around with the scars. Thank you so much.
Thank you for your testimony. The chair recognizes Representative J.R. Hole.
Good morning, members of the committee. Someone on the way up said it's difficult to hear. I don't know who's running the sound system. So for those speaking, yell into the microphone, I guess. I'm here in opposition to this bill for multiple reasons. One of which is it will not address a criminal who's intent on doing harm. At the end of the day, adding additional prohibitions on law-abiding citizens will only increase the risk of an incident in New Hampshire schools. I think everybody in this room has a common goal of making sure our children are safe, but this is the wrong way to go about it. First and foremost, whether the instructor in the classroom wants this role or not, they are the only adult in the room, and if there's a problem, they will be, because of proximity, the first responder to any incident. I had a conversation several years ago outside of this hall with someone who was vehemently anti-gun. And we had a discussion about whether teachers should be carrying mace, should be carrying pepper spray. And the reason we had that discussion, and the person agreed that was an appropriate solution, because we both realized that the first responder in all situations is the adult in the room when you have children. This bill, as filed, will make our schools more dangerous or less safe, depends how you want to say it. I would ask that you would ITL this bill. There's no reason for it. Our schools are safe. There are faculty and staff members who do carry. Okay, there are people ready and willing to respond who live adjacent to schools. And this bill is unnecessary. Thank you.
Thank you for your testimony. The chair recognizes Leonard Coro, Dr. Leonard Coro. Yeah.
Thank you very much, and thank you for your work in trying to enhance public safety in our state. This bill is a bill to try to make schools safe. Our teachers and our students and administrators and other people in schools are really frightened and anxious. Kids are anxious. I'm a psychiatrist. We see this so often these days. And this is a bill to keep guns out of schools so we don't have accidents and we can begin to make our schools as safe as they can be. Thank you very much.
Thank you for your testimony. Chair recognizes Mr. Timothy Wolf.
Thank you, Mr. Speaker. I would just like to voice my opposition to this proposal. I certainly understand the intent, and I think we all agree we want to make schools safer. I think our minds automatically go to Columbine areas, mass shootings like that. I think the thing that I disagree with this is the fact that we are asking law-abiding citizens to do something, not carry a gun in school, which we won't if this is passed. But if I was a criminal and I woke up in the morning and decided that I was going to inflict harm in a school, I would have no regard for this. So I really do not see. I understand the intent, but I think I do not feel as though this is, if we really ask ourselves, if we pass this law today, tomorrow, is it going to have a real impact? Is this something that our children are going to be safer? When my son is in school, is he less likely to be in harm's way if this is passed? And I have to honestly say, I don't believe he will be safer. I actually genuinely feel he will be less safe, because I think in the instance of people who are doing this type of heinous crime, they have no regard for the law. And I know that their mindset is they want to do something, go down in their last blaze of glory. And I think the immeasurable thing with firearm ownership and people having firearms is you don't know who has a firearm. And if there's the thought, it doesn't have to be a firearm there, but just the very thought of there being a firearm is enough to discourage somebody from going in there, because you're gonna mess up their master plan. And they traditionally, people have gone past gun-free zones, like in Aurora, Colorado. They went past 2 movie theaters to go to the movie theater that had the no gun sign over it. In Amherst, New Hampshire, we had a gun-free zone probably 20, 30 years ago. It was a big community got together and they said, we're a gun-free neighborhood. They started getting broken into left, right, front, center. And when they took that sign down, the break-in stopped. I won't belabor the point, but I just don't, I feel basically we would be losing. I would rather have somebody trying to protect my child. I know there's always, anytime firearms involved in defense, there's always, somebody could get hurt, that you don't intend to. But I would rather that than allow evil to prevail. Thank you.
Thank you for your testimony. The chair recognizes Dr. Johann.
Good morning, members of the committee. My name is Joe Hannon. I'm the Vice President for Gun Owners of New Hampshire, and I'm speaking in opposition to this bill. This bill does one thing. It makes criminals out of people who are not criminals, law-abiding citizens. Someone intent on harming someone or committing a heinous crime is not going to be deterred by a sign or a lesser charge of a misdemeanor or even a Class B felony. If someone is going to do that, they're going to do it. There's not a lot else to say other than this is going to hurt people who could possibly defend themselves in a situation where their life may depend on having a firearm with them. Years ago, when there was the shooting in Connecticut, I was actually in my son's school teaching a few kids, volunteering, And I went home, saw the news, I heard the news there, went home. The next week I went back and they gave me a school safety briefing on what to do if there's a shooting. And since I wasn't an employee, I was just a volunteer, I didn't have a key to the room to lock the door. So they said I couldn't lock the door, but they covered the windows with paper and told us to just line all the kids up against the wall so they can't see who's in the room. That was our self-defense plan. It was ridiculous. For one, there were windows, we could have easily gotten out and gone into the woods. But the bottom line is we're making basically fish in a barrel with this kind of policy. And as a member who was on the school safety task force back in 2018, one of the people that was there to help with some of the policies and recommendations, there were a lot of recommendations, and this was not, I believe, one of them. So please, ITL this bill, and that's all that needs to be said. Thank you.
Thank you for your testimony. The chair calls Mr. John Bunker.
Mr. Chairman, I have testimony. Mr. Chairman and committee members, I'm John Bunker. I reside in Stratham, New Hampshire, and I'm here today to support Bills 78, 32, and 106. I have submitted written testimony, and I'm here to tell you why I'm here today. Last year, on April 26th, I was driving back from Maine on a fishing trip without access to Wi-Fi or radio or cell service, and I heard about the Uvalde shootings. That news report left me angry, scared, and motivated. Angry that we as a nation have failed to successfully address the public health epidemic of gun violence. Scared that my 3-year-old granddaughter will soon be in a classroom. And motivated to become engaged in my community and my state. That's why I'm here. I grew up in Concord. I hunted and fished with my dad and my grandfather. I taught riflery and gun safety. I am also a parent, a grandparent, and a gun owner, and a public health professional. I come to gun violence issue with respect for the vast majority of gun owners in this country who are responsible, safe, and law-abiding members of their communities. I've enjoyed a 30-year career in public health and healthcare. I hold master's and doctoral degrees from the Johns Hopkins University of Public Health. I have done international and national healthcare consulting for private sector, public sector, and nonprofit sector clients. I served for over a decade as the founding president of New Futures, an advocacy organization established by the New Hampshire Charitable Foundation to reduce substance use disorders in New Hampshire. After New Futures, I served as an associate dean and the director of external relations in the College of Health and Human Services at UNH. I also serve on several nonprofit boards, including Goodwill of Northern New England, and I was a former board member of NAMI New Hampshire, the National Alliance of Mental Illness. After extensive study and research on the epidemic of gun violence in our country, today I have strong support for this bill. This bill clarifies that possession of a discharge of a firearm in a safe school zone is illegal and adds criminal penalties if this law is violated. I have several other remarks, but for the sake of time, I will pass on those. Finally, I want to share a quote from a recent editorial that resonated with me. The latest shootings were tragically, infuriatingly predictable. So let's ask politicians not just for lower flags in moving speeches, but also for a better way to honor the dead, an evidence-based slog that saves life. In the handout that I have for you, the testimony, I've left you with 3 references that I hope might be helpful for you as you deliberate your vote. The first is from the RAND Corporation,
It's on the science of gun violence. It's 486 pages, but there's a fair amount of information that might be relevant for this conversation. I've also given you the link to the Johns Hopkins Gun Violence and Prevention Policy Institute as well. And there's a terrific article that's sponsored by the Journal of American Medicine that also has information that you might find helpful. Thank you for the opportunity to present my testimony today.
Thank you for your testimony. The chair calls J.E. Simkin, and I would ask anyone who is coming to testify, please make sure you speak into the mic. The acoustics in this room are designed to go that way, not this way, so if you could speak right into it, it would be very helpful.
Good morning, Mr. Chairman and members of the committee. Thank you for giving me an opportunity to testify. I do have prepared testimony, which I'll hand in. It covers several bills. I figured it was more tree efficient and less burdensome to you to have short comments on each bill, but there are obviously bill-specific comments.
Your testimony that you're handing in is good for all the bills, but if you could limit your testimony now to just the
Yes.
bill in front of us.
I thought it was a little, again, more efficient. I'd like to hand this in, if I may, so that the members can look at a table, of data. I don't think anyone else will present these data to you. On the third page of my testimony is a table of data drawn from the FBI's uniform crime reports. These data, which cover 20 years from 2001 through 2020, show the incidence of violent crime per 100,000 residents for the New England states. A time series this long, and as I'll point out, so consistent, likely is fairly representative of reality. Sometimes data series bounce around a lot. For example, gains or losses in jobs varies widely from month to month. These data, annual, are very consistent. They show that over this 20-year period, the incidence of violent crime in New Hampshire, with a one-year exception, has been among the 3 lowest incidences nationwide. We live in a very, very safe state. Second, if you look at the line of data for Massachusetts, it shows that the incidence of violent crime in Massachusetts throughout this 20-year period has been at least twice that of New Hampshire. I point out, for the benefit of those who may not be familiar with Massachusetts laws as to firearms, they are voluminous. I deem them nasty and repressive. So over 20 years, if gun control laws were beneficial, one would have thought that would be obvious in Massachusetts, because periodically they add to the volume of their laws. It's brought down the level of violence there, but it's still twice that of New Hampshire. Now, to the specifics of House Bill 32 FM. It is so vaguely drawn that a purpose of it, stated or not, must be to ensnare those who are unaware. In a small town, a gun-free school zone could cover the entire town. So I have visions of towns being fenced off as East Berlin was from West Berlin in the bad old days. You know, you're leaving New Hampshire, you are entering a prohibited area. Okay, if we're gonna do that, that gives a person notice I'm carrying, I have to do a U-turn and go around this town. The practical impact of this is that law-abiding folks who have no ill intent are going to be ensnared. I don't know, and I'm not asking now because it wouldn't be proper, how many members of the committee
have actually litigated against a state. I've done so twice. I hold in my hand a Massachusetts temporary non-resident license to carry firearms. It was wrongfully revoked. It was restored to me by order of the Supreme Judicial Court of Massachusetts. That process took 3.5 years, and even with me doing most of the law research and drafting pleadings for my attorney's review and signature, cost about $125,000. The data in the fiscal note attached to this bill come from some other galaxy. It's the only way I can describe them. There's some imaginary rate that attorneys are deemed to charge. It doesn't correspond to the facts. So that most folks charged under this bill, should you decide to enact it, are either going to be bankrupted or they'll take a plea because they can't afford to fight it. That kind of law should not be enacted, not only not here, members of the committee and Mr. Chairman, shouldn't be enacted anywhere. It's a trap. It's going to cause folks to acquire criminal records who didn't have any criminal record, and the consequences of that, even if they fight it, and even if they succeed, could well be job loss, family problems because of the financial strain, and reputational damage. Those who propound this kind of measure may have noble intent. The road to hell is paved with noble intentions. In conclusion, and I'll be happy to take any questions you may have for me, please do not enact this bill or any similar.
Thank you for your testimony this morning.
Thank you.
The chair calls Kimberly Morin.
I'm short, so this is easy for me. My name is Kimberly Morin. I'm here representing the Women's Defense League of New Hampshire. We are a grassroots, all-volunteer, woman-run organization who teaches women in New Hampshire and the states surrounding how to safely and accurately shoot firearms. This bill does nothing to stop criminals from going onto school grounds with firearms. Nothing. It's already illegal to go on school grounds with a firearm unless you have a pistol revolver license. That's federal law. What this bill does do is stop law-abiding citizens from protecting themselves and children from criminals intent on doing harm. It also makes women who have either left abusive relationships or have stalkers unable to protect themselves for the mere act of dropping their kids off at school. The mom who fled to a new city and has to walk her kids to school, but is always looking over her shoulder for her abuser or her stalker, will be further victimized by this legislation if it were to pass. This legislation is written by an out-of-state organization, not all of these gun control bills are, and it seeks to solve a problem that doesn't exist in New Hampshire. And again, this bill will not stop criminals from bringing firearms onto school grounds. In fact, criminals seek out gun-free zones because they know their victims will be unable to protect themselves. Please vote inexpedient to legislate on this bill. All it does is make Granite Staters, especially women and children, less safe. Thank you.
Thank you for your testimony. Please refrain from clapping. The chair recognizes Mr. James Gaffrey. Thank you.
Thanks, Chair. This isn't the first time we've seen this bill. It's come up in various forms in years past. Most of you have heard the same testimony over and over and over. This bill won't accomplish anything. The only person that can defend you and keep you safe and your families is you. The Supreme Court's already come to a decision years ago that the police have no obligation to defend you. This is settled law. So the only person that can defend you is you. And so you're going to restrict people's ability to defend themselves? That doesn't make sense. I mean, how many states do we have to look at that already restrict firearms in school zones and other places which are keep having school shootings time after time after time? Police can't protect you. The laws that you guys pass can do nothing but punish people after the fact. This bill will accomplish nothing but make schools less safe. Period. End of discussion. It's proven in liberal state after liberal state. If gun control worked and keeping guns out of people's hands, then Chicago, New York, name a city would be like the safest places in the world. But instead, they're the most dangerous because nobody can defend themselves from bad people. So what are we going to accomplish by doing this? Nothing. The structure of the bill is terrible. We've beat this to death. And what disturbs me most is that the sponsors of the bill keep hearing the same stuff over and over, and we keep looking at the same bad results in states that have enacted stuff like this, and yet year after year after year, we get the same dumb idea presented to us. And I'm sorry to be offensive, but that's the fact. I want results. I don't want fluff. And this won't accomplish anything. Any questions? Oh, one other point. This bill in its structure doesn't accommodate what if you have a situation where a parent is walking a child to school. There's no accommodation for that person to carry a firearm and take care of it. It's one thing if you have a car, but not everybody drives. There are lots of people that walk their kids to school. So the structure of this bill is terrible. The ideas behind it don't accomplish anything, and it's only going to make us less safe. Any questions?
Thank you for your testimony.
Have a good day. Thank you.
The chair calls Nancy Brennan.
Good morning. My name is Nancy Brennan. I'm from Ware, and I thank you for being here and for this long day ahead of you. I find it ironic and more than a little sad that in these weeks that we are discussing this bill, there are other bills being discussed that would supposedly keep our kids safe by not letting them read certain books, or keep our kids safe by not letting them use the bathroom. And yet this bill that deals with deadly consequences should have full support. Will this bill by itself save all our children? And will it make sure that we never have a school shooting? No, it will not. But this bill, along with some other very good legislation, such as a piece I heard, I think, yesterday on health care, mental health care for kids, along with some of the other bills you're going to hear today, would go a long way in making a huge difference. I grew up at a time when the hunters brought their guns. You could see them in the back of the trucks because it was hunting season. And I'm not even sure they locked their trucks. The world is very different. If you doubt it, go back and look at the speech last night and the angry, partisan way we treated each other. It is not the same world, and we need to do something. This is one little piece. I am a teacher, no longer, but once a teacher, always a teacher. And with all due respect to my former representative who said he had talked to dozens and dozens of teachers who want to carry guns, I too have talked to dozens and dozens of teachers here in New Hampshire and across this country when I was lucky enough to be New Hampshire's Teacher of the Year and travel and meet with other teachers. And everyone I talked to agreed, we are busy trying to teach the kids to read and write. We do not want to carry guns in our classrooms. I believe in the Second Amendment. I actually own a gun, and I'm a pretty good shot, but I would never have a gun in my classroom. And if you think it would make a difference, I'm sorry, you are terribly, terribly wrong. There was a story or a person who was interviewed when Gabby Giffords was shot, and he was a person, a civilian that was allowed to carry a gun, and he was there and he heard the gunshots, and he said, by the time I got my gun out and tried to figure out who was shooting who and who I should protect, it was over. If you've ever taught middle school, that's kind of what it feels like sometimes in a middle school classroom. I would urge you, pass this bill, pass these mental health bills, and let's begin to change the narrative. There is a poem called America is a Gun. A lot of you may have heard it, but it talks about every country. What are they known for? Wine, cheese, this, that. And every verse ends with, America is a gun. Let's change the narrative. Let's make a difference. Thank you.
Thank you for your testimony. The chair recognizes Brian Barry.
Good morning, citizens. Good morning, representatives. Thank you for taking time out of your day to be here. It's good to see our Republic in action. I'm happy. I just want to read briefly from the New Hampshire Constitution. Part first, Bill of Rights. Article 2A, bearing of arms. All persons have the right to keep and bear arms in defense of themselves, their families, their property, and the state. Their families, our families, New Hampshire families. Guns are not the answer to the world's problems, and I don't think anyone here, no matter what side you're on, believes that. However, there are well-documented instances where a firearm stops another bad person with ill intent who has a firearm or a knife. These have happened in churches, Walmarts, and even schools. Oftentimes, it's a school resource officer that would stop the assailant. Now, to the best of my recollection, we have not had a school shooting in New Hampshire, thank God Almighty. But criminals don't like challenges. And I'll draw my law enforcement and military experience to guarantee you that. That's why they give up when uniforms show up. As it was pointed out earlier, officers do not have a duty to protect you or your family, society in general. I love our law enforcement, and 98% of them will step in front of you or me and take a bullet in defense of us. Some won't, as evidenced in some of the school shootings that we've seen documented in videos. They sit there and wait. And that's unfortunate. Does that mean because I'm carrying a firearm in school legally that I'm going to be a hero? No. Does it mean it gives the kids and teachers and people in that school a fighting chance if I choose to engage that bad person? Yeah. Maybe I draw enough fire. Maybe I get killed. Maybe it gives the kids a chance to get out. Maybe I go down. Maybe I stop them. This bill, I believe, is well-intentioned. We want safe schools. I do believe that. I don't think anyone here is doing anything out of spite or not what they feel pure in their heart. But there is a reality here that evil exists. It does. Some people just want to see the world burn. I've seen it firsthand. There's many good people here today who have a belief different than mine that a firearm in school would save the lives of students and teachers, and I respect that. But I'll bet you a coffee from Aroma Joe's, if I was at their child's school and I took action, whether I fall or whether I make it, that they'd be happy someone did something that gave those kids and those teachers a chance to escape. We can look back to the 50s and 60s when there were shooting teams in schools, and we didn't have the problems we have now. Society has changed. We need to fix that. Mental health's a big deal, 100%. But this bill, ladies and gentlemen, respectfully, is not gonna cure evil. It will not stop someone who has intent. I want you to think about that, please, when you cast your votes for this. Thank you for your time.
Thank you for your testimony. The chair calls Joanna Brown.
Thank you all. My name is Joanna Brown from Manchester, New Hampshire. I have to drop off my daughter at Manchester Central High School, which is one of the most highest crime-ridden communities. What's worse is that I have to park in the back lot in the dark, waiting for her to get home from the bus from sporting events. My heels lie. I am 5 feet tall. I cannot defend myself against any aggressor, not one. So if I decide to carry a firearm to protect myself and my daughters in the worst city in the state, you're taking away my right to defend myself and my daughters. You're attacking the wrong people. Criminals don't follow laws. They don't follow gun laws. They don't check what the rules are. They just do what they want to do and attack the people they want to attack when this urge strikes them. I don't know when that urge is going to be, but I can't protect myself and my daughters on the dark streets of Manchester. So I vehemently oppose this bill. Thank you very much.
Thank you for your testimony. Again, please refrain from clapping. The chair calls Marcel Dubie? Marcella? If everyone wonders why I'm struggling, I promise you I can read.
Hi, it's okay. It's Marcella Duvy. Thank you. It's a nice French name. So my name is Marcella Duby. I am a resident of Amherst, New Hampshire. I am a volunteer member of Moms Demand Action. We are probably very well known in this room to many of you. We believe in responsible gun ownership and support gun owners' rights. But there are several instances where we need to have laws and guidelines to protect our children and to protect our society. There are many, many bills for lots of things. This is only one of many bills. It can't just be this one that protects the kids or protects our citizens. I am reading testimony on behalf of my dear friend Jean Alute. She is a school board member in the town of Amherst. Restoring gun-free school zones to our state is something that I feel passionate about. My experience as a school board member of the Souhegan High School in Amherst for 13 years was especially emboldening because, as you know, school board members are entrusted with maintaining a safe learning environment for the children and in their districts. In addition to being a board member, I was also on multiple security study committees over the years. After a year-long study, recommendations were made for how to improve security in our schools. And I'm going to take a moment and just mention that after many, many years, Sauhegan finally got a buzz-in door at the front. For many years, you could just walk straight into the front. So that's and also an important factor is security in our schools. Unfortunately, the state legislator's decision several years ago to allow people to carry guns into schools makes safety an almost insurmountable challenge. We would have to create a prison-like environment for our children in order to ensure that bad people with guns never entered our schools. This bill to restrict the possession of or discharge of a firearm in a safe school zone would go a long way toward protecting our children and school staff. Parents need to feel confident that they are sending their children to a safe place every day. A federal law on gun-free school zones is adhered to in a majority of the states in this country. I believe that we are one of 3 exceptions. I do hope that this committee will back HB 32 and its common sense approach to protecting our public school students and staff from gun violence. Thank you, Jean Blute. Any questions?
Thank you for your testimony.
Thank you for having me.
Okay, this one, I'm going to ask you to come down and fill out the card. Somebody wrote Bear Arms. Well, that's great. I actually need your name, unless that is your name. Could you come forward, please, and fill out the card with your accurate name?
My name is Kang Lu.
Sir, could you?
Oh, you want me to write that?
Yes, please. It's for the record. Thank you.
Hello, ladies and gentlemen, dear legislators. My name is Kang Lu.
Speak into the mic.
My name is Kang Lu. I'm a New Hampshireite residing in Cheshire County. And I'm here to say that, just ask a few questions. Isn't it true that the proposed legislation would not apply to law enforcement officers carrying firearms in school zones during the performance of their duties? Of course it's true. It doesn't apply to police officers. And isn't it true that these police officers derive their power from our Constitution to protect us and to serve us? Specifically, Article 8 of our Constitution says, all power residing originally in and being derived from the people, all the magistrates and officers of government are our substitutes and agents. Because those statements are true, then the intent and effect of this bill is unconstitutional on its face, since it would deprive the people of our original right and power to defend ourselves and our children. Worse still, and even more intolerable, is that the proponents of this bill are working to deprive us of these rights, knowing full well that the Supreme Court has concluded that as a matter of general law, the state does not have an affirmative obligation to protect an individual against private violence. See DeShaney versus Winnebago, 1989. This is a government of delegated powers, supreme within its prescribed sphere, but powerless outside of it. In this country, sovereignty resides in the people, and Congress and legislatures can exercise no power which they have not, by their Constitution, entrusted to it. All else is withheld. If the power is not in terms granted, it does not exist. See Juilliard versus Greenman, 1884, a Supreme Court decision. Thus, I conclude that for facial violations of Article 2 and Article 8 of our New Hampshire Constitution, the Second Amendment, and Article 4, Section 4 of the federal Constitution, this bill must fail. Thank you very much for your time.
Thank you for your testimony. The chair calls Zandra Rice Hawkins.
Good morning. My name is Xandra Rice Hawkins. I'm the director of Gun Sense New Hampshire, a project of Granite State Progress, and the convener of the New Hampshire Gun Violence Prevention Coalition. We support this bill. The Federal Gun-Free Schools Act prohibits students from bringing firearms into schools, and the Gun-Free School Zone Act prohibits all other persons from bringing firearms within 1,000 feet of school property unless they are licensed by the state to carry a firearm. While federal law establishes gun-free school zones with qualifications, gaps in state law and statements from the Attorney General's office has left school districts and police departments in murky water on enforcement and jeopardizes safe spaces for our children to learn and grow. This is further complicated by House Bill 1178, which Governor Sununu signed into law last summer, that seeks to prevent local and state law enforcement and school officials from acting swiftly in response to the presence of firearms in our K-12 schools. A bill this afternoon seeks to further penalize state and local law enforcement and others for taking quick action to prevent gun violence. Federal and state laws ensuring that schools are gun-free zones have helped make K-12 schools even safer, significantly reducing gun violence in these places. The claim that gun-free zones invite mass shootings has been thoroughly debunked by research showing that the overwhelming majority, nearly 90%, of all high-fatality gun massacres since 1966 have occurred wholly or partly in locations where civilian guns were allowed or there was armed security or law enforcement present. In fact, unarmed school staff have stopped more active shooters than civilians armed with a gun, according to the FBI. An FBI study of 160 active shooter cases from 2000 to 2013 found that 21 incidents ended after unarmed citizens restrained the shooter. 11 of those involved unarmed principals, teachers, other school staff, and students who confronted and restrained the shooters. In only 5 of the 160 instances did the shooting end after armed civilians exchanged gunfire with the shooters. Contrast those 5 cases with at least 20 reported incidents where the presence of firearms subjected students to more danger. This bill seeks to clarify that our elementary, middle, and high schools are gun-free. It is critical that this measure passes. If a student or adult brings a firearm into a school in New Hampshire right now, local school districts and police departments face real challenges in how to appropriately deal with it in light of the major gaps in state law. The vast majority of states, 47 of them, and the District of Columbia prohibit carrying or possessing a firearm on K-12 school property or events. Only Hawaii, New Hampshire, and Wyoming do not. This problem will only grow worse as time passes, and especially now that more people realize how loose the gun laws are in New Hampshire. In fact, in the past, some gun groups have even hosted seminars encouraging people to carry firearms in our schools. This includes our classrooms, elementary school recitals, high school football games, you name it. Right now, someone could bring a gun into a school, and unless they issue threats or start shooting students, school and local law enforcement are essentially being told to stand down. In fact, some have been told to contact a regional ATF agent instead of taking immediate action. This means that schools are forced to monitor the situation, directing school personnel and resources away from the primary job of teaching our children. If the person carrying the gun does indeed do harm and start shooting, there will be a lot of second guessing as to what should have been done from the start. This is a major liability and public relations crisis for our schools at best, and we all know what a worst case scenario means. Let's skip the second guessing and empower our local school districts and police departments to take action from the start. Without this bill, they won't have all the options they can rely on to help deter a dangerous situation before it becomes a deadly one. Guns do not belong in our schools. We urge the committee to vote House Bill 32 ought to pass to protect our students, our educators, and our learning environments. Thank you, and I'm happy to take questions.
Representative Reed.
Thank you, Mr. Chairman. Can you just give me the source of the data for the safety of the school-free zones?
Yep, Daniel Webster, Firearms on College Campuses, Research, Evidence, and Policy Implications, a study of active shooter incidents in the United States between 2000 and 2013 from the FBI, and the Giffords Law Center to Prevent Gun Violence has a comprehensive overview of firearms laws at the state and federal level. I will send this by email with the hyperlink.
Thank you.
But I'd said it out loud for anybody else interested. Thank you very much for the question.
Thank you very much.
Thank you for your testimony.
Thank you.
The chair calls Penny Dean, and it appears our microphone situation has improved, so now you can stand at a reasonable distance from the microphone.
I'm not sure what reasonable distance is, but I guess this is it. My name is Penny Dean. I'm from Concord. I'm a private attorney in private practice. And my mother always told me you only have one time to make a good first impression. And I would ask that you ITL this bill. We can start from the beginning where it's a train wreck. Whoever wrote it didn't bother to proofread or even look at what they were saying. Because if you look at page 1, line 5, they reference RSA 189, 13A, Roman 5. And it says specifically, any of the offenses enumerated in that statute. Well, that statute is actually a provision about checking the criminal records for volunteers. So my basic premise is when you start going through this and you look at it, it's gobbledygook that doesn't make sense. Because I look at things like a mechanic. How do you actually do these things? This doesn't work. You had one speaker say this bill would go a long way. And I agree. It would go a really long way and make a difference, a bad difference. And we're looking at death by 1,000 cuts when it comes to people who hate guns. They don't think guns belong anywhere. And they don't like people that carry guns, and they always want a reason that you shouldn't have guns. When you look at this bill, and again, we look back at practicality, even if you wanted to enforce this bill, if you look at page 1, line 19, they talk about the grounds of a school zone. I defy any of you, including the facilities manager for Concord Schools, to show me the property lines of all the Concord property that the schools use. I bet they can't. I know they can't. I can tell you that my property, my back property, backs up with the Christa McCullough School. And they had some trees years ago that grew over my property. And so I was willing to pay for tree cutters because I wanted the branches gone. It took me hours and hours and days to get to the facilities manager, who gave me permission. He said, hey, if you're paying, bring in your people and cut away. But the gist of it is, how are we going to find out who's in charge to get permission to do these things? This was talking about a tree, cutting a couple branches from a tree. And you're asking for permission to carry guns through there for shooting, for hunting, for whatever. Hunting season will be over 5 years from now before you get to the right person. And then you ask with those who are politically, what I call incorrect, they're going to say, well, why can't they walk around this way? Why do they got to walk over the school property with our gun? And what gun are they going to carry? And when are they going to be there? And no. As a practical matter, if this passes, there won't be any people walking across the back of school property. But more importantly, you're going to have people getting arrested. This is one of these bills, I call it make work bill for lawyers. And I already got plenty of work. I don't need more work. I'm very grateful for that. But what you're talking about here is innocent people getting ensnared, not knowing where the boundaries are. And I guess we talk about people carrying firearms in school zones. What's the problem? We haven't had a problem in New Hampshire in decades with with those issues. So just because someone doesn't like firearms, just because someone's carrying a firearm doesn't mean they're going to do anything illegal. And they talk about monitoring the situation. Why are you monitoring any situation? They're not bothering anybody. You need to leave them alone. The other thing, when you go to page 2 of the bill, and again, we go back to look at page lines 19, 20, 21, 22, we go back to about authorized by school authorities. Does that mean the facilities manager? Does that mean the principal of the school where it's located? Does that mean the school superintendent? Who does that mean? So even again, if I thought I were ever so lucky to get the permission of any one of these, any more anti-gun people, do you honestly think, and then we get this, what I call turf war. The principal gives me permission, And the school superintendent says, he wasn't authorized to give you that permission. So you're looking to set people up to fail. You're looking to set up innocent gun owners to fail. But the bottom substantive thing that you should ask yourself, beyond the horrible mechanics of this, someone who drafted this was not a litigator or a lawyer, I can tell you that, is that, do we need this? And the answer is we absolutely don't need it. And it's abysmal, and it's really offensive to the Constitution. It's really offensive. You look at people like this and you say, what are you trying to do here? We've had enough instances in this country going back that when people have had firearms in school zones, lawful people, they've been able to stop things. They've been able to stop carnage. So I respectfully say that this bill is a horrible piece of drafting, a horrible piece of legislation. It's not mechanically sound or legally sound, and it will result in a lot of litigation. But more importantly, is we have constitutional rights, and they trump all of this balderdash of what people don't like. Maybe people feel uncomfortable if I wear pink. Do I now have to wear blue? You know, so I'm happy to answer mechanical questions, but again, this is a drafting nightmare.
Thank you for your testimony.
Thank you.
Is there anyone else who has not turned in a pink card? There being none, I hereby close the public hearing on HB 32. The committee will take a 10-minute bio break.
What's that? Be careful.
Okay, at this point, we're going to resume hearings. If everyone could please take their seats and halt their conversations. At this point, I am opening the public hearing on HB 59, and I recognize the prime sponsor, Representative Marjorie Smith.
Thank you, Mr. Chairman, and good morning to everyone. Guns don't kill people. People do. Now, that's an expression that's been used for many, many years. I'm not sure I ever got my mind around it. And yet I've come to recognize the truth of that guns don't automatically kill people. It's the people who aim those guns. And that's why I believe that this bill is so incredibly important, that is supported by more than 90% of our constituents and by 90% of gun owners, that is, responsible gun owners, and by Republicans. A slightly higher percentage of Democrats support it, but when you're up at 90, that's in the stratosphere. So I think it's pretty clear that this is a bill that is supported by people who want to protect the right of responsible people to own guns. This bill addresses not the gun, but the person who wants to use the gun. I'm not an expert on guns, but I do know a fair amount about people. Most of them, including gun owners, care about gun safety. This bill is to protect us from those very few who purchase and misuse guns for reasons that no responsible gun owner or caring citizen would support, to harm others, and perhaps in some cases to harm themselves. Never having purchased a gun, I was interested to learn how easy it would be to purchase a gun legally. Do you know that there are 59,000 unique gun dealers, licensed gun dealers across the country? That's 4 times as many as there are McDonald's and nearly twice as many as U.S. post offices. Nobody lives more than 10 miles from a licensed gun dealer. You don't have to travel far to be able to legally buy a gun and legally participate in a background check. This bill requires commercial firearm sales in New Hampshire to be processed through a licensed firearms dealer. The bill does close what is referred to as the Charleston loophole. That is referring to what happened in Charleston before one of the most egregious massacres, and that is someone who would not have passed a background check was permitted to have a gun because it took more than 3 days for the report to come back. This bill provides a way to wait until that report comes back. And I think that's important. Also, you will see that I've submitted an amendment. When the bill was printed, the analysis said this bill excludes private non-commercial sales or transfers between individuals, provided neither individual is prohibited from owning or possessing a firearm under state or federal law. Somehow, when the bill was printed, The analysis was there, but that specific language was omitted from the bill. And so I have submitted the amendment that adds those important words, and I believe it's been distributed to the entire committee. In a recent conversation I had with one of our colleagues, he talked about the fact that he wanted to be able to give a gun to his child. He has trained the child in gun safety, and he felt that the child was of an age where he would be responsible. He would be able to do that in the language in this bill. Our distinguished former colleague, Catherine Rogers, brought expertise in her repeated efforts to have a background check bill become law. There will be highly knowledgeable witnesses who will follow me and be better able to answer almost all questions. But I am here not as a gun owner, not as an opponent of gun ownership, but representing the overwhelming percentage of New Hampshire citizens, including almost all gun owners who believe in responsible gun ownership. Background checks make sense. They use existing systems that are familiar to legal gun purchases, and they save lives. I hope this will be the year that this committee will support a carefully drawn background check bill, and I thank you very much for your courtesy.
Thank you for your testimony this morning.
Thank you.
The chair calls Dr. Johannan, and I'm going to start telling you who's on deck just so we can move it along. After that will be Representative John Burke. That idea courtesy of the Sergeant at Arms. Thank you wherever you are.
Good morning again. My name is Joe Hannon, Gun Owners of New Hampshire Vice President. I'm in opposition to this bill as usual. For starters, I'd like to just say that this bill, the main issue is the definition of commercial sale. Now, I haven't read the amendment that's proposed, so I'll just speak to the bill at hand. But commercial sale is transfer of ownership of a firearm, including but not limited to a sale, gift, or exchange. That's not the definition of a commercial sale anywhere else. Commerce involves selling for profit, livelihood. Even the federal definition of commerce and related to firearms has nothing to do with individual trade or gifting to a spouse or family members, things like that, or even individual private sales, which are legal at the federal level. Someone has to engage in the business of selling firearms. So if someone is just liquidating their collection or selling a few firearms and not making a profit, and let me tell you that if you're selling a used firearm, it's generally not profitable. So it doesn't meet the definition of commerce. It's almost, I don't want to go to the length of level of saying it's new speak, but it's definitely changing the definition of a word to make people think differently about not just this bill, but everything that we're going to be governed by. Do we want to change the definition of commerce, not just for this, but for everything? Anything can be commercial trade if this is allowed. Let's see. There's another problem. I'm not really sure if it's possible to be addressed, but it says when someone has to sell, they have to go to a licensed dealer, and the seller is allowed to give them the firearm. The background check will be performed on the buyer, and they shall process the sale as if they were the seller. So now the dealer is a temporary seller. They're acting as if they're the seller at that point. The person who originally dropped the gun off is allowed to remove the firearm from the business premises from the licensed dealer while the background check for the purchaser is being conducted. So if they're waiting for it to be conducted, they can remove it and take it home, do whatever they want with it. But when the background check for the purchaser is completed, they must return to complete the transaction if it's legally allowed to go forward. But if not, it must be returned to the original seller. However, there's nothing that says that they can give it back to the seller without having to do another background check. Now, it makes sense, and I think most people would think that's what would happen, but it says if the dealer cannot legally deliver the firearm to the buyer, the dealer shall return the firearm to the seller after ensuring compliance with all state and federal laws applicable to the transfer, and the transfer to the buyer shall not take place. Well, according to the first definition of commercial firearm, the commercial sales, that's any transfer of ownership. The ownership went to the dealer, and they have to act as if they're the seller. And now you've got to do another background check to get your own firearm back from the dealer. So that is one issue. Another thing is, this is an indirect tax on gun owners in a sense. You know, people without significant means, you know, $25 or $50 for a background check processing fee can be quite significant. So this disproportionately affects people that don't have the means to easily throw away $25 or $50 for every transaction on a firearm. We've heard it's federally illegal to sell a firearm to a felon and other categories of individuals who are not allowed to possess a firearm. This bill does nothing to do anything to prevent legal, law-abiding gun owners from getting a firearm. What it does is it increases the value of the black market. You've now made the black market more lucrative. And I ask you not to do that, and please ITL this bill.
Thank you for your testimony. The chair calls Representative John Burr, and next up will be Timothy Wolf.
Thank you, Mr. Chairman and fine committee members. Again, I am former Representative John Burt. I represented Goffstown, Ware, and Deering for 12 years. Mr. Chairman, House Bill 59 seeks to categorize all sales as commercial, but a gift or a loan between friends, family, neighbors is not a commercial sale. It is a private transaction that should stay private. The government has no business telling people how to or when to dispose of personal property. Mr. Chairman, I am against this bill. We have seen this bill many, many times. We kill it every time. It's not needed. The federal government already does background checks. It works. And I like how they delete the records of my records within 24 hours. Now, from what I understand, that they will make a database here in New Hampshire, but there is an RSA that they have to follow also to delete it. But why have two databases? I don't think we need two databases on what guns I buy. Thank you, and please oppose this. Thank you.
Thank you for your testimony. The chair calls Mr. Timothy Wolf, and up next will be James Gaffrey.
Thank you. I'm just a little bit, just to state simply, a little confused by the language on the bill and not really sure of its necessity given the laws that we already have. First of all, when you purchase a firearm, they mention commercial firearm transactions, so I assume that means anything through a dealer. I don't know of any dealer in the state that you can go to and not do a background check if they're doing things as they should, which everyone that I know does. My understanding, I might be, there's enough dealers here, probably could correct me if I'm wrong, but if you're buying a pistol, it generally goes to the federal government and they do, FBI does the national instant, the background check on you. And if it's, or I'm not sure if it's the other way around, and the other one goes to the state police, but you're going to go through the background check. So I don't really see, if we're already doing this already, I'm not really understanding the need for this at all because I feel like it's already being done. Why would we use more of our state's resources for something we're already doing? It just doesn't make any sense. The other thing is just in the beginning of this, under the analysis, it says the bill excludes private non-commercial sales or transfers between individuals provided neither individual is prohibited from owning or possessing a firearm under state or federal law. So it's saying that it excludes individuals. And then further down, under the purpose, it talks about the commercial firearm sales. And then a little further down, the background under the definitions is actually where I got confused. It talks about the commercial sale is not limited to sale, exchange, or gift. So if you're gifting it to somebody, how is that? I just, I don't understand the language for commercial here. Because they actually have an individual listed under definitions means a natural person. So is there a conflict between the exclusion under analysis and the definitions? They seem, I might be missing something here, but it seems like there's a conflict in the definitions and the exclusion under the analysis. Other than that, that's all I have. Thank you.
Thank you for your testimony. Chair calls James Gaffrey, and up next will be J.E. Simkin.
Sorry for my handwriting. The last name's Gaffney. The bill, as it's written, is poorly written. We've dealt with the same language or intent multiple times. It's been voted down each time. This bill seems to be a little more special than previous versions in that it attempts to tell me that the sky is green and the grass is blue, in stating that a private transaction between two individuals is somehow a commercial activity. Are we then going to apply that same standard to every transaction, whether it pertains to a firearm or any other inanimate object? No, of course we're not. So why would we do it in this special occasion? Murder's illegal, assault's illegal. We have innumerable laws that say various things are illegal, and so now we're going to criminalize the transaction of some inanimate object. It's not going to accomplish anything. All it does is make more work for people. It makes it more difficult for two individuals to perform a transaction. There should be a cost analysis of this, right? First and foremost. What is it going to add to the burden of two individuals to engage in a transaction? A private transaction. What about all the trips back and forth between the FFL, between these two people? Should there also be an environmental impact study? I'm not trying to be ridiculous. I'm trying to point out the obvious problems with this bill and the fact that it's not going to accomplish anything. Thank you very much.
Thank you for your testimony. The chair calls J.E. Simkin, and up next will be Tom Mannion.
Good morning, Mr. Chairman and members of the committee. Thank you for giving me an opportunity to testify. I make it my mission to put before you things that probably you would not otherwise hear. So some disclosures. I'm a federally licensed firearms dealer. I've been so for a few months short of 40 years, 30 of them in New Hampshire. I personally do background checks. That is to say, I'm the fellow who picks up the phone and calls the New Hampshire State Police gun line or the FBI NICS Center. So I know with some precision how the process works. Background checks are a consumer fraud. I heard prior testimony that 90% of Americans support them. May be true. No source was cited for the data. Okay, so here are some foundational facts. As at the end of 2020, there were in the United States approximately 454 million firearms. That data point is from U.S. Department of Justice, Firearms Commerce in the United States, issues of 2000 and 2022, 5 May. So there is far more than one firearm for every U.S. resident, including infants who usually don't own much. and we hope they don't own firearms. My point is real simple. Anything so numerous, mainly concealable, cannot be controlled. The effort is foredoomed. To pursue it is akin to doing what was done in the ex-Soviet Union, where it was thought if all factory, farm, mine, forest, etc., output is governed by quotas set by planners sitting in offices in Moscow, we will eliminate waste, we will be super efficient, and we will overtake the capitalists. I have little background in this realm. I used to lecture Russian and Soviet studies at university level. Well, they pursued this. They committed a genocide in order to break opposition to this approach to managing the economy. And as the evidence mounted that this approach made Soviet citizens poorer, not richer, they doubled down. Eventually, the Soviet Union went bankrupt. So my point is, there are some ideas that get a really strong grip, but they're flawed. And the idea that background checks stop bad folks from getting weapons is such a flawed idea. Now, here's some data. I'll preface it by a statement that the federal authorities do almost nothing to stop bad folks from getting weapons. The attempt by someone to get a weapon from a dealer and to lie in the process is a federal felony. Specifically, it is a violation of 18 U.S. Code, Section 922, small a 6. This felony is punishable by a fine up to $10,000 and/or a prison sentence, a sentence up to 10 years in federal prison, and/or a fine up to $250,000. You could say that's a pretty good punishment. Here's the problem. The feds rarely prosecute those who lie. Here's some data points. From 2010, of 76,000 denials, there were 62 prosecutions. Fast forward, 2018, Government Accountability Office study. Of 12,000 denials referred for investigation, there were, count them, you'll have to take off one shoe, 12 prosecutions. In short, the feds do not enforce criminal penalties on those who lie to dealers, and these penalties have been on the books, if memory serves, since 1968. Could things have changed since 2018? Possible, but here's why I doubt it. If you look at the number of cases filed by U.S. attorneys nationwide, for them to have prosecuted those mentioned in the GAO study, 12,000 plus denials, the U.S. attorneys would have little time to prosecute other cases, espionage, securities fraud, etc., etc. In short, the feds don't only not prosecute those who lie to dealers. If they did, that's pretty much the only crime that would actually be prosecuted by federal prosecutors. We simply don't have the infrastructure, the human infrastructure, to prosecute bad guys who try to get weapons. In short, I understand that a lot of folks put faith in background checks. They are as much in error as were the Soviets, who insisted that making all output decisions in Moscow would make Soviet citizens wealthier. They were simply wrong. History has judged. The fact that the folks now in charge of the Soviet Union look back with longing to the Soviet era is proof positive that some ideas plainly failed have an unbreakable grip. Background checks is one of those ideas, unless we, meaning the taxpayers, are willing to hire enough federal prosecutors and build enough prison space to put behind bars those who lie. In closing, in the 20-plus years that we've had background checks, they began in November 1998. I'm a small-scale dealer. I've had 2 persons denied, both of whom were not murderers, bank robbers, or rapists, because I was told by the reviewing authority, have your customer call us, meaning to the gun line, and we will tell them what matter in their record makes them disqualified. One of the 2, man then in his 40s, said, I will pursue this. 6 months later, he comes back, told me it took me $1,900 in attorney's fees. The matter's been cleared up. I had held the firearm for him, no cost to him. I redid the background check. He passed. He left with his weapon. The other fellow, never heard from. Maybe he didn't have that kind of money. Don't know. But if the other fellow wanted a weapon, there are hundreds of millions of them. Quantitatively, this bill, it furthers an idea that I've just shown you quantitatively is nonsense. And I respectfully suggest you do not enact it, because to enact it would suggest that you, the members of the committee, and the members of this honorable House cannot do basic math. I have not only no reason to think you can do basic math, I suspect you can do it without using a calculator. Thank you. I'll be happy to take any questions. I add only that in my submitted testimony, the data sources are provided. You can look at them with your own eyes.
Thank you for that, and thank you for your testimony.
Thank you.
The chair calls Tom Mannion, and up next will be State Representative, the Honorable Maria Perez.
Thank you, Mr. Chair, members of the committee. My name is Tom Mannion. I represent Hillsborough 1, Pelham. I'm here to testify in opposition of HB 59. To start, this bill opens with the definition of commercial sale as including gifts. So let me run a hypothetical by you. My father is raising his son way up in Coos County. They go hunting, target shooting on weekends. The son is raised in a gun-friendly environment, is very well trained and capable thanks to the great mentorship of his father. When the father deemed his son to be mature enough, the father gives his son the rifle they've been using for years as a birthday gift. Same as his father did before him. It is now the son's to own. His eyes light up with wonder, a smile spreads across his face, and Dad is now guilty of a Class B misdemeanor thanks to HB 59. Tough break, Pops. Since FFL firearm purchases are already subject to background checks, I want to highlight what I believe to be unconstitutional in ATF Form 4473. If we're going to be lapdogs to arbitrary federal rules, I think I should elaborate exactly what that entails and how it's a violation of granted staters' rights. I want to credit Liberty Block for bringing this to my attention. In all the times I've completed this form, the specific legal language the ATF uses never popped out at me. Question 11B states, are you under indictment or information in court for a felony or any other crime which a judge could imprison you for more than 1 year? Indictment. Not guilty of, so no trial, no jury, no conviction, no sentence, yet answering yes would prohibit purchase of a firearm. So you're being denied liberty without due process of law and being forced to bear witness against yourself. This violates the Fifth Amendment. Question 11C covers conviction, so 11B sticks out unnecessary and unconstitutional. And subject to felony convictions of firearms and firearm ownership is a bill that this committee's already heard and I've already submitted testimony for. Question 11E states, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic, drug, or other controlled substance? And then in bold, it says, warning, the use or possession of marijuana remains unlawful under federal law regardless of whether it's been legalized or decriminalized for medical or recreational purposes in the state where you reside. The question is dubiously worded, and it says unlawful user, and immediately reminds you that any use of marijuana is unlawful. This question, as with all of these, violates the Fifth Amendment protection against bearing witness against oneself, as well as the 10th Amendment, which gives up all authority not explicitly outlined in the U.S. Constitution to the states, which includes drugs. This goes on, but I would argue that we shouldn't be completing these forms in the first place, let alone making a dad run one for gifting a son to his rifle. Criminals do not acquire arms through these means. They steal them, or federal agencies, like those during the Obama administration, ferry them to Mexico, and they come back into circulation that way. It also won't be long before the newly Taliban-owned arms make their way around the planet. I'm certain the DOD didn't run background checks on those guys before leaving them guns. I asked this committee to ITL HB 59. I'm willing to take any questions.
Thank you for your testimony. The chair calls Representative Perez, and up next will be Andrew Schiller.
Thank you, honorable members of the committee. Again, my name is State Representative Maria Perez. I represent District 43 in Milford. I'm here in support of this bill. I'm tired of hearing so many comments about wasting time, wasting money. Let me tell you something. Time and money means a lot for victims of domestic violence. None of the people who's been coming and testify previously has said anything or care about people like myself. I'm a survivor of domestic violence.
Ma'am, Representative, please don't characterize the testimony of other people. Speak to your own.
Yeah, that's fine.
Thank you.
I'm a survivor of domestic violence. And let me tell you, me buying a gun, it doesn't make me feel safer. It means I'm going to cause more harm to the world than save myself. I don't feel safer. How many times I've been told every time that my name has been targeted online? My information, my personal information has been put online. My name has been targeted so many times. But that doesn't mean that I'm going to go and buy a gun just to feel safer. And for the people who say this is waste of time and money and they don't have the money to pay, if they have the money to buy a gun, even if that was a gift, the person who gave you the gift have enough money to buy the gun. They should have the money to provide you money to go through the background check. I ask this committee to support this bill. Enough is enough. We see enough gun violence. That not passing this bill is creating more unsafe world for victims like myself. Thank you so much.
Thank you for your testimony. The chair recognizes Andrew Schiller, and up next will be Representative Janine Notter.
Hey, thank you. I just want to make a comment. The rights delayed is a right infringed, and given forcing the background checks on all commercial sales can potentially add unforeseen delays that the customer may have no control over and therefore cannot exercise their rights for nothing of their own doing. I also remember somebody mentioned marijuana use. There was a recent Supreme Court ruling saying marijuana users cannot be denied firearms. So just more further proof that the forcing a background check is not a good thing, and therefore this bill should be ITL. Thank you.
Thank you for your testimony. Chair recognizes Representative Janine Otter. Up next will be Teresa Grinnell.
Hello, Mr. Chairman. Good morning, committee members. For the record, I'm Janine Nodder. I represent the town of Merrimack, Hillsborough 12. I promised my constituents that I would defend and protect the Second Amendment, and I'm here today for the people who voted for me. You're hearing bills all day long that pertain to the Second Amendment, and I'm here to ask you to ITL every single one of them that infringes on our rights to bear arms. Thank you.
Thank you for your brief but succinct testimony. Chair calls Teresa Grinnell, and up next will be William Rosen, I think.
Hi there. Thank you for the time to speak. My name is Therese Grinnell. I'm a registered nurse foster mom from Loudon, New Hampshire. Many of you know that my First Amendment was violated severely October 13th of 2021 at the Executive Council meeting where I was arrested for uttering the word amen. I am still awaiting my trial date after 6 hearings with 0 evidence that I made any such word. Our Second Amendment by our forefathers was to protect our first. I can't help but see people jump from high-rise buildings in China, where my exchange students came from, and told me what it was like in their country, to know that our forefathers put our Second Amendment there to protect us from a government that comes in to violate our rights. I'm now aware that if my husband and I go and purchase a couple of guns, it gets reported to our chief of police in our town. It's registered. Why is it registered? We've already seen the ATF knock on doors to say, hey, I just want to make sure those 2 guns you just bought, they actually went to you. Can we take a look at them? Why is the government taking a list of who's bearing arms? Our forefathers gave us that right to protect us from becoming China or North Korea. We need to understand our history. If we care about our children, our future, we need to make sure that we're able to protect ourselves. And I'm here to tell you, after living through the Rodney King riots in East LA while I was in college at Azusa Pacific, when things go bad, they go bad very, very quickly. And the people who are going to do criminal activity with a firearm are not the ones that are going to go somewhere where they have to have a background check. There is a way with our open borders for people to very easily get their hands on a firearm, show up at a school, show up at a polling place, do whatever the heck they want to do. And you're only penalizing those of us that are trying to protect this country. You took an oath to preserve our Constitution, each and every one of you. I don't want a child to be in a shooting. I feel as though my children, my 2 little boys, would be safer if I knew that there was someone at their public school that was a responsible gun owner. That if something happened, they could protect those children quicker than police and EMS could get there. We've already seen our state troopers come tap me on the shoulder, 4 of them, tell me to come to the back of the room, put me into the back of a paddy wagon, make me urinate in front of a glass wall in front of grown men for doing nothing. If they can do that by our Governor Sununu, who I voted for, please do not let us become China. Do not let us become North Korea. Our children deserve America that our forefathers fought for. I would ask you to oppose anything, table anything that comes up to you today that violates our rights as law-abiding citizens to safely have a firearm without any sort of government overreach or infringement, or to be on a list where I'm going to get tapped on the shoulder and told to get into a paddy wagon because I'm there trying to protect my family from a government that's gone sideways. That's what our forefathers wanted for each and every one of us. God bless each of you for your time serving our legislative body and our citizens.
Thank you for your testimony.
Any questions?
I don't see any. Thank you. The chair calls William Rosen, and up next will be Dr. Leonard Cohen.
Don't see anybody else, so I think my penmanship got me again.
Yeah, I think I butchered your name last bill.
William Rogers. Sorry about that. This bill seems like a solution looking for a problem, frankly. I was confused by it because I thought it covered just commercial sales, but then you look, it calls a private sale a commercial sale. All commercial sales are already under federal background checks. Private sales, it says it's going to exempt it. I don't understand. I'm not as smart as representatives, 10 of them, but I don't understand. It's confusing to me, so I'll trust your judgment because you guys are obviously a lot smarter than me and can figure it out, so thank you.
Thank you for that. Chair calls Dr. Cohen, and up next will be Brian Blackton.
So I have some written testimony which I would like to give to. This bill, like 6 of the other gun bills today, are a response to a problem that exists in the United States. This is not, we do not have the safety in the United States that Norway and Great Britain and France and Germany and every other civilized Western society has. We have more than 25 times the gun violence of those other democratic countries. Why does this exist? Partly or mostly it exists because we don't have common sense gun laws. Doesn't it make sense that this particular bill, if a person wants to buy a gun, that they pass a background check? Why is that so unreasonable? I don't understand. The background check bill exists to prevent people who have committed felonies and have other reasons to not purchase a gun. We've heard it before. 70%, 90% of the citizens in this country want reasonable gun laws. But the reason that we don't is that politics, rather than the will of the people, interferes with reasonable, common sense gun laws. So, about gun, it takes a person and a gun. That's the equation. In order to reduce the very significant gun violence in this country, we have to attack both the person and the easy availability of guns. Now, I represent the New Hampshire Medical Society and the New Hampshire Psychiatric Society. The reason I'm standing here is that this is a lane where we as physicians occupy. We take care of the people who are injured or killed and come to our emergency rooms. If they're still alive, we operate on them and try to save them. There are so many horrible injuries as well as deaths every year, every day. More than 120 people die of gun violence every day in the United States. It's unconscionable. And every reasonable gun law that comes before you ought to be passed so that we can do something about this. So the background check law is really the bedrock of reasonable gun laws. It's a simple law. It requires people who want to have a gun to pass certain requirements that they're safe to have a gun. That's all. Thank you for listening to my testimony. Does anybody have any questions?
Thank you for your testimony. Chair recognizes Mr. Brian Blackton, and up next will be Brian Barry.
I ask you to ITL this bill. As I started reading the analysis, I was very happy I was doing my job as an FFL really, really well. And it looked like, at first glance, somebody just cut and pasted part of the ATF rules to tell me what to do. Until I got to, this bill excludes private non-commercial sales or transfers between individuals, provided neither individual is prohibited from owning or possessing a firearm under state or federal law. And this is where it gets a little fuzzy for me. As far as the definition of commercial sale, it says ownership of a firearm, including but not limited to a sale, exchange, or gift. That's not commercial. And on the front here, it says this excludes private non-commercial sales. That's a conflict to me. Except when you get to number 2, it says if neither party to prospective firearms transactions is a licensed firearms dealer, the parties to the transaction shall complete the commercial sale through a licensed firearms dealer. What you're doing in this, basically, is making all private sales commercial. That's all that's happening here. I already do background checks. I actually do a lot of private party background checks. But this is forcing people to do private sales as commercial sales. And to me, that's nothing more at blocking and tracking private sales. And noted in number 6 in the bill, mail order sales are now required to go through an FFL. They do now. There's no need for that to be written in there. We already do that. And under section 62A, that is a violation of federal law. Because once an FFL takes possession of a firearm and puts it in their bound book, that gun doesn't leave their possession, doesn't leave that door until the next check is done. So for anybody to think that they're going to give an FFL a gun and then walk out the door with it, they're crazy. It's not going to happen. It's against federal law. And all you're doing at that point is making FFL dealers criminals. That's all that does. As far as criminal penalties, under RSA 159 F41A of this proposed bill, criminal deterrence of a Class B misdemeanor is a joke if you're trying to appear tough on crime, considering consensual act of public sex carries a stiffer penalty than that. In my opinion, this bill would be found to be unconstitutional, and maybe the authors should know the requirements of being an FFL. And this bill also makes a private sale commercial in one direct contradiction to the private sale description in House Bill 351 FN. If you compare the two bills, they contradict each other. Please ITL this bill. Thank you.
Thank you for your testimony. Brian Mary, and up next will be Kimberly Moore.
Good morning, everyone, again. Whoa. You did fix that problem, huh?
We'll get.
How's it going? I'd like to draw your attention to the New Hampshire State Constitution. I'm going to go down to Article 2B, right to privacy. An individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. Our Constitution. As was pointed out prior by some other testimony, there are problems with the federal background check. That's for another day. Let's talk about New Hampshire. The analysis of 59 shows that this bill requires commercial firearm sales or transfers in this state to be subject to a criminal background check and provides a criminal penalty for a violation. The bill excludes private, non-commercial sales or transfers between individuals, provided neither individual is prohibited from owning or possessing a firearm under state or federal law. Sounds reasonable, right? As was pointed out already, commercial sale definition, I don't get to rehash that, you guys, right? Get that down? But on page 2, line 3, Roman numeral 2, if neither party to a prospective firearms transaction is a licensed firearms dealer, the parties to the transaction shall complete the commercial sale through a licensed firearms dealer as follows. Shall. Not should, shall. Words matter. This does eliminate private sales. And it contradicts the analysis on the front page of it. I would like, if you could please respectfully read that when you have a chance and see if I'm a little bit off there. We already know that in a private sale, we are responsible to make sure we know who the person is who we're selling to make sure that person isn't a prohibited person. That falls on us already. It's already in law. And that's common sense. I wouldn't come up to someone and be like, oh yeah, flea market, buy a gun, sure, see you later. Most responsible citizens who own guns and sell guns and buy guns look for something a little more definitive. Do you have a PNR license with you? Do you have your state ID? Can I see those, please? Okay, let's do a transaction together. Take a picture of it, photo document it. We're good if something happens. The federal government provides for transactions to be put through the system on private sales as well. They encourage it. Hey, you met off website X. Sure. Hey, you know what? Let's go to a gun store and do this the right way. All right, I don't know who you are. We just met online. These steps are already in place. But this isn't going to prevent a criminal from obtaining a gun illegally the way criminals do. It won't. I think we have a little bit of government intrusion into our lives now, a little bit more than I like. I don't think that we, the citizenry as a whole, should be penalized for the crimes of a few. Let's focus on the people who are doing the wrong things. Let's bring them to task. Let's get them in the system. Let's have them realize the consequences of their actions instead of being lenient on them all the time and understanding. And yeah, okay, you're a criminal. You're doing it. You know what you're doing. Ladies and gentlemen, I oppose this. Background checks exist already in two forms, federally with NICS and at the state level through the gun line. The gun line's a good idea because it will show prohibited person status on the state level quicker than it would get into the federal system. That's not a bad thing. And the federal background check system works. I've had denials. I'm an active FFL, by the way, next level firearms. So I'm speaking from current experience. It works. It's not perfect. Some of the language in the federal portions of the 4473 I don't like. But as far as this private sales, I think that's you just beating a dead horse, honestly, guys. And I will take questions if people want to come by and get me. I'm right here, hard to miss. And thank you for your time.
Thank you. We appreciate your testimony and your availability. The chair recognizes Kimberly Moran, and up next will be Zandra Rice Hawkins.
This legislation, written by a California gun control organization many years ago, we've had fun with this bill every year for at least 10 years, maybe more, hasn't changed much over the years. It was resurrected from the depths of hell with a few changes in language, but with the same results. It will harm those who seek gun safety training other than at big corporations who have gun shops in their training facilities. At the Women's Defense League, we provide gun safety training to women every year and have trained hundreds of women and girls since 2014. Because we aren't a licensed FFL dealer, according to this legislation, we'd have to get background checks on each of these women before every class. As an all-volunteer organization, this isn't physically feasible or possible. Any students who take training sign a waiver that states they are not a prohibited person. This California gun control legislation doesn't find that acceptable. This legislation will do nothing to stop criminals from seeking illegal firearms, but will do everything to stop law-abiding citizens from seeking gun safety training to protect themselves from criminals, especially women. We ask that you vote inexpedient to legislate on House Bill 59 so that women will continue to get gun safety training and will not be further victimized. And for the record, all commercial firearm dealers have to perform background checks according to federal law. Thank you.
Thank you for your testimony. The chair recognizes Zandra Rice Hawkins, and up next will be Penny Dean.
Hello again. My name is Zandra Rice Hawkins. I'm the director of Gun Sense New Hampshire, a project of Granite State Progress, and a member of the New Hampshire Gun Violence Prevention Coalition. We are here today in support of this bill. It is important for states to explore options to prevent or reduce gun violence in our communities. This bill would require background checks for all firearm sales, helping keep guns out of the hands of felons and domestic abusers and other prohibited persons. Let's talk for a minute about how background checks work. Under the Federal Brady Act, criminal background checks must be conducted on individuals before a firearm may be purchased from a federally licensed dealer, manufacturer, or importer, sometimes referred to as FFLs, as you've heard today. In New Hampshire, background checks on handgun purchases are conducted by the New Hampshire Department of Safety, and background checks on long guns are conducted by the FBI's National Instant Background Check, Criminal Background Check System, or NICS. Since the Brady Act through January 31st, 2023, just under 446 million applications for firearm transfers or permits were subject to background checks. A study of the Brady Act from its inception in 1999 through 2010 found that 118 million applications for firearm transfers or permits were subject to background checks, and about 2.1 million applications, or 1.8%, were denied. A Department of Justice study of those applications found that a felony conviction or indictment was the most common reason to deny an application during FBI, 63%, or state, 50.7% of background checks. Domestic abusers attempting to purchase guns accounted for the second most common reason of denials during those federal background checks at 15.5%, or in state at 13.2% of the background checks conducted. Where are we in New Hampshire? Last month, New Hampshire conducted over 10,000 NICS background checks to keep guns out of the hands of felons, domestic abusers, and other prohibited persons. Last year, they did around 133,000 throughout the year. These are real numbers and an important public safety check. But guns sold in New Hampshire through private sales at gun shows, online, or the classifieds do not currently require a background check. Requiring a background check every single time a gun is sold is effective in keeping guns out of the hands of those who should not have them. This bill does that, and it just makes sense. Responsible gun owners should not put guns in the hands of people that they do not know or do not know well enough to know whether they are prohibited from possessing or owning a firearm. Under this bill, gun sales, including online sales, would require a criminal background check through a federally licensed dealer using the same background check system already used in all dealer sales. It defines these as a transfer of ownership of a firearm, including but not limited to a sale, exchange, or gift. Transfers and exchanges are included because it is not uncommon for a firearm to be traded rather than sold for financial value. This bill would help keep guns out of the hands of dangerous criminals and save lives. An overwhelming 9 out of 10 Granite Staters support closing background check loopholes, including a majority of gun owners and NRA members. What's more, this bill closes what is known as the Charleston loophole. Under federal law, a licensed dealer may proceed with the sale of a firearm after 3 business days if the mandated background check has not yet been completed and there's no confirmation that the purchaser is legally permitted to have firearms. We have seen how this tragedy plays out. According to a fiscal note at the end of a similar bill in 2014, an estimated 33,000 gun sales in New Hampshire did not go through the background checks process the previous year. We don't have a lot of data on this. This is why I'm citing a 2014 piece in the fiscal note, and we would love to see an updated piece in the other bills. This morning, our office looked on ArmsList, which advertises itself as an online firearms marketplace. There are over 80 firearms for sale or trade in New Hampshire alone. The website has a disclaimer advising users to follow all federal and state firearms laws. That is it. You have to click a button saying, yes, I'm allowed to purchase a gun, no questions asked, no background check. There is no guarantee the individual seller will require one. There is, however, a disclaimer alleviating the company and its owners from any liability. It's high time we had a conversation about who can easily buy firearms in New Hampshire. This bill does not affect law-abiding New Hampshire gun owners selling and trading guns between friends and family, as long as no one is prohibited to own or possess a firearm. It expressly prohibits a gun registry. We ask for your support, and I'm happy to take any questions.
Thank you for your testimony.
Thank you.
Chair calls Ms. Penny Dean. And up next will be Kina Sakokian something. You'll have to tell me how to pronounce it.
It's Kriya Sakakini. Thank you. It's okay. Oh, sorry.
It's okay. My name is Penny Dean still, and I'm still a Concord attorney. And I'd like you to ITL this bill for several reasons. And I always believe in starting in the basement when you're doing an analysis. And the first thing is, like a fish story, this bill has come back again and again and again. We heard years ago that 50 to 55% of gun owners support it. And then we heard it 60%. And we heard 70%. I heard 90%. And here's where I come from. If I bring you studies or data, I give you clear sources of where I get those facts or data from. And everyone knows that where the study is conducted mattered. Was it conducted outside of Sarah Brady's Supporters for Handgun Violence? Or was it conducted outside an NRA convention? Those things matter. And I think you hear a variety of numbers, but I think what matters is we elected a majority of Republican legislature. And if everybody wanted gun control in this state, I think there'd be 400 plus Dems in here. Don't have that. So I think that speaks. But when you talk about this bill itself specifically, I want to talk about what I call wrongful denials. When we talk about how many are denied, I make a good amount of my living, and quite frankly, a lot of the free time I do for people doing wrongful denials. You don't know how often a person said, I had one most recently, said, oh, your client has felony convictions. I said, gee, that's funny. I've got certificates of annulment from the Superior Court. Oh, well, we didn't get those entered. And so what you have, last time I heard, and I've heard different numbers, so I don't pertain to represent to you the exact number, between 170,000 and 220,000 Superior Court records and court records that are not, whether they be entered or entered correctly or reconciled, with the New Hampshire Criminal Records Database. And I don't claim to know what one of those numbers are right. I've heard different variations of them over the past 4 or 5 years. But I will bet you a nickel you're talking about well over 100,000 records. And what you have are human beings entering data. And with human beings make errors. And so many gun denials that either delays or quite frankly outright denials that come from the New Hampshire State Police gun line are based on bad data. And I'm not cracking on the gun line here. I'm saying that it's based on bad data. And those people are lawfully entitled to buy firearms. But what you have happening is, think about the average working man. It sometimes takes me, I most recently took pity on a man and did one of the many freebie cases I do. It took me 10 hours of my time to straighten out the fact that he was able to buy a gun. He was denied. They said he had felonies. Once we looked into it, 2 things had happened. The gun line had not entered annulments that he had, and there's a fee that a lot of people don't understand. I put together a 2 to 3 page letter explaining to clients how the annulment process works, because it's not clear. It took me a long time to put that letter together. And at the end of a process, when the average person gets a certificate of annulment from the court signed by a judge, they think they can go out and buy a gun. They got a certificate of annulment from a judge. Well, if you don't pay the state police $100 to enter it in their system after that, you can't buy a gun because your annulment isn't entered, even though you have that piece of paper from a judge. Now, if you have a lawyer like me who's known to be anal, you're going to know that, and I'm going to hold your hand to the very end. But there's some people who do annulments on their own. They're poor, or they think they can handle it themselves. Or there's other of my colleagues who I hate to admit don't do a job that I would be proud to do. But however you look at it, there's many wrongful denials. That's number one, and that's huge. Because if you come to me and I say it's going to cost probably $1,000 to $3,000, best case scenario, to try and figure out why you were denied, how many people can just write a check like that? Think about their working constituents. I mean, doctors and lawyers, yeah, we can write a check like that. But working people, that's a lot of money to them. The next thing you have to look at here is you look at what I call almost a fish story. And this is probably the one that offends me the most. And I feel for women, I have a bad ankle, got it from running. And so I don't run anymore, I barely walk. I can tell you that I can't defend myself like I used to. And I represent sometimes women who they now need a gun. They are physically afraid for their well-being. And they're going to have to wait, and not even if there's a problem with their record, not be subjected to a 3-day period. Right now, under federal law, the gun dealer can choose to let that firearm go after 3 days, and they will have within 3 days a firearm. And let me tell you what happens all the time. Police arrest, go to a scene where there's domestic violence. I had a client, they arrested her husband, and somehow or other somebody clicked the box that they arrested her. She wasn't able to buy a gun. We're at the most terrible time in her life, and she's going to wait how long? This is anti-woman. It's a horrible bill. But here's what's even worse. You go down this, and you say, okay, let's look just at the drafting. And I go back to whoever drafted this doesn't have subject matter competence, or they're deliberately, as one client said, don't ever ascribe to malice what can be explained by incompetence. So maybe we have incompetence here. But if you look at page number 1, and we look specifically at line 30, possessing a firearm pursuant to 18 U.S.C. 922D or pursuant to state law. Well, let me tell you what the drafters either ignorantly left out or deliberately left out. 922D specifically says if you have a state law misdemeanor for which you received more than a year's imprisonment, you are barred from guns. But that's not the end of the story. You have to keep looking and do a whole job here. 18 USC 921 A20 A and B says no, a person can have a state court misdemeanor for up to 2 years and or have antitrust violations, and they can still have firearms. But if you enact this without that other exemption, which is found in federal law, you are foreclosing tons of people of their rights. Because what people in New Hampshire might not understand, there are a lot of Massachusetts residents come up here. Massachusetts has tons of 2-year misdemeanors. Under this provision, the way it's written, all those men and women wouldn't be able to buy firearms, even though they can under federal law. We go to the back when people talk about loopholes. Loopholes is any law they don't want and they want changed. The definition of loophole is very clear. It's an oversight. The 3-day of letting people have a firearm if there's no response is not a loophole. It's deliberate. It's to keep the government honest and to keep honest citizens to be able to get firearms instead of having what we had for some years at the gun line, people dragging their feet or playing mini detective or doing whatever and taking days and days and days and weeks and weeks and weeks and months and months and months to find out something that could have been found out in 2 or 3 days. And so you look at that. The other thing you have to look at is on page 2, lines 6 through 11. What you're doing is basically asking every federal firearms licensee in the country to violate federal law. And pretty soon the ATF's going to investigate all of them. You won't worry, you won't have a gun deal in the country. You can't ask or require these dealers to do something that violates the provisions of federal law or the conditions of their license. That's not reasonable. People have to look at this, and we could go on and on and on and on. But the bottom line is, the other thing is dealers can't work for free. These men pay money if they have overhead. They're going to charge usually $25 to $50 a check. You're going to add that onto every gun. Think about that again for the average working guy who's going to buy a $200, $300, $400 gun. That's a lot of money. People, make X amount of dollars an hour. But in short, there's a lot of mechanical defects in this bill, in addition to the fact that, quite frankly, I'm ideologically opposed to it. There's no reason to have it to begin with. This is not worth fixing. You're going to make a father go get permission to give the family rifle to the son? When they talk about these internet gun sales, that's the biggest crock of horse feathers I've ever heard. It is illegal to have interstate sale between private individuals, non-licensed people. It's illegal now. It just doesn't happen. And when it does, the ATF cracks down on it. So I'm happy to answer any questions you have. But as a practical matter, this is horrible. And you put the gun line in, quite frankly, a bad position, asking them to do things I'm not sure they can do. And when I say legally, I'm not saying they couldn't mechanically potentially do them. But you're putting them in a position and asking them probably to violate several agreements they have with the databases they're in.
Thank you for your testimony. And the chair recognizes Kina
It's okay. It's Kriya Sakakini.
Sakini.
Sure. I wasn't planning on speaking today, but I am speaking on behalf of my 2 children, Owen, who is 6 years old, and Zaya, who is 2 years old. And I'm acutely aware that there are mothers and fathers in this country whose children are not alive and do not have the privilege to stand here and to advocate for this bill because their children have been slaughtered by people who were able to get guns, who we know never should have had those guns in their hands. The children in this country and in this state do not have the privilege to be here before you, to plead with you, to do what is right to protect them. There are mothers in this state who cannot be here right now because they are caring for their children who they trust you to protect. They trust you every time they send their children into school to know that you will do the right thing, that they will not be victims to senseless gun violence when they kiss their child in the morning and say goodbye to them. This is a law that we know the majority of people support. This is a law that has statistics behind it that shows it reduces homicide, it reduces suicide, it reduces senseless killing. And when we talk about rights, where are the people protecting the rights of our children? The children who deserve a chance at living, of growing to their potential, of advocating for themselves. They have been slaughtered. We are watching them die in numbers that are beyond what other developed nations are witnessing. And it's because we do not have the courage to put these laws into place. If you took this opportunity to the women who are at home with their children to speak to you, to look into your eyes, I guarantee they would speak to you, but they don't have access to the opportunity to come into this room like many others who you've heard from. So I'm asking you to open this conversation up to the mothers and the parents in this state and listen to them and possibly even listen to the children. Thank you for your time, and please, please consider passing this bill.
Thank you for your testimony. Is there anyone who has not turned in their pink card yet to testify on this bill? Seeing none, I hereby close the public hearing on HB 59 and open the public hearing on HB 76. Oh. I reopen the public hearing, and please take the microphone. We seem to have misplaced the card, so just
I
please.
brought it in late. It was passed down somehow.
I'm sure it's somewhere
But
here.
that's
We
okay.
have-
I'm Joanna Brown from Manchester. I oppose this bill, and I too have children, and I would like you to all think about what you don't hear on the news are the people, the private citizens who are stopping gun violence by taking out the aggressors. You don't hear about that in the news. In a utopian society, a 3-day wait might be fine. But a woman, a restaurant waitress in Manchester, received death threats from a homeless man. She doesn't have 3 days to wait. 3 days is the difference between life and death for her. Women who've been in abused relationships, who are dealing with stalkers on the street, they can't wait 3 days.
Ma'am, this bill is about background checks. The 3-day waiting period bill is later, although this does touch on it a little bit, but not really about what you're talking about. So if you could just speak to this bill regarding the background checks.
So this bill is the one about all the technical language and doing a background check that takes 3 days?
It addresses the part where if you have to wait 3 days and you don't get an answer back, the law currently is
Okay.
that you can get your firearm. So
Okay.
it briefly touches on.
That's all I had to say anyway.
Okay,
Thank you.
thank you. Anyone else? Seeing none, HB 59 is now closed. HB 76 is open, and the chair recognizes the prime sponsor. Representative David Muse.
Chairman Roy, just to clarify, I am not the prime sponsor. Representative Cam Kenny is the prime sponsor, but I think I can play one on TV. So I'm going to try to do that. I'm going to read Representative Kenny's statement, and then I'll have some comments of my own. Thank you, Mr. Chairman and members of the committee. I apologize for not being able to be in person to introduce HB 76 today. Unfortunately, I'm in my second year of law school and have class right now, but please email me if you have any questions. To start with, this bill establishes a reasonable waiting period of 3 days before the delivery of a firearm. This should not be a partisan issue, as both blue and red states, such as Florida, Massachusetts, Rhode Island, and Illinois, and others, have passed some form of waiting period. Additionally, waiting periods or cooling off periods have been shown to reduce suicide and other forms of violence by offering time to gain perspective when things in the moment might seem intolerable or hopeless. This bill gives a very reasonable window to increase the possibility of second thoughts and of getting help. There were reasonable exceptions offered in Part 3 of the bill, which the chairman just mentioned, such as a 16-hour hunting education course, exemptions for law enforcement officers or active duty service members. There are also provisions for exceptions for folks who basically are impacted by restraining orders or who have a reasonable fear of violence. The bill is only intended to reduce impulsive acts by establishing a waiting period that has worked in other jurisdictions, and hopefully Part 3 offers a fair balance that will narrowly confine the impact. What I wanted to add, and I'm a co-sponsor of this bill, is that HB 76, with the exception of the enactment date, is identical to HB 1101. That's a bill that passed in the full House in 2020 and was tabled in the Senate during COVID. Under current federal law, there is no waiting period to purchase guns. A waiting period can actually give law enforcement additional time to perform a background check and a cooling off period in cases where people may be prone to violence or may be considering a suicide attempt. I also wanted to mention the fact that waiting periods are not an uncommon thing to encounter as a consumer in this state. Anyone who's bought dental or health insurance is familiar with waiting periods after you buy coverage. We have waiting periods for pet insurance. We have waiting periods for divorces. And many employers also have a waiting period between the time you start work and when your employee benefits take effect. We also have cooling off periods for many types of contracts where a person can opt out of a contract 3 days after signing it. One of the things I wanted to mention too is how frustrating it was for me during COVID when my oven went out to have to wait for 3 months for a new oven to show up at my house. That was a bummer. We had lots of microwaved meals, very inconvenient. And I think the key point of that is that all of us are adults and we're used to waiting. Sometimes we just have to deal with the fact that some of the things we would really like to have now, we just simply have to wait for. So I wanted to make that point. The other point that I wanted to make also is that this bill, probably more than some of the others that we're going to hear today, has the potential to significantly impact suicides. So in New Hampshire, I would be the first to say we have much less of a gun homicide problem than we do a gun suicide problem. In 2020, which is the last year that I could find, 118 out of 129 firearm deaths were suicide. That's about 91% of the deaths by firearm during that year, and that's from the chief medical examiner. From 2015 to 2019, suicide was also the second leading cause in the Granite State between people between the age of 10 and 34. And meanwhile, I think one of the things you have to consider is that death from firearms remains the most lethal type of suicide. About 90% of the people who try it, unfortunately, are successful. One of the things we hear a lot is that, well, gee, I could take a screwdriver and I could commit suicide with that. I could drink too much water and commit suicide that way. The point is all you have to do with a gun is point it at your head, pull the trigger, and 90% of the time, it's lights out, it's over. In addition to establishing the 3-day waiting period, the bill does offer some common sense exemptions, and those exemptions, and we mentioned the one for people who've completed hunter safety courses. There are also exemptions that address issues by victims of domestic violence or people who have had their personal safety threatened. In cases where you feel your personal safety is threatened and you've expressed fear for your personal safety to a law enforcement officer, the 3-day waiting period could be waived. Not to say that it's not a terrible idea. Giving a firearm to an untrained person, there's also some significant risk there. But the bottom line is, this was one of the main objections that came up the last time that this bill was filed. And it was amended to address this objection. And essentially, that's the bill that's before us today. So what I would ask you is, please give it your strong consideration. Waiting periods are not unusual. They're not a tragedy. In the case of a firearm where suicide or acts of violence is a real risk, it's one more thing that we can do, not necessarily to completely prevent gun violence, but it's part of the picture of reducing the risk of gun violence. And I think that's something that whether you're a gun owner, whether you're a gun violence prevention advocate, I think that's something we all should be able to support, hopefully. So please give it your strong consideration. Thank you.
Thank you for your testimony. The chair recognizes the Honorable John Burt. And up next will be Dr. Hannan.
Thank you, Mr. Chairman and fine committee members. I am former Representative John Burt. For 12 years, I represented Goffstown, Ware, and Deeren. Mr. Chairman, we don't need this. And I'm going to tell you why. New Hampshire is one of the safest states in the nation. You know, this is just going to mess it up. I look at the men, and I do say men and women, that are abused in this state. And occasionally, some of those men and women want to protect themselves from their abuser, and they purchase a firearm. They don't want to wait the 3 days, because as we've seen, it takes a half hour, 10 minutes, even 2 minutes for a police officer to show up. That's too long, or it can be too long. And again, we are one of the safest states in the nation. Occasionally we're number 1, occasionally we're number 2 or 3. It's always within those ranges. We're even safer than Canada. And look what Trudeau is doing up there. He is taking guns. And their crime rates are increasing. Isn't that something? And Mr. Chairman, I do want to point out one last thing. The fine representative that spoke last said that there is a 3-day wait-in period in Massachusetts. There is no wait-in period in Massachusetts. You walk in, and if you're not a prohibited person, you walk out with that firearm that minute. So you just look at this bill, it's bad. So please oppose this bill. Thank you for your time.
Thank you for your testimony. Chair recognizes Dr. Hannan. Up next will be Joanne Brown.
Good morning for the next 2 minutes, I guess. Still morning. Joe Hannan, Gun Owners of New Hampshire. We're obviously in opposition to this bill again. There are exceptions in this bill, which I'll give credit where credit is due. We usually don't see this many exceptions, but they're not anything that would make us feel more comfortable with supporting this bill at all. Allowing exceptions for law enforcement, expressing to a law enforcement officer for a reasonable fear of his or her own safety sounds reasonable, unless you're married to a law enforcement officer who is abusing you, and that's why you need the firearm. Now their buddies know, and that's the only way you can get it otherwise. That's just one example. You're allowed to get it if you trade in a firearm. Sounds great because you already got a gun, but what if you already have a gun? Do you have to trade it in? What if I already have one and show them I already own a firearm? So there's no exceptions for someone who already has a gun and has the means to do whatever with that firearm. That's not an exception. I'm not trying to improve the bill. I'm just trying to tell you that there are a lot of things wrong with the way it is written. If someone can purchase a rifle or a shotgun, and for one thing, if the purpose is to reduce suicides, there are two things that are not predominantly used in suicides, but they can, I'll say they can be, but if a person completes a 16-hour hunter education course offered by the Department of Fish and Game, you can take that as young as age 12. Obviously, you have to be older to purchase a firearm, but all they have to do is take a course. So we're assuming by this that if suicide prevention is the goal, that people that are trained in a hunter safety course are not going to be suicidal. So there's a lot of exceptions to make people happy, but I don't know if it's doing what people expect it to do. And also the data shows that most suicides that occur with the use of a firearm, although more successful with a firearm, obviously it is effective, unfortunately, most of them occur after a year after purchase. And even with 10-day waiting periods, there's still a very significant increase in suicides in the shorter period, even after 10-day waiting periods. So having a shorter waiting period, if someone's intent on doing it, you know, it's not something that's going to be statistically significant to stop what the intended goal may or may not be. There's more that can be said, but we've heard this so many times. You know, a right delayed is a right denied is something that was said. I don't remember the Supreme Court justice. Sorry, but it's very true in this case. We don't expect people to wait to post something online or social media, although it's probably a good idea for some people. You know, we don't expect people to, in New Hampshire, to wait to vote. You can do same-day voting. They're making an exception for this, which is not right. If you're allowing an exception to exercise a right, not a privilege, that's a very bad precedent to set in New Hampshire. Thank you.
Thank you for your testimony. Chair recognizes Joanne Brown, and up next will be Andrew Schuler. Chair calls Joanne Brown. Andrew Schuler.
Hey, thank you for letting me publicly speak. So I noticed there's some semantic issues here. It mentions in order to skip the time to pretend that delaying isn't infringing rights for a second, expressing to a law enforcement officer a reasonable fear for his or her own personal safety. Well, expression can mean multiple things, like maybe buying favors or giving them something, and it's not particularly upsetting citizen thing to do, but it is possible according to here. I know there's a concealed carry permit, which could be in essence the same thing, but it doesn't include open carry, so this doesn't really include that. And then just more in general speaking, not just firearms, still if you had to wait to buy a car, or even worse, you know, like you have a kid, but you have to wait 3 days to take the kid home, like that's silly, right? So applying to firearms the same way. Why would you add an arbitrary delay to an item that you lawfully can own? That's all I wanted to say. Thank you.
Thank you. Chair calls Leonard Cohen, Dr. Leonard Cohen.
Thank you. As a psychiatrist, we know that suicide is a very impulsive act. And often the impulse to kill subsides over hours, let alone a couple of days. This bill is an attempt to interfere with the impulsive act that somebody who is thinking about suicide might go get a gun and act on it right away. So this is an attempt to interfere with that impulsive act, and we think it would be one important step in trying to reduce gun violence. Thank you.
Thank you for your testimony. The chair recognizes Brian Blackton. Keep your eyes.
I apologize if you're going to get sick of hearing me today. I ask you to ITL this bill in response to House Bill 76. This bill is in conflict with ATF Form 4473, 5300.9, revised December of 22. Specifically, the proposed bill states there is no waiting period for a person who has obtained a restraining order from a court under circumstances where the person feared for his or her safety or expresses to a law enforcement officer a reasonable fear for his or her own personal safety. Reasonable is very subjective. The 4473 NICS check may delay anyone who is aged 21 up to 10 days. I will not be made a felon by this bill if I am told by a police officer to sell someone a firearm prior to this bill's 3-day wait period if the ATF can make them wait 10 days. I will not be told by a police officer to break the ATF rules based on the proposed bill in their thought of what is reasonable. I also find this bill hypocritical that someone may buy a shotgun or rifle instantly merely due to holding a hunting license, which I'm not an expert on New Hampshire hunting licenses, so I don't know how easily they can be forged. I answer to the ATF, not to a local police officer. If the ATF has up until 10 days to wait, I refuse to be a felon because a police officer says he wants somebody to have a gun instantly for their own safety. What if a police officer's friend doesn't want to wait 3 days and has them tell me not to wait 3 days based on their reasonable thought of fear? This is rife for abuse, with the FFLs being on the hook. Further, I don't need to be told by the authors to make my records available to the ATF when that is already an ATF regulation for licensure. And if I refuse to comply with an illegal law, I become a felon. The authors may want to have an attorney look over the proposed bill, as it is clear they do not know what they are doing. Thank you.
Thank you for your testimony. Chair calls Representative Tom Mannion, and up next will be Brian Berry.
Thank you, Mr. Chair, members of the committee. My name is Tom Mannion. I represent Hillsborough 1 Pelham. I'm here to speak against HB 76. During the summer of 2020, I watched live streams of fiery but mostly peaceful protests across the country. The citizens were angry, and I agreed with their anger, but not the methodology. Private businesses, even those with black owners, were torched. In some of the larger cities with more violent protests, terrified business owners were told by 911 dispatchers the police were unavailable to help, and they were on their own. Hearing this, I was thankful we live in a country where we can arm ourselves against such violence. But in states with firearm waiting periods like California, you cannot just go get a firearm to protect your business, your family, your property. These people learned the hard way that their feel-good, sensible gun control measures would have costly consequences. A cop acting criminally halfway across the country away would result in near overnight reaction from a rightfully angry community, but would end up destroying the livelihood or homes of people wholly uninvolved. And they were told by both the police and the gun store owners, you're going to have to wait. It's easy to be a money quarterback and say they should have already had the gun. But the same people pushing for waiting periods don't actually believe this either. They'd rather you be disarmed and hope the waiting period is enough of a deterrent to keep you from bothering at all. They believe a waiting period would stop some heat-of-the-moment gun purchase for a vigilante looking for vengeance or whatever thriller movie scenario they have cooked up. That same person will just get it illegally should a waiting period be introduced. The only people being affected by this are those that wish to remain within the law and will ultimately be harmed by it. If another countrywide protest is on the horizon and your state has a mandatory waiting period, you may as well pack your things and leave town. Just don't expect your home to be there when you get back. I ask the committee to ITL HB 76, and I'm willing to take any questions.
Thank you for your testimony. Chair calls Brian Berry. Up next will be J.E. Simkin. J.E. Simpkin.
Well, good afternoon. Again, thank you for your time, citizens and representatives. Appreciate it. Suicide, yep, serious. Does help. 988 is a good number to keep in mind if someone that you know or yourself may be looking to hurt yourself or is in distress. Okay, we get that out of the way. I'm going to oppose the 3-day waiting period that we're talking about right now. There's a few reasons. I'm going to touch on the federal constitution for a minute, if I may. Amendment 14 in particular. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction to the equal protection of the laws. Yet, we have a number of exceptions in our 3-day waiting period that you're proposing. Why are there exceptions for certain people and not for, just let it go? If I pass a background check, if she passes a background check, that part of the equation has been done, it's resolved, they pass, let them have their gun. I've seen domestic violence up close and personal as a law enforcement officer in a past life. It's ugly. It's very ugly. I wish it upon nobody. I don't think anyone should ever see it. But when that cycle is broken, and enough's enough, and the police come and take away the husband, and his last words, I'm gonna explicitly kill you, he means it. He's not cooling down. That woman needs something to defend herself with right now. She doesn't have to buy a gun. She can go and rent to her mother's place, father's place, cousin's place, sure. But she could buy a gun if she wanted to, if she's in that much fear of her life, and leave with it that day. If this were to be implemented, there is some conflict with federal law, which was touched on. Between 18 years of age and 21, there's a 10-day waiting period now. It was in response to a lot of young shooters that were shooting up in schools and Walmarts and stuff. So that's already in conflict there. If I get a delay from the gun line, saying it's a delay, it's a pending, is the actual language used, pending, P, 5 zeros, and then 5 numbers, I'm not going to violate law and be held accountable because somebody's going to tell me, yeah, you can do it. If that gun's used incorrectly, who's on the hook for that? The officer who told me to do it? Or me? I'm on the hook either way. I'm a gun store. I'm the bad guy. I understand that. I try to do good, though. But let's say, for the sake of argument, that this takes effect, 3-day waiting period, and that person who's been abused or broke the cycle can't get a restraining order right now for whatever reason. They come to me first. Well, I close my doors early because I'm sick. It would be nice if my cousin who has a gun could give it to me. Well, 59 would prevent that, wouldn't it? So now we've just helped along a victim become more of a victim with both sets of these proposed laws. I hope some of the testimony that is being given here makes sense and gives you a different perspective on how to look at things. Again, I don't believe anybody here is doing this other than from the heart and what they believe, because they want people to be safe. They don't want people to get hurt. I think we all agree on that. There's different ways of preventing from becoming a victim, different ways of responding to a violent situation. But I respectfully ask you, let's not penalize the citizens who wish to exercise their rights the way they want to, the way we've been doing for for hundreds of years as a republic. Let's not start making exceptions. That's not rule of law. Then we start putting certain people in certain classes. Oh, the trooper can have a gun, you gotta wait. He already has a gun, man. State gave it to him, we paid for it. He's all set. And as in the other example, what if his wife was the abused victim here? She needs something to defend herself. He's trained. And as was pointed out by some other female colleagues here, stature. Look at me, 5'9", 280. Where's Kim? Think she's gonna stop me? It's morbid. I understand that. But it's real. Thank you for your time.
Thank you for your testimony. Chair calls J.E. Simkin, and up next will be Timothy Wolf.
Good afternoon, Mr. Chairman and members of the committee. Thank you for this opportunity to testify. I'll try to be a little briefer than I've been. Anyone who uses the term, quote, gun violence, end quote, seeks to mislead. Homicide is a crime. Suicide is not. Both are very sad, but these are fundamentally different events that should not be lumped together. The doing so is, to my mind, bespeaks a certain element of intellectual dishonesty. Now, to the bill. In New Hampshire, and for the members of the committee, I may labor the obvious, murders are so infrequent that all are prosecuted by an assistant to the Attorney General of the state. I presume, I do not know this for sure, that county prosecutors don't see enough murders to become adept at this type of prosecution. The murder rate in New Hampshire typically is about 1 per 100,000, which is about the same as in, quote, civilized countries in Europe. Occasionally it will pop above, occasionally a little below 1, whereas the murder rate in the nation at large is usually 5 per 100,000 or more. So again, we appear to be a very law-abiding state. There would not, therefore, appear to be any matter, any reason having to do with prevention of crime for a waiting period at all. I can explain, if anyone wants to ask a question, why the incidence of violent crime in New Hampshire is so much lower than it is in Massachusetts, our neighbor to the south. But I'll only take your time if you wish. As to other civilized countries, and I put that term civilized countries in quotes, those who use or cite those statistics disregard the number of residents of those countries who, for example, were murdered by the Nazis. Victims of genocide aren't counted. The biggest murderer in the century just closed, the 20th century, were not criminals, either common or organized. The biggest murderers in the century just closed were officials of governments gone bad. Nazi Germany, Soviet Union, Mao Zedong's China, Rwanda, Cambodia, Uganda, Guatemala. All of these countries had gun control regimes in place, in some cases 90 years before the genocide occurred. You should think of gun control laws as akin to expended but unexploded bombs and artillery shells. Ukraine, for the next century, will have to send out teams to dig up and disarm or explode in place, quote, dud rounds. How do I know this? And I do know it with certainty. I know this because in Western Europe, where a war has not been fought for 80 years, governments there, if not daily, certainly weekly, France, Belgium, Germany, sometimes even Britain, send teams of military experts to disarm unexploded ordnance. And this stuff remains lethal.
Mr. Simkin?
Okay.
The committee appreciates the history, but
Well, the
stick to
history,
three-day waiting period,
the
please.
history, Mr. Chairman, is relevant.
The three-day waiting period.
Because everyone here, at some level, buys the case that gun control saves lives. And therefore, the discussion is, well, how do we adjust it to make it less onerous? My point attacks the basic concept. Gun control clears the way, not for 1,000 murders, for millions. The fact that it hasn't happened here recently, neither here nor there. And this is a point that I really think the members of the committee need to think about. Because the same bills are brought back year after year after year, because the assumption is gun control is a social good. Even in countries where firearms are not abundant, it's a bad concept, a lethally bad concept. Thank you, Mr. Chairman and members of the committee, for your time. I appreciate it.
Thank you.
I'll be happy to answer any questions relevant to my testimony.
And thank you for that availability.
You're welcome.
The chair recognizes Timothy Wolf. Up next will be James Gaffney.
Thank you. Some good testimony here. Just standing there, or sitting there, I should say, really brought up a lot of issues I hadn't really even thought of. But in terms of this bill, I see a lot of this type of legislation being proposed for suicide prevention specifically. And it's a pretty close issue to me. I can think of 4 people just sitting there that I know or have a son, actually in one case, who took their life at the hand of a firearm. One of them actually is still alive, unfortunately for her, as a ward of the state of Massachusetts. So I understand the intention, but I have to say that talking to all these people's families afterwards, these were not stupid people. They were hurting. And they would have found a way to take their lives with or without a firearm. There's no doubt about that. Is a firearm something that you use? It's quick. You can't take it back. Yes. But do we need to, the cases that a lot of other people have made here is if somebody needs a gun, I specifically think of my children, my 2 sons. They're getting older. One of them's out of my house. One of them's about to be out of my house. And I brought them up, I taught them how to shoot, but they have no interest in firearms at all. But they know how to use them. And God forbid they be in a situation where they would ever need that firearm and they be in another state, per se, say that state is a student or something and you're in New Hampshire. And somebody, relative, basically says, I want to kill you. And it's a domestic situation, whether it be a man or a woman, and somebody else wants to do you harm. Well, 3 days is a long time when somebody wants to kill you. And I think for every action, there's a reaction. So yes, I understand this is seen as a cooling off period for somebody to kind of get their wits back about them. But if you're the person who needs a gun because somebody wants to kill you, it doesn't give you the opportunity to defend yourself, and it discounts their life. It does not give them the chance to defend their life. So that would be my major issue with it. And in a lot of cases, and specifically all the ones that I am unfortunately a little too familiar with, those guns were already owned. They were already in possession, you know, and other people I know, you know, I mean, but they could have used a charcoal grill just as easily as they could have a firearm. So anyhow, thank you.
Thank you for that testimony. The chair calls James Gaffney, and Penny Dean will be next.
This bill is very similar to the last one. It's not going to accomplish anything. I'll let Penny go into the structural details of it, but this is a bill that is written in such a manner that it tries to lump together two different issues. Suicide is very, very different than someone committing violence against another person, right? That's the first thing. The second thing is that if somebody wants to do something, whether it's kill themselves or commit a violent act, right? In the second case, we already have laws against that. It's illegal to murder somebody. It's illegal to commit assault. It's illegal 16 different ways. So if they already have a gun or a knife or a baseball bat or an automobile or any other tool, this makes me a tool user, they're going to find a way to do it. And nothing you say or do can stop them from doing it. Period. Full stop. You are not going to stop people from, this law is not going to cause somebody to say, oh, wow, now that it's 17 times illegal, I'm not going to do it. It's like the joke about the British police. Stop or I'll say stop again. So, as far as suicide goes, well, I haven't heard anybody offer much information.
I just want to interrupt you real quick. I wanted to recognize in the gallery, we have a class of school children here today, and I wanted to thank them for coming in to take part in this government exercise. So thank you very much and welcome to the New Hampshire House.
Thank you, sir.
And
as far as suicide goes, we haven't heard anybody talk to the reasons that people commit suicide. It's varied. It's everything from mental illness to people who are terminally ill and want to end their lives. And I think that's an important point because nobody's talked about it before. This is my life. If I'm facing a terminal illness, it's not up to any of you or anyone else to tell me whether or not I can choose to end my life or not. This bill, it's a complicated issue, but this bill in the end will not accomplish anything but trample the rights of people over and over and over. Please give this an ITL rating. Any questions?
Thank you for your testimony.
Thank you.
The chair recognizes Attorney Penny Dean.
Thank you, Mr. Chair and members of the committee. Good afternoon. And I would ask that you ITL this bill. Despite its laudable goals, as judges tell me all the time, connect the dots. Tell me how it's relevant. They can't. This isn't anything that we should, quote, have to deal with. This is a constitutional right. And that's really what's important. I happen to do divorces. There's no waiting period. You know, they have 30 days like everything else before it kicks in for an appeal period. That's not a waiting period. It happens with all sorts of cases. There's a period of time in which either party can appeal. But you're talking again about a constitutional right here. That's a big deal. But when we look at, I call them dog whistles of the anti-gun community. Whenever you hear the words reasonable restriction, common sense, those should be keywords to anti-Second Amendment litigation, legislation. And that's what it is. And to say that people support this, I don't buy it. I haven't seen any surveys that they support things like this. And I understand that suicide may be an impulsive issue. Don't disagree with that. But here, so you're telling me that people who have taken Hunter education are not impulsive? It just so happens that I taught Hunter education, that's an interesting story, for 17 years. So it says here that if you have certain criterion, that you would be exempt from that. And again, back to connecting the dots. So you're going to tell me that if I just go out and buy a hunting license, I'm exempt? That doesn't make any sense to me. Doesn't make any sense whatsoever. The other thing that we hear about more and more and more is police and firemen about how they're really stressed out about their jobs lately. They're having higher and higher and higher suicide rates, and they are taking mental health breaks. And so what about the police officer who has a domestic violence restraining order against him? They pulled, he's off work, paid or unpaid. He can walk in because he's exempt from that waiting period, according to this. But I think the thing that probably concerns me, or one of the most important things concerns me of this, is that if you look at page 1, line 25 and 26, there's an exemption for a person who has obtained a valid restraining order. Anybody on planet Earth can get a temporary restraining order, ex parte, before the person has a right to a hearing. And there's an old saying that you could indict a ham sandwich, and it's about darn true when it comes to some of these temporary orders. And so you look at a person, the question is this going to incentivize people to make false accusations against other people? And I think that's a problem. You're going to have, I'm not saying everyone or all of them, but I'm saying I can see a person going into a police department and having someone, because I've seen all sorts of officials do it, nod, nod, wink, wink, nudge, nudge. If this was your problem, I could help you. Are you scared? And so you have to ask yourself how many false accusations we'll get out of this. And how many temporary orders that once there's a hearing are dismissed. But yet that person got away with no waiting period. And I'm not saying there should be a waiting period. I'm totally against it. It's a constitutional right. It's not like buying a car. It's not like getting a divorce. It's not like anything else. But there are huge mechanical and inequitable problems in this. And for someone to suggest that certain categories of people essentially are less impulsive, so you don't have to worry about them, they can buy guns, but all the other people, they're impulsive, so we're going to stop them and save their life. I think that's patently ridiculous. And happy to answer any questions, and thank you for listening to me.
Thank you for your testimony. The chair is recalling Joanne Brown. I believe I saw her enter. You don't want to testify on this one? Okay, thank you. Anyone else hasn't turned in their pink card? Who? Oh, go ahead.
While the intentions of this legislation attempt to stop some of the suicides that occur in the state of New Hampshire, it does not address the actual issue of suicide, nor help the people who are potentially thinking about suicide. In 2021, the latest official statistics from the Centers for Disease Control, 223 Granite Staters committed suicide. Around half of those people used a firearm. Why are legislators focusing only on firearms rather than focusing on the mental health help necessary to help all people who may be thinking of committing suicide? Japan has a higher rate of suicide per capita than the United States, and they don't have guns. At the same time, this legislation also creates a deadly problem for others, especially women who are in abusive situations or need to protect themselves from stalkers. It turns the women who are already victims of this abuse or stalking into victims of the legislature because they are unable to purchase a firearm to protect themselves thanks to an arbitrary waiting period that can mean the difference between life or death. Now, we brought that up last time this, again, out-of-state legislation was pushed in the legislature, so they changed it to include people who get restraining orders, or if someone tells an officer that they are in reasonable fear of their life. So really, a woman is going to have to wait to prove she can immediately practice her fundamental human right to self-defense only if she gets a piece of paper or brings a police officer to the gun shop with her? While we've been in here, there is a woman online. Her name is Maura Chappelle. She was going to be here but she stayed home due to illness, but she's listening. And she told me that it took her 2 days to get a restraining order from her abuser. And she would have much preferred to go to a gun shop to try to protect herself, but she couldn't. Please vote inexpedient to legislate on this bill. The legislation will make it so women cannot save their own lives because law-abiding women will follow the law, no matter how ridiculous. Their attackers will not do the same.
Thank you for your testimony. And that being the last person, I'm going to go ahead and close the. What was? Yeah. Yeah, regardless, please come up and take the microphone.
Thank you. William Rogers. I think we look at guns differently here in this room. I look at it as a self-defense tool, strictly to defend myself and to defend my family, defend my country, defend my state. Being a self-defense tool, like other people have done, there might be times I want it immediately, and I might be a person who never had one before. Why should I be infringed? If you see it as a suicide tool, strictly as a weapon of violence to do harm, I could see that makes sense. But if you see it as a defense weapon, it makes no sense. And I'm not just talking about, it's certainly valid, a woman who's been stalked or has someone or feels threatened. And I see that woman, I don't see a suicidal person with a gun to their head. That's a horrible, tragic thing. I see a woman behind her door and she's relieved. She's breathing a sigh of relief that she can protect herself. And as the lawyer said, this is an infringement on the Second Amendment. Plain and simple. We have the right to defend ourselves. Why would we wait to do it? And this could also be not just a stalker, it could be a natural disaster coming. We know there's the hurricane of the century coming, and we're worried about looting. We're worried about things like that. If I had no weapon, I would go out and get one, and I would expect to be able to protect myself, because it is a self-defense tool strictly. Thank you.
Thank you for your testimony. With that, I'm closing the public hearing on HB 76. At this time, I open the public hearing on HB 78 and recognize Speaker Shurtleff to introduce the bill.
Thank you. Thank you, Mr. Chairman and members of the committee. For the record, my name is Steve Shurtleff, and I represent Merrimack District 15, which is Ward 1 of Concord, the village of Pennacook. And having sat where all of you are sitting today, let me start by saying, in conclusion, I'm here on behalf of Representative Vail to introduce this bill, and I want to thank the committee for everything you've done already this morning, your attention and your politeness to the witnesses on both sides of the issue. It's commendable and looks very well on the New Hampshire House. Mr. Chairman, in 1997, as I mentioned, I retired as a supervisory deputy U.S. Marshal. And in 1997, I was still on the job in August of that year. And we learned of the horrific shooting up in the northern part of the state, and the name now has escaped my mind, and I know Colebrook, where 4 people had been murdered. A newspaper editor, a district court judge, and 2 state troopers, Scott Phillips and Leslie Lord. And my partner at the time, Bob Weisberg, looked at me and said, "You know, Steve, New Hampshire's not Mayberry anymore." And regardless of some of the testimony we've heard, New Hampshire really isn't Mayberry. He was right 25 years ago. I'm here to ask the committee to support House Bill 78, which would repeal 1178, which restricts law enforcement involvement in the enforcement of any federal gun law that could impair the New Hampshire's right to bear arms. Last September, the Attorney General, our current Attorney General, Famella, issued a 6-page memorandum to New Hampshire law enforcement going through the various points that have already been brought up that officers could be concerned about if what they were doing were legal or were they violating the RSA that forbid them involving themselves in federal gun laws. And one of the things the Attorney General pointed out on page 3 of his memorandum was, be very careful. Although you're a law enforcement officer, you could be charged under federal law with aiding and abetting if you should not do something you should legally do. For example, if you're searching a prisoner and you locate a handgun that's illegal, you've got to make sure that you seize that as you would any evidence is turned over to federal agents so they can prosecute that case. The AG also said, don't confuse assistance with cooperation. They aren't the same. You have certain rights. And the 6-page memorandum was followed by several frequently asked questions. And I wouldn't be surprised if the AG had to do a supplemental, because you did a wonderful job of pointing out where you could be wrong and what you're doing. And this concerns me, and it goes back to what I talked about, that horrific death and those that died. The officers acted superbly. But my fear today is that a local officer or a state officer could get involved in a situation and be hesitant for just a few seconds because they're not sure if they're violating the state law. And I'd hate to see that kind of a tragedy happen again in New Hampshire. And I thank you again, Mr. Chairman. If there are any questions, I'd be glad to answer them.
Thank you for your testimony and introducing the bill, Mr. Speaker.
Thank you, Mr. Chairman.
The chair recognizes the Honorable John Burt. Just for everyone's information, I'm going to do 2 more witnesses, and we are going to take a short lunch break, and then we will continue.
Thank you, Mr. Chairman and fine committee members. Again, I am former Representative John Burt. I served 12 years here. Mr. Chairman, I'm a little concerned on this bill because it repeals 1178, which is my bill. 1178, that House Bill 78 repeals, I worked extremely hard to get it right. And let me explain what I mean by right. If you break New Hampshire law, as the case in Colebrook, and the feds, for whatever reason, I don't know if they were involved with the Colebrook case, but if they were, New Hampshire law enforcement can help because you broke New Hampshire law. It's that easy. That's why the governor signed this. This is a good bill that that House Bill 78 is trying to repeal. So I hope you ITL this bill. I'd like to point out that I was very honored. There's a magazine called The American Revolution that is put out, and it was put out on the 4th quarter of last year. I'm mentioned in that bill, or the magazine, again, The American Revolution. It says, New Hampshire emerges as a beacon of liberty. And it was by Heather Fazo. What the article read real quick is this one section. It says, with the leadership of John Burt, the law has been corrected and that the citizens of New Hampshire now can move forward, move about the mountains fully armed on the snowmobiles. And that was another bill. But then it goes into this. More significantly, Rep. Burt's House Bill 1178 effectively rejects federal gun control, asserting that state and local law enforcement will not cooperate with the Bureau of ATF. And then it also says what the real world impacts of this bill. Earlier this year, the White House announced a new rule that would ban ghost guns. That's the build kits, which allow you to create a firearm without a serial number. House Bill 1178, that this bill is trying to repeal, states that local and state officials are forbidden to help federal agents in an unconstitutional rule. So that's what this is trying to repeal, is my House Bill 1178, which is protecting New Hampshire citizens from unconstitutional laws that the feds or rules that the feds pass. So I asked you to ITL this because, again, New Hampshire is a very safe state. We want to protect ourselves from the federal government's overreach up here. Everybody on this board, everybody out here, both sides always says local control. Well, I don't want the feds to come up here and to borrow my Goffstown policemen to come to my house if they feel I did something wrong, which I didn't. And that is the way it should be. The feds do not need our tax-paid local police help to enforce their unconstitutional rules or laws. So please, ITL House Bill 78. Thank you.
Thank you for your testimony. The chair calls Brian Blackton. This will be the last witness before lunch.
This is real short. I asked ITL this bill. I believe it is merely an attempt at strategically trying to form the groundwork to remove arms from citizens, making them subjects. We already had that discussion and it didn't go well for Britain. That's why we have Article 2A and 10 in our state constitution. Thank you.
Thank you for that testimony. At this point, the committee stands in recess for 1 hour until, what is it, an hour, no, quarter of 2. Quarter to 2? Yeah, 1 hour. Yeah, 1:45, in other words.
Oh, I know where I stand. I know.
So,
the public hearing for House Bill 78 in the House. The chair recognizes, who's up next? That's Representative Tom Mannion.
Thank you, Mr. Chair, members of the committee. My name is Tom Minion. I represent Hillsborough 1, Pelham. I'm here to speak against HB 78. The federal government creates so many rules and laws that even their bloated agencies are incapable of enforcing them all. As such, they rely on our law enforcement to waste time and resources, aiding in any number of potentially unconstitutional acts. They reward such obedience with things like bearcats that the police then use to smash in the front of private residents just because they can. Our law enforcement should be focused on the laws of New Hampshire. We are not obligated to assist the feds with whatever new rules they create, especially as it pertains to firearms. The ATF's own rules are extremely fluid in nature, and they don't wait for a law to come from Congress to just decide to ban new things. The latest are pistol braces. But before that, an executive order from President Trump banned bump stocks, only to be overturned by the courts. So in the interim, while these unconstitutional rules and executive orders came into existence with no oversight, any one of us could become a felon in our sleep. Last year's House Bill 1178 of John Burt, great guy, put an end to wasting our law enforcement's time with these wild swings in policy from DC. If the feds want to enforce these laws, there's sadly not much we can do about it yet, but they're going to have a much harder time doing it alone. Despite what the ATF and others believe, we have a natural right to self-defense, and we respect that here in New Hampshire. I personally believe the ATF is an illegal organization responsible for many deaths caused by their actions over the decades. I do not want our state law enforcement agencies cooperating with them, and ideally, we'll create an alert system warning communities that they are in danger whenever they are on the move, akin to a Midwestern tornado sirens. I ask the committee to ITL HB 78, and I'm willing to take any questions.
Thank you for your testimony this afternoon. Chair recognizes Andrew Scholler.
Hello, just a quick point. The public employees of the state of New Hampshire, they're supposed to serve the constituents of New Hampshire, not the federal agents. And so I support the ITL of Bill 78, and I'd like to keep our public servants focused on just New Hampshire and protecting New Hampshire residents rather than throwing them in prison. Thank you, that's all.
Thank you for your testimony. The House recognizes Dr. Leonard Cohen.
Thank you again. And as I've said before, I'm representing both the New Hampshire Medical Society and the New Hampshire Psychiatric Society. And, you know, listening to so much testimony this morning and beginning this afternoon, it almost seems like so many people in New Hampshire don't salute the American flag. They only seem to want to follow laws that are New Hampshire laws. Well, HB 78 is an attempt to repeal what many of us think is an unconstitutional law as it is 1178. Now, as a psychiatrist in New Hampshire, I've been aware ever since I came to the state almost 50 years ago that New Hampshire does not send the names of committed patients who are committed after meeting with the judge because they're a danger to themselves or others. So individuals who are committed can leave the hospital and their names are not sent to the National Data Bank. And so they can go out and buy a gun. That has never seemed to be a particularly good idea for one who wants to have safety in our state. We don't keep track of those records, so we don't really know what happens to those patients after they leave the hospital in terms of whether a certain percentage of them commit violence towards themselves or someone else. So that's one thing about this 1178 that doesn't really make sense to me. And it doesn't make sense to me either because we're one of 50 states in this country. And why shouldn't we do whatever we can to prevent gun violence? Now, there was somebody who made a statement that suicide is not a crime. That is true, but it's not terribly a good idea. And if we can prevent it, as psychiatrists, as mental health individuals, as families, we would like to do something to prevent it. Now, there's also a recent executive order preventing or trying to regulate ghost guns. Why does it not make sense that we would have a mechanism to prevent people who are not allowed to purchase a gun to get a gun by another means? And these ghost guns are being involved in crimes more and more. 3-4 years ago, maybe 10% of crimes were committed with ghost guns around the country. Now 33% are, and the percentages are going up. So it makes sense, if we want to prevent gun violence, to follow some national laws as well as the laws in New Hampshire. So that's why not only the New Hampshire Medical Society and the New Hampshire Psychiatric Society, but more than 70 medical societies around the country are trying to encourage reasonable, common sense gun laws. And that includes the American Medical Association. So thank you very much. Anybody have any questions? Thank you.
Thank you for testifying. The chair recognizes James Grenier. And up next will be Representative Heather Raymond.
Well, thank you for your time. And I want to thank each and every one of you, actually, for your time for being here every week. You probably don't hear it enough, but it is appreciated by the rest of us who are just kind of private citizens hanging around. I get up here about once a year at most, and this is the only bill I'm going to speak about. So, as you know already, everyone knows that HB 78 seeks to repeal HB 1178. And that bill tells the agencies of New Hampshire that they do not have to comply with any unconstitutional law, rule, or mandate imposed by the federal government. Unconstitutional means that it is not under the purview, right, of the federal government, but under the state government. When you think of it, it's a little silly. We shouldn't have to have a bill that tells the federal government that they can't do something that's not in their rules, you know? But there it is. That's where we are in 2023. We can, by the way, regulate our own rules here. This is, I know we're not doing history, but I just verified that this is the chamber where we've been continuously doing business since 1819. So you're a part of that. So I'll just ask you to, I would ask you as a citizen like yourselves to mark HB 78 as ITL. Let the legislature go on with all the many bills you have instead of repealing one you just did last year, and continue to do the work of the people of New Hampshire. Thank you.
Thank you for your testimony and your kind words. The chair recognizes Representative Heather Raymond, and up next will be Eric Leighton.
Oh, I'm sorry. Eric Leightonen, Lancaster, New Hampshire.
and I'm very honored to be addressing you today, and I would like to strongly oppose HB 78. I say this to you as a former federal employee, a member of the military with a long, illustrious career where I circled the globe at least 3 times, east to west, north and south. I've served in 2 wars, and I have been in areas of the world where there have been more penguins than people. So I have a very unique insight on the U.S. federal government and life here in New Hampshire, and I'm very grateful to be here as a citizen of New Hampshire, which is, after all of my travels, the place that I truly believe is the safest, freest place in North America. This didn't happen by accident. It's in the DNA of New Hampshire. It's in the mortar of this very building. New Hampshire existed before the federal government. It had a constitution before the federal government. And long after the bloated federal behemoth passes away into the dustbin of history due to its printing of money and corruption, New Hampshire will still be here. The state of New Hampshire has done a wonderful job of protecting the rights of its citizens. We have an exceptionally well-armed populace, and it's protected by a limited government. That we're fortunate to have even people here today who have actually put legislation forth to protect the rights of citizens from an overstepping federal government. That's an honor. Lest anyone have any doubt about where, I'm sorry, let me just check one thing here. I want to pull something up for you. I had it there, one moment. I apologize. The Article 7 of the New Hampshire Constitution expressly recognizes, I actually invite all of you to reference that. It expressly recognizes the sovereignty of the state of New Hampshire as a unique, free, independent, sovereign republic. When New Hampshire decided to join what is now called the United States, it delegated certain things to it. The United States government today has overstepped the bounds on so many levels. We see it. We see a politicized FBI, IRS, Homeland Security, ATF. The litany of alphabet agencies goes on and on. And wise legislators with a sitting governor decided, no, we are residents of a place called New Hampshire. We recognize the rights of our citizens, and we will not allow federal agents to come in and trample the people that live here. And we're going to hold law enforcement and agencies accountable. And I want to know, and I'm grateful to know, that my county sheriff, my town police, the New Hampshire State Police are there and they have my back. They're not going to be part of that just perfidious circus that we see in Washington, D.C. And whether you like Trump or Biden, Pelosi, Schumer, or the litany, the circus continues. And even though they have lost sight of what their mandate is, I hope and I pray that our legislators are wise enough to recognize the tragedy that is Washington, D.C., and the cabal that is there, and all the many reasons why that's happening. Here we do it differently. We've codified it. We recognize it. The government doesn't give us rights, it protects our rights. And I ask you, each of you, to remember that. We do it differently here in New Hampshire, and I remind you, we live free or we die. Those words were said in a specific context, and they haven't lost their power today. I say this as a former member of the military, the instrument of the agent of those policies. Please remember that. Don't lose sight of that. We're not a county in the United States of America. We are an independent sovereign entity. The 10th Amendment of the Constitution recognizes us as such and specifically gives police powers to the states.
Thank you for your testimony. Chair recognizes Brian Barry.
Button. Got me that time. I'm going to draw on a few documents that helped found this state and this nation. United States Constitution, Amendment number 10. Powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Part first, Bill of Rights, Constitution of New Hampshire, our great state. Article 7, which was touched upon. The people of this state have the sole and exclusive right of governing themselves as a free, sovereign, and independent state, and do and forever hereafter shall exercise and enjoy every power, jurisdiction, and right pertaining thereto, which is not, or may not hereafter be, by them expressly delegated to the United States of America and Congress assembled. It's not just about firearms, although we are here talking about firearms. It is about government overreach, federal government overreach in this case. It's creeping up everywhere. In guns, firearms, we see what's going on. Executive orders for this, reinterpretations for that. I'm changing this rule. The braces, I'm sure those that have been in the news lately were all familiar with the braces that are becoming the new terror of the gun world. A few years ago, the ATF approved it in a letter saying, yeah, it's fine, no problem. Now, for some reason, they changed their mind. They measure something a little bit different and go, oh no, now it's going to be a short barrel rifle. Now you need a stamp for it. We can go down the list of education, CRT maybe, so on and so forth. We all know what's in the news. We all know what it's about. I don't have to hash it out here. There'll probably be another committee for that. We can do that later on. But there is federal overreach. I believe our founders want each state to pave their own course. Not to be separate from the United States, but to be their own state. Each state is to be its own little experiment. We're doing it right in a lot of ways. No income taxes, no sales tax, a thriving and growing economy here, low crime rate, lots of natural resources, camping, skiing. We have the coast, we have lakes, you name it. We're doing it right. We still have some work to do. We should be paving and steering our own course. In this case, we're saying let's not help the feds with what could be unconstitutional laws and regulation. Law enforcement representatives like you across this nation at every level swear an oath to the Constitution of the United States of America and to the Constitution of the state in which you serve. That's a serious oath. I'm former military, I'm former law enforcement, and I can speak for myself, I won't speak for my brother over there. My oath has no expiration. I love our country with all its flaws, with all of our good history and all of our bad history, with all of our mistakes. We make it work. Nowhere else can you have such a diverse population of religion, race, creed, origin come together and make things work. No other country can you go to. I can't go to China and become Chinese. I can't go to Brazil and become Brazilian. But anybody in this world can come here and become American. That's what's unique about our country, and I love it. You may think I've strayed off course, but I haven't. We are the masters of our own destiny here. This is just one example of overreach by the federal government. Let's take care of ourselves. I'm not saying to blow off the United States. I'm not saying separate from them. That's not what I'm saying. But there are some things which we can stand up for as a state and say, that's enough. No. You don't need to come in here and pull our resources. You got an investigation to do, you got a law to enforce, you'll go ahead and do it. Our troopers are out here saving lives. Our officers are out here neighborhood policing, in many cases, from Nashua to Manchester. They're trying to do the right thing. Bridge that divide. Protect and serve. Feds have enough money. They want to send people in to do an investigation for federal crimes. Let them handle it. Thank you for your time.
Thank you for your testimony. Timothy Wolf. And he'll be followed by John Hink.
Thank you. I'm here to oppose this bill. It does seem almost like we should never have needed this bill, but that said, it's here, and I don't see what harm there is in letting it stand. When I look at something, this is very short here, and it says the bill repeals a prohibition of the state from enforcing any federal statute, regulation, or presidential executive order that restricts or regulates the rights of the people to keep and bear arms. That's basic. That's our rights. Why would we want to restrict or regulate that? I was a student of history, which most people don't know. I graduated UNH with a 4-year degree, a non-Western, and had my fair share of American history. And I won't bore you with a history lesson, but the one thing that I always found interesting was that most people didn't know is that the United States Constitution, the people of this country did not want to ratify it. It's a beloved document to us, but they didn't want to ratify it. The only way they were able to get the document ratified was to add what we call the Bill of Rights, the first 10 amendments. And those were known to be individual rights. They realized that the document gave too much power to a central government, and they had just fought a revolution or a war of insurrection, depending on your viewpoint, against the insurrection. But it basically, they realized it was overreaching, and by securing those individual rights, ensuring their individual rights, they allowed the Constitution, they said, okay, we will ratify this because it secures individual rights. And Article 1, 2, and 3 that form the executive branch, that forms the legislature and the courts, the only reason that those are allowed to exist is because we said, okay, we'll allow this government to exist if we have these individual rights. If you start taking away those rights, you're starting to take away public trust. And when you take away public trust, I don't know if we want to go down that road because, it puts chills on my skin thinking of, if we were to take this bill and instead of the way it's written, if I can find it here again, which I probably can't, if we basically were to say that we wanted to if it was something that restricted, say, I don't know, freedom of religion, freedom of speech, press, maybe quartering soldiers in our homes or right to a fair trial, it just sets a bad precedence. And basically my concern with it more than anything, like I said, I don't see any reason to repeal it. And I do find real danger in the fact that, people, basically the Constitution is null and void if people lose their individual rights. They do not have to accept an executive branch. They do not have to accept a judicial branch. They do not have to accept the legislature if they feel as though those institutions are treading on their individual rights. That's it. Thank you.
Thank you for your testimony. The chair recognizes John Hink.
Good afternoon. I'm Dr. John Hink, also representing the New Hampshire Psychiatric Society. I'd like to agree with everything my colleague Len Korn just said. We'd like to support HB 78 to allow for federal gun safety laws, such as the application of the Brady Law in New Hampshire. The Brady Act is a federal law enacted in 1993 by the U.S. Congress following the assassination attempt against President Ronald Reagan. It prohibits firearm purchases from certain individuals who have been committed to a mental institution. Currently, there are no state prohibitions on individuals committed to a mental institution from purchasing firearms. Thank you for your attention.
Thank you for your testimony. Chair recognizes James Gaffney.
Thanks for the opportunity. I'll try to keep this brief. I'd like to address a comment that the previous speaker offered in testimony. There are, in fact, federal laws that prohibit the ownership of firearms of people who are involuntarily committed to mental institutions. That's well established. Back to my own testimony, if I may. The existing statute seems to be, well, for lack of a better way of putting it, it's like, duh. You guys are supposed to defend and protect our rights. You took oaths to uphold the state and the federal constitution. Those constitutions have explicit language in there that says that government shall not infringe upon our rights, and that it confirms our natural right to keep and bear arms and defend ourselves, our families, our property, et cetera, et cetera, et cetera. So the existing statute really is a no-brainer, and the only reason I can think of that the sponsors of this bill would want to support unlawful actions, to support unconstitutional actions, is because they're getting ready to do something that you might kill them over. I'm sorry to go there, but if people are supporting and trying to advocate for tyranny, I'm not sure how anybody can condone that, let alone a legislative body. Your job is to protect and to defend our rights. The Constitution of this state and our federal Constitution were put in place to limit what government can do. Our freedoms are a function or a product of the limitation of government. It's government that infringes upon individual rights, natural and otherwise. And if we read through, depending on your familiarity of history, well, why do we have a state constitution? Why do we have a federal constitution? It was because they were afraid of the creation of an all-power, overreaching central government again, i.e. the English crown, right? So the Constitution is a limitation on government. I ask you guys to uphold your constitutional obligations and your oath to those constitutions and ITL this bill. Thank you.
Thank you for your testimony. Chair recognizes Dr. Joe Hannon.
Thank you, members of the committee. I hope you had a great lunch. I'm glad you took a recess, even though you ruined a joke. My analysis said this bill delays lunch, and I couldn't use it as effectively before, but I thought I'd give it to you now. This is a pretty simple thing, and I'll make it brief because I had the pre-lunch speech ready for you, so I'll give you that. Article 7 of the state constitution, state sovereignty. The people of the state have the sole and exclusive right of governing themselves as a free, sovereign, and independent state, and do and forever hereafter shall exercise and enjoy every power, jurisdiction, and right pertaining hereto, which is not or may not hereafter be by them expressly delegated to the United States of America in Congress assembled, June 2nd, 1784, prior to the adoption of the U.S. Constitution. I'm not going to read Article 2A to you. If you're on this committee, you probably know that, but it's also very relevant to this. And for those reasons, I think it's very important that we as New Hampshire retain our identity, our laws, and our safety and keep this in place. Since it's been passed, I have yet to hear a complaint other than I believe one of the complaints I heard was officers should be concerned about doing what is legal. Well, I think that should be across the board, no matter what. They should always be concerned about doing what is legal. So please, you know what to do with this. Thank you.
Thank you for your testimony. Chair recognizes Nick Hubbard.
Thank you, Mr. Chair and members of the committee for the opportunity to testify in opposition to House Bill 78 today. The intent of House Bill 78 is to repeal a provision in state law enacted last year to protect the rights of granted staters from federal overreach. Free market economist and political theorist Murray Rothbard, in his 1982 treatise, The Ethics of Liberty, offered this analogy for an argument which I believe best encapsulates the spirit of this bill. If each of us is allowed to remain free in all aspects, and particularly if each of us is allowed to retain weapons and the right of self-defense, then surely we would all be at war against each other and society would be wrecked. Therefore, let us turn over all of our guns and all of our ultimate decision-making power and the power to enforce our rights to the Jones family over there. The Jones family will guard us from our predatory instincts, keep social peace, and enforce justice. But the cry of who would guard us from the Jones family, especially when we are deprived of our weapons, would suffice to shout down such a scheme. Attempting to regulate weapon ownership does nothing to make the populace safer. Instead, it tips the balance of power away from peaceful, law-abiding individuals who adhere to the restrictions and in favor of other unrestricted entities. This includes not only criminals possessing such weapons in violation of the law, but the governments which insist on disarming their subjects. During the Warsaw Ghetto Uprising of 1943, detainees of the ghetto staged an armed resistance against just such a government. In a daring bid to save their lives and the lives of those they loved in the face of impending relocation to concentration camps, roughly 700 of the 70,000 remaining detainees fought to defend the ghetto against Nazi troops for 4 weeks. Those 700 people and their weapons, which they were prohibited from owning by the government attacking them, are the reason there were any survivors from the Warsaw Ghetto at all. Years later, Gerard Metrel quoted one of those survivors in the preface to his book about how to build such a weapon as saying, "There is only one thing I regret very much, that I didn't have a submachine gun." As Metrel and many others following in the same footsteps have ensured, individuals will continue to have access to dangerous weapons whether or not the ownership of such weapons is forbidden or restricted. Therefore, the wisest, safest, and most civilized course of action is to ensure that the balance of power is kept equal. By ignoring the Second Amendment to its Constitution and enacting such laws as the National Firearms Act, the federal government has violated the restrictions it placed for itself on its power. Our legislature should continue to assert the rights of granted staters against this federal overreach, because it is only the assertion of our rights that preserves them. For this reason, I urge the committee to consider House Bill 78 inexpedient to legislate.
Thank you for your testimony. The chair recognizes Kimberly Moran.
Before I begin my testimony, it'll be quick, but since the original bill that this is trying to reverse was passed, I don't know of any firearms dealer who isn't still using ATF Form 4473 to conduct a background check and before they sell a firearm. Right on Form 4473, it says under question 21, section 8, H, have you ever been adjudicated as a mental defective or have you ever been committed to a mental institution? For those who don't understand what adjudicated as a mental defective mean, that means a court of law mandated a person gets inpatient or outpatient mental health treatment. That person is a prohibited person. If you lie on any of the questions on this form, you commit a felony. The adjudication in a court of law shows up on a background check. I just wanted to clear that up. This is the second piece of legislation we've seen this year where legislators who are supposed to represent granted staters are either begging the federal government to infringe upon our Second Amendment rights or demanding that the state legislature not protect our Second Amendment rights from an overreaching federal government. This one's pretty easy. Please vote inexpedient to legislate on this bill. This legislature is supposed to represent granted staters, not the federal government, no matter who's in office. Thank you.
Thank you for your testimony. And the chair recognizes Penny Dean.
Thank you, Chair and members of the committee. I'm asking that you ITL HB 78. And first you have to look at what problem are we looking to solve? Those who suggested it's unconstitutional, there's nobody barring them from the courtroom doors. If they believe it's unconstitutional, let them walk into court and find out. But the bottom line is that you have to look at is what are we trying to fix? We're asking them specifically to follow the law, and we're telling them, more importantly, that federal law enforcement officers can't come in and order New Hampshire law enforcement officers around like dogs. And that's really what we've had before. And this allows regular rank and file law enforcement officers to essentially refuse unlawful orders. And it allows them a shield from doing so. Because you have some, at least in this state, the Police Chiefs Association is one of the most anti-gun associations we've ever seen. Every time we're at the State House, if there's a pro-firearm bill, chiefs are usually against it. If there's an anti-firearm bill, chiefs are usually for it. And you have to understand, those are the people that order the rank and file around. And this law gives rank and file an opportunity to follow the law. But here's the bottom line. We have a governor that can order state workers, state employees, state troopers to do within the laws he chooses. If he wants state troopers to help the feds, he can ask them to. But what you have here, anyone who's been out on any type of scene, there's a hierarchy on scenes. Usually in an accident scene, technically the highest ranking fire officer is the incident commander. But as a practical matter, they tend to be a little bit different people, and sometimes they allow whoever's ranking officer of police there to basically run the scene. And that's how it works as a practical matter. But the bottom line is, just because the feds come into certain areas and run their operations doesn't mean that we should be kowtowing to them. And more importantly, it's really an unfunded mandate. And the question is, do you want your tax dollars used the way you think your officials are using them, or do you want them used the way the feds come in and tell you? And so we look at this, and you haven't heard one person talk about one instance where this law has been a problem. So you ask yourself, why would I want to ITL it when there's not one problem, not one incident that's come up? And we heard one person say, well, you know, I have this fear about this, or I worry about this. So we're going to change a law that hasn't caused any problem because one person has a fear or concern and they can't articulate what specifically that fear or concern is about? I'm back to connecting the dots. You've got to say, this is my fear, this is what I think will happen. And it just hasn't happened in a decade or so. So the question you have to ask yourself is, why do we want to repeal something that's working? And I go back to the fact that the governor and all sorts of authorities, the chiefs, everyone can offer joint ventures. There's all sorts of other things that can happen. But the bottom line is we're not their lackeys, and we shouldn't be. we're equal. That's the bottom line is, even though federal law has supremacy, when you talk about the 10th Amendment and stuff, we're an equal group of states. And I'm happy to answer any mechanical questions or anything else.
Thank you for your testimony. At this point, I'll be closing the public hearing on HB 78. Oh, we have one more. Did you turn in a pink card? Sir, did you turn in a pink card?
I apologize, Mr. Chairman. I do not believe I did. But based on what I've heard, I beg your indulgence.
Sure. When you're finished testifying, I need you to fill in a pink card. Please keep it short and succinct.
I'll do my very best.
Thank you.
I owe you that. The reason to ITL this bill is summed up in 3 words: Gregory Peter DuPont. Mr. DuPont, native of Massachusetts, convicted of OUI in Massachusetts in 1999. That conviction could have brought a sentence of up to 2.5 years in prison, as no one was hurt and there was no property damage, there was no prison sentence. But the potential sentence made him federally prohibited. In 2004, the Massachusetts General Court specifically created a firearms licensing review board to consider persons who had run afoul of the DUI law. And it authorized this board to restore the civil right to be armed of such persons if, after an evidentiary hearing, the person proved to the board that they had changed their ways and were not going to reoffend. Mr. DuPont went before the board. He convinced the board to issue a letter saying that he was eligible to be armed and he could apply for a license. The board was not then and is not now an issuer of licenses. He moved to New Hampshire. He sought a pistol and revolver license. He sought an armed security guard license. He fully and properly disclosed that he had been convicted and provided proof that his civil right to be armed had been restored. I know these things because as a non-attorney representative, the New Hampshire Supreme Court graciously allowed me to appear as a non-attorney before it because Mr. DuPont's licenses were revoked on the basis of the Massachusetts conviction. I think the feds had a hand in that. They could have prosecuted Mr. DuPont on their own. But folks at Nashua Police Department, and I'm ashamed to say our own Department of Safety, revoked his licenses. The licenses were issued under separate laws. There were 2 separate cases that he brought. Armed security guards don't make a fortune, and when his armed security guard license was revoked, it broke his rice bowl, slashed his income. So I stepped forward to file a brief on his behalf with the New Hampshire Supreme Court and to argue his cause. A very kind attorney stepped up pro bono to appeal the other revocation. Now here's the clincher. New Hampshire had no interest in those revocations. We meaning Department of Safety and Nashua PD, could have accepted the action of the Massachusetts Firearms Licensing Review Board. They did not. And as a result, the matter went through district court for his pistol and revolver license and Superior Court for his armed security guard license. Both were, if you will, I guess, prosecuted by the state on the basis, well, if we let Mr. DuPont acquire firearms by respecting the Massachusetts decision, our employees, New Hampshire state employees, might be prosecuted. I thought that was a joke then. I think it's still a joke. Okay. The New Hampshire Supreme Court issued an extraordinarily strong and favorable decision restoring Mr. DuPont's licenses. So you think that's the end of the matter? No. Someone in the AG's office, I do not know who, decided to seek review by the U.S. Supreme Court with a view to overturning the New Hampshire Supreme Court decision. Maybe that person wanted to curry favor with the feds, but this is a real life example of what happens when the feds and the state decide to team up. In this case, against someone who had done nothing wrong, who had been totally honest with his licensors throughout. So to repeal the statute at issue would be to encourage further abuse of this sort. Just for the record, as a non-attorney representative, I could not, by court rule, and therefore did not, charge Mr. DuPont even a penny. So I met the costs of copying, filing fees out of my own pocket because I thought what Department of Safety and Nashua Pete did to him was just plain wrong. So the idea that, this is sort of theoretical, no, it isn't theoretical. It's happened. You can Google and find the decision, Gregory DuPont versus Nashua Police Department. The Supreme Court of New Hampshire ruled in 2015. I'll be happy to take any questions.
Thank you for your testimony. At this point, I am closing House Bill 78, and we'll be opening House Bill 106. From this point forward, I am instituting a 2-minute rule. We still have 5 bills to get through before the end of the day, and testimony is unfortunately becoming close to being repetitive. So I would encourage you to keep your comments to the point on the bill we're talking about, and assume for the sake of argument that we all understand or at least know the Constitution. Thank you. And at this point, I will recognize Representative Bradley to introduce her bill.
Thank you. Good afternoon. I am here today to testify in support of HB 106. A few years ago, I lost a friend to gun suicide. Having HB 106 in place could have saved his life. 89% of all gun deaths in New Hampshire are suicides. In New Hampshire, the rate of gun deaths has increased by 26% compared to a 13% increase nationwide. And currently, 19 states have implemented ARPO. ARPO is a forward-facing court order that asks the court to assess future danger, temporarily removing access to guns when a person is in crisis. Under HB 106, law enforcement and family members can enlist the help of a court to issue an ARPO. An in-person petition can be filed in the county where the respondent or petitioner resides. Sufficient evidence is proof that is clear and convincing, which is a rightfully high bar to meet. Signs include recent acts or threats of violence, a history of domestic violence, and a past violent criminal history. HB 106 establishes clear and appropriately high standards that must be made before a court issues an ARPO. HB 106 also makes it a criminal offense to falsify a petition or use the process to harass, and the petitioner must appear in court under oath. A temporary ARPO can be issued in emergency situations. Respondents that have a temporary ARPO issued against them can request an expedited hearing to occur within 3 to 5 days. Court-ordered mental health evaluations are already a part of court procedures. HB 106 allows loved ones to intercede in a crisis situation without involuntary commitment. Constitutionally supported due process is built in throughout the reporting, hearing, and notice process. This is a public safety specific civil action. Law enforcement are expected to intercede in instances of imminent danger, both with and without a court warrant. In the case of ERPO, the issuance of the order requires surrender. I ask that the committee recommend OTP. Thank you.
Thank you for introducing the bill. At this point, I recognize Representative David Muse.
Thank you, Mr. Chair. One of the things that I thought I would do, because this is a 9-page bill, it's very long, it's very complicated, and has quite a history, is I thought I just might spend some time going through what the bill does and what it doesn't do. So as quickly as I can, under the bill, law enforcement officers and family or household members in New Hampshire who recognize warning signs of danger could enlist the help of a court in filing a petition to issue an extreme risk protection order. Unlike our domestic violence or stalking protective order process, the procedure for seeking an ERPO order is a civil versus a criminal process that focuses solely on limiting a person's access to firearms if they are found to be an immediate threat to themselves or to others. Under the bill, law enforcement officers, family or household members, and intimate partners of the respondent can petition for an order. There are two types of ERPOs that can actually be issued: a temporary order and a final order. A temporary order can be issued in emergency situations if a judge finds there is reasonable cause to believe that the respondent poses a significant risk of causing personal injury to himself or herself in the immediate future by having access to firearms and ammunition. In urgent situations, the order can also be issued ex parte, that is, without notice to either side and before a full hearing. But ex parte orders are only issued when circumstances pose a real risk that irreparable harm will result if the judge doesn't take immediate action without hearing from all of the sides in the dispute. Temporary orders can last no longer than 7 days, and after that time, the court must hold a full hearing, at which time all parties have the opportunity to appear and present evidence. Respondents who are subject to a temporary ERPO can request an expedited hearing, which must take place within 3 to 5 days of their request. The temporary order automatically expires on the hearing date for the final order. If granted, the final order can remain in effect for no more than 1 year and can only be issued after notice to the respondent in a full hearing at which all parties have the opportunity to be heard. Final orders can only be issued if the court finds there is clear and convincing evidence that a respondent poses a significant risk of causing personal injury to himself or to others by having access to firearms and ammunition. The court also has the option during the final hearing to order a mental health or chemical dependency evaluation. Throughout the process, the person asking for the order bears the burden of proving, based on all relevant evidence, that the respondent poses a serious threat to themselves or to others by having firearms.
Representative, I'm going to have to stop you at that point. I'll let you go a little over the 2 minutes. I will, however, give you as much time as you like during the executive session to address us. So we're going to have to move on to the next witness. Thank you. At this point, Representative John Burt.
Thank you, Mr. Chairman and fine committee members. I oppose this bill, as I always have. It seems to keep coming back like a bad penny. One of the biggest reasons I oppose this is because I'm from the old Vermont. Not the Vermont today, but the old Vermont that used to be there. The new Vermont has this, and a few of my friends have been caught up in this with an X that has a grind, to get back at them, they'll make up something. And let's go to the punishment of this. If you make up a lie, it really doesn't exist. Because when I sat on your committee, criminal justice, when a policeman came up once, I asked him, what's the chances of you prosecuting? He said 0. Because you can't know the intent of the person. You can't prove that they're lying. I mean, sometimes you can, but they still just won't prosecute anybody that lies. And it happens all the time. The other reason I'm against this is, I think most of you know who I am. I have a huge target on my back, and, there's some people that don't like me for some reason, and I don't understand why. But there is. They would love to have this to make up some stuff on me and take my guns, because I'm very vocal about my guns that I have. Until I had the boat accident, of course. They're all gone now. But people want to harm certain people. There are certain crazy people out in this community, and sadly I have them in Goffstown, that would love to have this bill and make up something on me or other people that dare to push the envelope, which I do. Thank you. Please oppose this. ITL it.
2 minutes exactly. Very good, Representative Burke. Chair recognizes James Gaffney. And he will be followed by Kathy Holmes.
Thanks for the opportunity to speak. I would hope that you will vote this bill ITL. We've testified many times on this bill. It's not consistent with the Constitution of the United States, nor is it consistent with the Constitution of New Hampshire. Article 20 clearly states in a civil trial it involves property exceeding $1,500 that the person has a right to a jury trial. The proposed bill will accuse, try, and convict and apply punishment without the party ever being made aware, let alone having an opportunity to face their witness or defend themselves. In no way, shape, or form is this bill constitutional or lawful. As we see, and you will hear, I'm sure, others testify, our current existing ex parte laws are used as a matter of course in divorce proceedings. They're abused regularly. There are no consequences to it. The courts don't even try to prosecute it. We have no data quantifying the problem, but any lawyer that practices family law will tell you as a matter of course they're abused on a regular basis. The New York State Supreme Court just invalidated, declared unconstitutional their emergency protective order. Are we really going to go down that route too, especially in light of the Bruin decision at the Supreme Court, which has cast doubt on pretty much all of these laws? I don't think it's a good place to go. Thank you.
Thank you for your testimony. The chair recognizes Kathy Holmes.
Kathy Holmes, Chichester. I'm against this bill. And the main point you'll find in my orange box there, the actual lawbreaker accuses the innocent and gets away with it again and again. They use the system to suit a myriad of purposes. And this happened to me. And then my husband, just because he's by proxy. We had a past tenant, long 10-year court case, got the judgment 10 years previously. They owed us $12,000 pure rent. Just to keep the lawsuit simple, we left out damages, pure rent. And over the course of their manipulations and lying, and they got warrants for their arrest. We were a thorn in their side. And how convenient, when I was substitute teaching in Concord, happened to be in their second grade girls class. I don't even know the last names. When you're subbing, you don't know people's last names. But so within a flash, I was accused of stalking, and they were afraid. What might I do? So we got the bad advice from the police. Oh, ask for an expedited hearing. Oh, we did. But yet we weren't heard. When we tried to bring up what the situation was, the judge said, I can't hear that. That's another case. When I asked, why won't they be arrested? I can't hear that. So my husband lost the guns and I lost my job. And because we asked for that expedited hearing, we had to go to the New Hampshire Supreme Court. That was our only recourse. Expensive. And here, this tenant, over the years they were living in our property, it was a proven liar. We time and time again, liars lie and they keep on lying.
Ma'am, at this time, I have to cut you off at 2 minutes. We do have that, and we appreciate it. And if any of the members would like to ask further questions, you can approach her off
See
the
at the
side.
bottom to verify my testimony by the court case. You can look it up.
I will, and I appreciate that. Thank you very much. And again, the chair hates to have to cut anybody off, but there's just only so many minutes left in the day. The chair recognizes Dr. Leonard Cord. Why did he change his name?
Thank you again for hearing my testimony. As a psychiatrist, I have witnessed many situations where individuals with serious mental illness are suicidal, sometimes even homicidal, and there's no actions really that we can take until after some violent episode takes place. 23 days ago, I attended a funeral of a 26-year-old young man who I still treat his mother. And she knew that her son was very paranoid and was a potential danger to himself, but she could do nothing. And she told me at the funeral how sad she was that she could do nothing to prevent his impulsive act. This bill, a so-called red flag law, are present in 19 states, and they have reduced suicide in particular. And I encourage you all to consider passing this law so that we can do something to prevent mostly suicide, but also potentially homicide. Thank you very much.
Thank you for your testimony.
Any questions?
The chair recognizes Mr. George Gurick.
Thank you. George R. Jurick, G-U-R-I-C-K Jr. I live in Farmington, New Hampshire. I live in Farmington, New Hampshire, and I represent no one except myself. The treating House Bill 106 as a red flag law is entirely appropriate, but what is, in my research, missing from many of these is the consideration for what is called in American criminal law state of mind and before the fact, two bedrock principles in American criminal law. Before the fact, in many applications to seize a person's private property under red flag laws, there's nothing in the person's background that they are convicted of crime, did a crime, or anything else before the fact. Also, to secure a conviction in misdemeanors and felonies, the prosecution beyond reasonable doubt, must get the ruling that the state of mind has been established. State of mind here in New Hampshire is with purpose, with knowledge, recklessly or negligently. And state of mind applies to red flag laws to show that they're unconstitutional. Red flag laws everywhere, because they don't take those foundations into effect. Thank you.
Thank you for your testimony. Chair recognizes Timothy Wolf.
Thank you. I'll just state, this bill, of all the bills today, this one is really kind of horrific to me. It scares me. And it's, I understand the intent, but it's just the methodology. It's basically saying that you're guilty until you're proven innocent. And the ex parte not having representation, as, again, is a constitutional right, just having the ability to face your accuser, you don't get that. I understand these situations that they're used in as a difficult situation, but I just don't think it's a path we want to go down to. I feel like we're treading too, I feel like it's a fine sheet of ice we're kind of trying to walk across here. And I think the cold water underneath is something we don't want to go into. I think there's too much potential for abuse. I think this could be politicized. And I really it just doesn't feel who we are as Americans. It doesn't, I understand the intention, but I think there's got to be a different way than this. It just does not feel right to me. Situation with this that comes to mind, and I'm trying to be respectful in my language here, but, if there's a 300-pound man or dating a 95-pound woman, and somebody calls and basically, and this man's being abusive, and they get a restraining order or whatever, there's not much saying that 300-pound man couldn't red flag this 95-pound woman because she knows she's got a gun. And that night, after the police come and take her gun, she comes in, he's waiting there for her, and, we probably know what the outcome would be there. Overwhelmed at a 3-to-1 body weight ratio and physically stronger.
Thank you. That's your time.
Okay, thank you.
The chair recognizes Holly Stevens.
Chair Roy, members of the committee, thank you for the opportunity to testify today. My name is Holly Stevens, and I am the Director of Public Policy for NAMI New Hampshire, the National Alliance on Mental Illness. NAMI is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide through support, education, and advocacy. On behalf of NAMI New Hampshire, I'm here today to speak in favor of House Bill 106 relative to extreme risk protection orders. The United States Surgeon General has identified that suicide is a major public health issue in the United States and one that is largely preventable. However, we have done little as a state or a society to prevent suicide. The impact of even a single death is profound and ripples into our family, friends, schools, workplaces, first responders, and beyond. It is important to note that 90% of all people who survive a suicide attempt do not go on to die by suicide. Unlike almost every other means of suicide, Use of a firearm in a suicide attempt is almost always lethal and leaves little opportunity for intervention. While people may contemplate suicide for a long period of time, once they make the decision to end their life, the window of time before they make an attempt is often very small. Toward that end, temporarily restricting access to lethal means, in this case firearms, is one tool that can help reduce the public health crisis of suicide. As indicated in the accompanying chart that I provided you, in New Hampshire, suicide is the second leading cause of death of people ages 15 to 35. The third leading cause of death, I'll wrap up in 1 second, sir, I apologize. Let me just wrap up by saying that, simply put, you've got the chart, you can look at it. Temporarily restricting firearms when individuals pose a significant risk to themselves or others is one tool that we can use to reduce suicide in New Hampshire. Thank you very much.
And thank you for your testimony. The committee will read your submitted testimony as well. The chair calls John Hink, MD.
Hello again. I'm John Hink, representing the New Hampshire Psychiatric Society in support of HB 106. The Psychiatric Society in New Hampshire is a branch of the American Psychiatric Association, the APA. The APA recognizes the critical public health need for action to promote safe communities and reduce deaths and injuries due to firearm-related violence. Many deaths and injuries from gun violence can be prevented through national and state legislation and regulations. The APA views the problem of firearm-related deaths and injuries as a public health issue and supports interventions that reduce the risk of such harm. The APA supports restricting access to firearms for persons whose conduct indicates they are a risk to themselves or others. Extreme risk protection order laws in other states have been shown to reduce suicide rates. These types of laws exist in 19 states and the District of Columbia. They allow for family or police to petition a court to ask for temporary removal of guns from people who they fear may be at risk of harming themselves or others. In Connecticut, an extreme risk protection order law was passed and was shown to prevent suicides. Research by Swanson regarding the Connecticut law showed that for every 10 to 20 guns removed, one suicide death was prevented. Over half of gun-related deaths in the United States are deaths by suicide. And legislation such as HB 106 may help reduce those deaths. Another study by Kivisto and Phelan in 2018 showed that risk-based firearm seizure laws in Connecticut and Indiana were associated with reduced firearm suicide rates. Of particular concern, gun violence is now the leading cause of death in children in the United States. For the first time in 2020, more children died from gunfire than motor vehicle accidents, with 3,597 lives lost. 30% of child gun deaths were due to suicide.
Thank you. That's your time, Doctor.
Could I give you my written testimony?
Absolutely. We encourage it.
And the study?
Yes, please. And if it's one copy, we'll have copies made and distributed to the committee. At this point, the chair recognizes Elliot Axelman. Again, for anyone who was not in the room when the hearing started, testimony is limited to 2 minutes at this point, please.
Hello, my name is Elliot. I go by Alu Axelman. I live in Hooksett with my wife and my son. I'm speaking in opposition to House Bill 106, the ERPO red flag laws. Plain and simple, red flag laws violate due process on its face. We all learned in first or second grade in civics that we're presumed innocent in this great United States until proven guilty beyond a shadow of a doubt with a jury and a judge and a whole courtroom. Red flag laws take what any person could exhibit red flags if someone mentions joke or they're angry or they seem upset or anything. And it punishes them by taking away a natural right as protected by the Second Amendment and Article 2A, I believe, of the New Hampshire Constitution. It punishes them with hearsay evidence, ex parte hearing, without their constitutional natural right to face their accuser, without them being present, without them knowing. And it punishes them, forces them after the fact to pay for a lawyer, which you may know costs hundreds of thousands or millions of dollars, which I don't have that kind of money on me. And then they can go to court and try to reverse a judgment. And if you've gone to court to try to reverse a judgment, you know it's pretty difficult. It would cost hundreds of thousands of dollars in lawyers' fees. So it's flipped. You're presumed guilty and punished until you prove your innocence. In the country I thought I grew up in, you're presumed innocent until someone proves you're guilty. It also violates the Second Amendment, which says shall not be infringed. And you'll notice some amendments actually have some exceptions, like the Fourth and Fifth Amendments, but upon probable cause, but upon, a search, specific search. The Second Amendment has no such exceptions. It says shall not be infringed. The founders could have put exceptions in there, but they didn't for anything that could be considered a red flag. So for anything that could be, they didn't put exceptions for potentially red flag behavior or speech. Speaking of speech, red flag laws may actually violate the First Amendment too. There have been some cases that went into federal courts, I think the Supreme Court, of speech that someone made that was posting song lyrics that were pretty intense and passionate, and he was red flagged for song lyrics. I don't think it was even Eminem, but I think it was a little less intense than that. But if you post any song like that, they could be red flagged because he says some pretty intense, ridiculous stuff.
That's your time, sir.
Yep. Thank you very much. I'll try to submit testimony to the committee.
Please do. I appreciate it. Thank you. The chair recognizes Kimberly Moran.
Minutes. You're so evil. No, I'm going to cut stuff out and try to be quick about this. This is the
We
same
would be here
egregious,
till midnight.
but hey, watch it. This is the same egregious and draconian legislation that New York City billionaire Michael Bloomberg spent thousands of dollars pushing a few years ago. So I'll remind you of why this legislation is so bad, aside from the fact that it's completely discriminatory against a subset of Granite Staters. Pretty much anyone and their brother can make an accusation against an unknowing law-abiding gun owner, your ex-mother-in-law who hates that you left her abusive son, a former psychopathic roommate who is still angry you moved out even if it was 2 years ago, a step-cousin of your stepson of your husband from a second marriage. You get the drift. And of course, the police can file a petition on anyone at any time. Ironic coming from the same people who support that defund the police movement. The bar is set so low for evidence that pretty much anything goes. All the petitioner has to do is convince a judge that they believe the accused is thinking about harming themselves or others sometime in the future. In other words, the petitioner has a crystal ball and can see into the future, and the courts and law enforcement will act as thought police. The accused could have written or said something out of anger a couple of years ago. That's considered evidence. The rules for evidence are not the same as in a criminal case. Who are the accused? Law-abiding gun owners who have committed no crime. I'm going to repeat that. The accused are law-abiding gun owners who have committed no crime. Once a petition has been granted, surprise, the thought police are at your door confiscating your firearms, and you have no idea why. Someone already talked about the thousands that the accused would have to spend to get their rights back. Proponents of the red flag bill have talked about suicide. In all the states that have red flag laws in place, neither suicides or homicides were decreased. Red flag laws did absolutely nothing. There's another law we do have on the books in New Hampshire called involuntary admissions. This is specific to mental health, applies to every single Granite Stater. There's due process, and it's adjudicated by a court. And that actually provides and mandates mental health care, whether outpatient or inpatient. And as we already know, spoke about it earlier, you're adjudicated mentally to get mental health help, you're a prohibited person. HB 106 isn't about protection, it's about gun confiscation. Bill of Rights be damned. And you know, it's really, really kind of ironic. A New York State Supreme Court judge just ruled Michael Bloomberg's red flag law unconstitutional in the state of New York. Please vote inexpedient to legislate. The thought crimes in the book 1984 were fictional. They weren't meant to be a roadmap for real life, especially not in New Hampshire.
Thank you. have you submitted your testimony in writing? Yeah. Thank you. The chair calls J. Simkin.
I do have testimony, Mr. Chairman, and I have the pink card that I promised you. I will consider that you have given me the 2-minute warning without, of course, use of the starter pistol. HB 106 has 2 defects, and these defects are common to most red flag laws. First, a person who is the target of a red flag action needs to have their attorney's fees and costs paid from tax dollars at their chosen attorney's regular hourly rate. Defending one of these things is tens of thousands of dollars. Most folks can't write a check for that amount. Second, any red flag law has to have in it a right of private action to bring a prosecution for perjury against someone who misleads a court into granting a red flag order. Perjury is basically never prosecuted. But since a red flag order can cause tremendous financial and reputational damage to a person, there has to be sure recourse, so that a right of private action means the person who's wrongly targeted, falsely accused, hires an attorney who then is authorized by law to bring and prosecute a perjury charge. And again, that attorney has to be paid their normal hourly rate. Attorneys are not charities. Thank you, Mr. Chairman. I'll be happy to answer questions, and I think I'm within the 2-minute limit.
Thank you for your testimony.
Thank you.
The chair calls Joanne Brown.
Hello and thank you. I believe 106 is essentially good intentions gone wrong. A family, the definition could be an ex-spouse who no longer lives at the same address, which means women suffering from an abusive ex could be stripped of her main line of defense by her ex reporting her. Many people suffering mental health issues don't care about laws or penalties. This bill will arm abusers with another way to weaken their victims. Law enforcement, as defined in the bill, doesn't even have to be in their hometown. It could be from any city or town. I'd like to remind you, in 2021, the FBI highlighted moms speaking at school boards. It would have been very easy for the FBI to contact local police to target us. People lie. They lie all the time. I know. I was in a relationship with a pathological liar. And we've seen that on the testimony on the gun background checks. Criminals don't tell the truth. But the big problems of this bill is that it's based on predictions, not on actions. The other main problems are the court is not bound by any technical rules of evidence. And the temporary order does not require notice to the respondent or defendant. See section 159F4. What's worse is the temporary extreme risk protection order is an ex parte hearing, which means the defendant is not even included and cannot defend themselves. This is unconstitutional, plain and simple. Thank you.
Thank you for your testimony. Lena Nurk.
My name is Lana Nurk, and I represent Moms Demand Action for Gun Sense in America. I'm testifying in support of HB 106, the Extreme Risk Protection Order Bill. I support the Extreme Risk Protection Order Bill because it provides families a proven tool to reduce gun suicides and mass shootings. I will focus my comments on gun suicide because a shocking 89% of gun deaths in New Hampshire are suicides. Gun suicide in New Hampshire has increased 61% between 2011 and 2020, compared to a 12% increase nationwide. Many gun violence tragedies are preceded by red flags, warning signs that are often noticed by family members. Reducing a suicidal person's access to firearms by temporarily removing them from when that person is clearly in crisis could save their life. Data shows that having access to a firearm triples one's risk of death by suicide, and states that have passed this type of protective order or red flag law have seen decreases in firearm suicide rates. My personal experience working with families in New Hampshire in crisis reinforced my belief that families deserve access to every tool that can help prevent warning signs from escalating into tragedy. The ability to temporarily limit access to lethal firearms by individuals in crisis can help save lives. Thank you.
Thank you for your testimony. Representative Hall? Sure is.
It sounded like you said hall, as in we're in the hall.
I probably did pronounce it wrong. I'm sorry.
That's okay. Good afternoon, representatives. Thank you for sitting there. I know this is a long day. I have 4 documents I want to turn into you. One is a letter from the New Hampshire Firearms Coalition regarding all the bills. I would ask the clerk that a copy be placed in each bill folder that's listed on that letter. Instead of me speaking multiple times, I covered it all in one letter. There is a letter from former Representative Itza relative to this bill in particular. I would ask that you would add that to the file. Second is third is a Supreme Court decision that's worth reviewing. And fourth is the famous, that we've been talking about, New York Supreme Court decision that came out late December that has to do with the bill at hand. I would like to read a couple of pieces from that particular Supreme Court decision so everybody's on the same page. And I'm going to ask for an extra minute if I can from the committee, only because this keeps coming up. On August 30th, the petitioner filed with the court, I'm cutting out a few words, names and things, an application for a temporary extreme risk protection order. In his application, the petitioner alleged that his estranged girlfriend was a threat to herself, the petitioner, or another person. That was the grounds for this entire case. Okay? This is the exact same case former speakers have talked about that says, oh, this is about suicide. At the conclusion of this court case, 1 or 2 pages from the end, the judge or the Supreme Court writes, however, when viewed objectively, the law, which is their law, CPLR 63-A's goal of removing weapons from otherwise lawful possession of their owners without adequate constitutional safeguards cannot be condoned by this court. Therefore, temporary extreme risk protection orders are deemed unconstitutional by this court. Going on further, it cannot be stated clearly enough that the Second Amendment is not a second-class right, nor should it ever be treated as such. That is a recent Supreme Court decision on the heels of, New York Supreme Court decision on the heels of some of the Supreme Court decisions. All of these bills that we've heard today violate constitutional protections. All of these bills today, would, if they came out of committee, would run afoul of House Rule 45A, which commands us not to pass with a positive recommendation any bill that violates the Constitution. 2 years ago, this bill was sent to this committee. I know, I'm hurrying up. And it was a financial protection order at that time. That's how they were trying to get it through. At least they've been honest this year. They are intending to take our firearms.
Representative, we did actually grant you an extra 30 seconds in there, and we are going to have to.
Okay. This is a civil process, not a criminal process. If it was a criminal process, all the due protections that the courts are looking for would be in place. But this process, by its design, is intended to circumvent those civil protections. Thank you.
Thank you. Brian Barry?
with one of my favorite books right here. If you all could please, Brian Joseph Barry, Chester, New Hampshire. I own Next Level Firearms in Salem, New Hampshire. Article 15, rights of the accused, at your convenience, please. Innocent until proven guilty in our country. However, page 9, line 26, the respondent shall have the burden of proving by clear and convincing evidence that the respondent is no longer possesses a significant risk of causing bodily injury to himself or herself or others by having a firearm. There's no due process in this at all. You're taking personal property from people, taking it on the mere suspicion that somebody may be a danger to themselves. And I take this kind of personally because on the back of my business cards, I put the suicide hotline. Nowhere in this bill, and no one else in this hearing today has mentioned about the person who's in distress. Why aren't we going to deploy a specialist or a psychiatrist to go to the house? Hey, we understand that you're having a bad moment. You're thinking about hurting yourself. Can we talk to you? Can you come with us to a facility so we can talk? If the family is aware that there's a problem, why are they going to go and get a petition to take personal property away instead of going to seek help from professionals? Call the suicide hotline. Call a doctor. Call 911. Hey, I need someone down here to help the person who's in distress. We're more concerned with taking away the firearms than waiting a few days until we can get a hearing for the person who's in distress while we leave them with their car keys, alcohol, over-the-counter drugs, prescription drugs, rope, kitchen knives, chlorine, bleach, so on and so forth. If it's that serious, ladies and gentlemen, you really care about people that much, then don't worry about...
Thank you for your testimony. 2 minutes.
Thank you. Don't worry about the materials. Worry about the person, please. Thank you.
Representative Mannion?
Hi, I'm Tom Mannion. I represent Hillsborough 1 Pelham. I'm here to speak against HB 106. Everybody covered the due process component of this really well, and so I'm just going to cut through a good chunk of my testimony here. There's something that nobody covered. As an Iraq War veteran, I fortunately emerged mentally sound from my time over there. Not all of us did. While the VA offers free mental health care, there is a fear amongst veterans that if they seek help, their guns will be taken away. This is a very real fear amongst that community. The mere existence of red flag laws with language about potential harm to yourself, it's understandable why the vets feel this way. So instead of getting the help that they need, they'd rather tough it out. They'd rather grapple with their demons alone than have their firearms confiscated, and I completely understand. However, the deadly scenario the red flag law is attempting to prevent can become a reality instead. I ask the committee to ITL HB 106, and I'm willing to take any questions.
Thank you for your testimony.
Thank
you. Marie Cassidy? Not sure if it's Marie. Right.
My name is Marie Cassidy, and I live in Peterborough, New Hampshire, and I am a volunteer with Moms Demand Action for Gun Sense in America. I'm here to testify in favor of HB 106. The importance of this public safety issue is personal to me. I have lost 2 family members to gun suicide. Both young men, Edward Rogers and Fred Shields, were veterans dealing with PTSD. If a bill such as this one that would allow family members to request the removal of firearms had been in place, my family might still be whole. Gun suicide death rates in New Hampshire are more than 25% higher than the national rate. The Granite State ranks 26th in the country for gun suicide deaths. Suicide is the second leading cause of death for ages 10 to 44 in New Hampshire. On average, 1 person dies by suicide every 68 hours in our state. 9 out of 10 firearm suicide attempts end in death. Suicides account for the majority of gun deaths in our state, 89%. Data from states that have enacted ERPO laws suggest 1 life is saved for every 10 to 11 gun removals carried out under the law. Suicide is an impulsive act. Guns are a fast, deadly way to act on those impulses. People considering suicide often give some signs of their intentions. Passage of HB 106 would allow the family members and loved ones who see these intentions to act, to have weapons removed, and to help ensure that those they love and those around them are kept safe and whole. Thank you.
Thank you, Ms. Cassidy. I speak for all of our criminal justice members when I offer you condolences for your loss. Brian Blackton.
I ask to ITL this bill, please. This is merely a red flag gun seizure bill. It is discriminatory to firearms only and not to other possible dangerous weapons such as motor vehicles, hammers, knives, baseball bats, poisons, alcohol bottles, and any other weapon. Like if you look on WMUR today, the woman who used her exercise rope to kill her 3 children. But we don't see that in the bill. This bill is also rife for abuse by a spurned spouse, significant other, or a police officer you may have had an issue with. It is not difficult to get on the wrong side if you file complaints against them, as we know they are not above abusing authority. While it may be a minority, it only takes one. This is another punitive proposal to a firearm owner, as they must pay storage for their liberties stripped from them, and the respondent must prove his or her innocence, which flies in the face of constitutional protections. It is also less than believable that someone will be prosecuted under 159F11, as we see domestic violence cases based on untruths fail and no charges are ever brought. I know this as a fact because I represented a man last year at Concord District Court. He was found not guilty of domestic violence, and she was proven to have committed perjury and was never charged. Further, charge equality is skewed in this bill from felony possession to misdemeanor attempt for application lies, when it's a federal felony for lying on the same 4473 application form. This bill is flawed. Thank you.
Thank you for your testimony. Representative Newman?
Yes, thank you. I'm Sue Newman. I'm from Hillsborough 4, Nashua's Ward 2, and I support this legislation. Unfortunately, everything I've put down, most of it has all been said. And especially, I didn't get your name, but not the most recent mom, but the one before her, she really, I was scratching out things along the way. She covered just about everything. However, I will comment that I know no amount of legislation can mandate or require good, rational, safe behavior or for someone to make good choices. We just can't legislate good behavior. But I do believe that this extreme risk bill does provide a way, a mechanism to intervene in situations before warning signs and exhibited disturbing behaviors become tragedies. I'm going to roll back just a little bit. I think 2018, the Parkland, Florida school shooting, and not too long after that awful tragic occurrence happened, Florida did pass red flag laws, and They did it primarily because the shooter at that school had been, he was made noticed to police and other officials several times before that, and I think they felt we could have done something. True story. Several years ago, I was having a casual conversation with a United States Senator's staff person. We were talking about background checks, who could qualify to get a firearm, who wasn't allowed to get a firearm, and so forth. And all of a sudden it came, okay, but what do you do about the person, maybe your brother, they've lost their job, the wife took off, the mortgage is late, and the dog just got run over by a car, and there's a firearm in the house. What do you do? And there was silence. She had nothing more to say. I had nothing more to say. So if there can be something in the form of an intervention that is out there, it's a tool. I hope it could be used. As for comments made by several people as to what's constitutional or not, I'm aware of the court case that was cited, but I'm also aware that as I came early this morning, I hadn't seen any news crawler that 19 states that have red flag laws have repealed all their laws because of any court case yet. So maybe some fact checking would be helpful so everybody knows what is actually fact, what's constitutional, and whatever. Thank you very much. I would support OTP. Thank you.
Thank you, Representative. Bill Rogers?
Thank you again. Something that hasn't been touched on, but I thought of, is let's think of a law enforcement response. Potentially we have someone who's in a psychotic break or in crisis, and someone has just turned them in that they want their guns taken away. You think the law enforcement agency is going to go knocking on the door politely? Think about the response that they have to make. And now you're putting law enforcement potentially in harm's way over this as well, only to find out it's an ex-husband who's pissed off. We all know ex-husbands don't lie. So the potential for abuse, the law enforcement, why put them at jeopardy for someone who wants to kill himself? Why? Why, instead of one person dead, now you got 3? It makes no sense. As well as innocent until proven guilty, not guilty until proven innocent. Thank you.
Thank you for your testimony. John Bunker? Just as a friendly reminder, we are limiting testimony to 2 minutes. Everybody's doing a fantastic job. Thank you.
Good afternoon. I'm John Bunker. I live in Stratham, New Hampshire. I strongly support this bill, and I support it for 2 reasons. It is rational, it is reasonable, and it's common sense. 19 other states have also thought the same. I have a handout for you, and this is from the Johns Hopkins Center for Gun Violence and Solutions. It's what we refer to in the academic world as a literature review of public policy. And this particular one has 17 references that are peer-reviewed on this particular law. I would encourage you, as you deliberate the testimony you've heard, to refer to these citations to get an appreciation for the research that's going into this field. And I'll end with a quote from a researcher at Johns Hopkins. When I look at the landscape of gun violence prevention policy in this country, in the possibilities and the progress, I'm very hopeful. By bringing science to policy, we're getting good new laws that are making a difference in our communities every day. And this is a prime example. Thank you.
Andrew Scholler.
I just had a quick note here. So House Bill 106. So looking at historical American history, the government was formed to serve the people. And if the government wasn't serving the people, it was the duty of the government to handle the situation, to remove those not serving the people, which means that there's a risk of the government official losing their job because of the civilians. Well, this bill is trying to flip that on its side. The government can just intervene into your life and take away your rights because of somebody said so. And that somebody said so could be neighbor, friend, former friend, lover, or another government official. But because you don't know, you have no recourse. It could allow for government to just intervene in your life, and there's nothing you can do about it. And therefore, I suggest ITL 106. Thank you.
Thank you for your testimony. Dr. Hannon?
Okay, start the timer. Joe Hannon from Gun Owners of New Hampshire. I'll try to be brief. I'm going to be quick, but that's not to be disrespectful to the topic. It's a serious topic. So I'm going to run through this. No adequate due process protections are less reliable. There's no reason for a person to participate in their to be required to be at their hearing, then they can have their firearms removed and their rights lost. But there is a hearing required to regain their property after the protection order has ended, which does not make sense. There's an potential increased risk to innocence and the respondent and possibly law enforcement officers by increasing the chance of a violent encounter. We've heard of cases where just mental health checks where someone goes in because someone was threatening harm to themselves or others. And there's a recent case in New Hampshire where a young man died. I don't believe there's a firearm involved on his part, but they don't show up to, they're there to protect their safety. And sometimes people die when that happens. It could be the officers, it could be the respondent. This is reminiscent of the 2002 movie Minority Report. It's about pre-crime. We don't have anything that in our laws anywhere that you lose your rights before you've committed any crime or violation, or even a threat. You don't have to threaten actual violence or commit a crime. You can still be convicted in a sense. They don't call it a conviction, obviously, but you are losing a constitutionally guaranteed right. Social media and other things can be used against someone. They're used in other states against people to even attain their rights in the first place. And it was, as you heard from another veteran and some other people spoke about the less likelihood of seeking psychiatric help. People will be less likely to talk about the problems they have if they're worried about losing their rights, possibly. And lastly, rumor has it that Abel and his parents were concerned about Cain's mental health, so they had his spears removed. Well, we all know what happened after that. So removing one thing that is potentially dangerous is not necessarily an answer to preventing a violent crime or some harm to someone or another. If someone commits a crime, obviously they need to be dealt with and deal with the consequences. But pre-crime is something that none of us should be addressing in this chamber or in any government. Thank you.
Thank you for your testimony. And the chair calls Jonathan Weinberg.
Thank you for the opportunity for letting me sneak in last moment. My name is Jonathan Weinberg. I'm a member of the Concord School Board. However, I'm here in my capacity as an individual and not on behalf of the board. I guess, does wearing a seatbelt prevent death? No. Does wearing a helmet absolutely prevent brain injury? No. Does holding a knife down while walking in a kitchen absolutely ensure that no one is hurt by it? No. Yet we don't wear a seatbelt or a helmet or practice safe knife handling because we know the outcome. We know they are designed to minimize the risk of a dangerous outcome. No bill, no law will completely change the reality that too many people are dying at the hands of gun violence. But if you believe that, like the other safeguards, the helmets, the seatbelts, and that this bill is proactively trying to address a real challenge and save lives, then I urge you to vote ought to pass on HB 106. Thank you.
Thank you for your testimony. And the chair recognizes Dr. Michael Layer.
That's it. Thank you. I will be very fast with my testimony. For those of you who watched the State of the Union the other night, Joe Biden talked about ending no-knock warrants. And yet here we are listening to testimony advocating no-knock warrants. I'm going to go through a brief history, and in less than 2 minutes, I have one request for this committee. This country, we've heard so much about systemic racism in this country. Nowhere is it more apparent, nowhere is systemic racism more apparent than in gun control. You can go back and look at the Dred Scott case, specifically the words of Chief Justice Taney, which I will not repeat. You can look at the words of Senator Shields from Tennessee. If you think the word common sense gun control, you should be proud of using it today in 2023, go look at his words. It is right out of Jim Crow. It is absolutely horrible. Unfortunately, the United States exported gun control to Germany, to Weimar, Germany, very progressive state, incredibly progressive state. Thank you, President Wilson. Following Weimar, Germany, we got the National Socialists of Germany, who very, very effectively used a red flag law to disarm the undesirables, which went far beyond the Jews. It included gays, the undesirables, the not good Nazis of society. Over the past 10 years, unfortunately, the gun control policies that have been advanced in New Hampshire have not differentiated from what was used in Nazi Germany at all, which is truly, truly a tragedy. This brings me to my request. In 2012, Representative Steve Valencourt was censured by this body for saying Sieg Heil to then Speaker of the House. I thought it was the right thing to do because I think Nazis, all socialists, are absolutely abhorrent. That's still on his record. He's unfortunately passed away. If you're going to advance this, if you're going to spread Jim Crow and you're going to advance the policies of Nazi Germany, please vindicate the late Representative and Honorable Steve Valencourt and remove the censure from him for uttering those words in this hall. Thank you.
Thank you for your testimony. Chair recognizes Kang Lee from Keene.
Oh, hi, ladies and gentlemen. Thank you again for your time. I present myself to support and defend the Constitution, which this legislative body is sworn to uphold. But let me disclose an uncomfortable and hidden truth. The legislature has no power of rulemaking or legislation that would impair our fundamental rights. In fact, this body has never made any statute directly prohibiting the right of the people to keep and bear arms. Take note of the following United States Supreme Court decision in Miranda versus Arizona 1966, stating, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Next, we have the newest decision from 2022, wherein, quoting DC versus Heller, the Bruin Court stated that the Second Amendment is the very product of an interest balancing by the people, and surely it elevates above all other interests the right of law-abiding, responsible citizens to use arms for defense. That said, in 1943, the Supreme Court also wrote that the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be guided by the courts. One's fundamental right may not be submitted to a vote. They depend on the outcome of no elections. Again, you can confirm this for yourself, as no statute has ever been written by this body that directed its subject matter jurisdiction against the right of the people to keep and bear arms. That is, the words to keep and bear arms are totally absent from the so-called legislation or gun laws.
That's your time, sir.
Okay, thank you very much.
Thank you. We appreciate your testimony. Thank the court, the court. We're talking about court so much. The chair recognizes Vic Topo, or Topo.
Good afternoon, Chairman Roy and members of the House Criminal Justice and Public Safety Committee. My name is Vic Topo. I'm CEO of the Center for Life Management in Derry, and I am here representing the New Hampshire Community Behavioral Health Association and the state's 10 community mental health centers to express our strong support for House Bill 106. I am also here as a member of the New Hampshire Suicide Prevention Council. Part of the council's charge per RSA 126R is to oversee the implementation of the New Hampshire Suicide Prevention Plan and to serve as a proponent for suicide prevention in New Hampshire. According to the New Hampshire Child Fatality Review Report issued last week, suicide was the cause of death for over 23% of our residents, age 1 to 21. Between 2017 and 2021, and 38% of those suicides were gun deaths. Finding reasonable and practical ways to help prevent those deaths is part of my mission personally and professionally. And as a member of the Suicide Prevention Council, House Bill 106 is one such solution. We all know that mental health issues, especially among children and teens, spiked in the past 3 years following the shutdowns and isolation of the COVID-19 pandemic. We also know that the state has a severe workforce shortage in the healthcare arena, and that extends to the community mental health system. We are struggling to ensure that everyone in all our communities gets the care they need when they need it. As you have already heard from others, 19 states in the District of Columbia now have so-called red flag laws. And in New England, all our neighboring states, except for Maine, have acted these laws. Maine passed a yellow flag law in 2019, which was a compromise with the sportsmen's groups and which is still being evaluated for its effectiveness.
That's your time.
Thank you.
If you want, you can submit written testimony if you have more.
Thank you.
Thank you. And the chair recognizes Penny Dean.
Thank you for your perseverance on a long day. I'm Penny Dean from Concord, New Hampshire, and I'm sad to say that this 12-page bill, 106 FN of 12 pages needs to be ITL'd. Because of the time limit, I won't be able to point out probably 5% of the flaws. Closer, sorry. Because of the time limit, I won't be able to point out not even 5% of the flaws, and they're serious flaws. When we talk about the New York case, yes, it was found unconstitutional, but how much blood, sweat, tears, and money did the plaintiffs have to do that? You guys are supposed to be our first line of defense. You're not supposed to pass legislation and say, let them fight it out in the courts. That's not right. People like me can do that, but what about the average person that's just going to destroy their life and destroy their finances? Start with the very beginning. This bill deserves a black ribbon, not a blue ribbon, a black ribbon. If you look at page 2, line 6, 7, and 8, that is the first section which talks about proceedings under this chapter may be transferred to another court upon the motion of any party or the court as the interest of justice requires. There's 2 famous United States Supreme Court cases, International Shoe and Kokomo Tire, and they talk about jurisdiction. So what if I'm in Concord, New Hampshire, and what if someone files one against me and they say, we want it to be heard in Coos County because it's more convenient for us? Should I be hauled into Coos County? I don't ever go to Coos County. But yet that's what's going to happen here. What's going to cost me to litigate and travel up there? That's huge. Next, what other states do? I don't give a fig about. Other states don't have seatbelt laws. Do have them and we don't. Guess what? We're different. Helmet laws. I don't care what the other states have. Not my, because they plan to be sillies? No. But the bottom line is, there's two things you have to know. I don't want to use the word never, but I don't recall ever in 22 plus years of practice seeing anything but an ex parte order coming down. Number one, ex parte, which means one side gets to go and tell the judge their side for a temporary order. Now, once these orders, these are one-year orders, so everyone says, oh, these are temporary. If it's you, 1 year is not temporary, I can tell you that. And after the 1 year, judges automatically rubber stamp another year and another year and another year. The other thing is, I have never once seen a person who committed perjury prosecuted for this. Prosecutors have absolute prosecutorial discretion. And I've heard everyone say to me, I can't prosecute a victim. And I think you need to look at page 3, which is another highlights of bad things. Lines 7 and 8, they appeal to the Superior Court on errors of law. Again, whoever wrote this looked like they took a bunch of bad bills and threw them together and don't understand how the mechanics work. And I'm only pointing out the big things because of time. The other thing
that is your time.
Can I say one sentence?
Just one sentence.
Okay. If you look at lines 21 and lines 28 on line 3, you were told it was a certain standard. Right here, you say preponderance of the evidence. So don't believe what people are telling you. Read the bill. And it's a bad, bad, bad bill.
Thank you for your testimony. With that, anyone else have a card? Going once, going twice, closed. House Bill 106 is closed, and now I open the public hearing on House Bill 351. And I recognize Representative David Muse to introduce his bill. As the sponsor, where is he? There he is. As the sponsor, Representative Muse, you are not limited to the 2 minutes, but you are the only one.
Thank you. There are few tragedies greater than the negligent death or injury of a child or another innocent person as a result of a firearm being left unattended. While HB 351 won't end all of these tragedies, it will reduce the risk of them happening. As many of you will recall, in 2019, an 11-year-old child from Alton was arrested for shooting and killing his parents with an unsecured firearm. Last month in Virginia, a 6-year-old boy brought his mother's unsecured and loaded gun to school and shot his teacher. Over the years, we've also read tragic news stories in New Hampshire and elsewhere about shootings involving children playing with unsecured firearms and the wounding or killing of those children, their siblings, and their playmates. In 2015, 13 million U.S. households with children contained firearms. In 2019, a study in the medical journal Pediatrics said incidents involving guns are estimated to be the third leading cause of injury-related death among children aged 17 and under, the third largest cause of death. The Centers for Disease Control and Prevention reports that every day in America, 8 children and teens are injured or killed in shootings involving an improperly stored or misused gun found in the home. 2 more are injured or killed attempting suicide with a firearm. An equally alarming 38% of firearm-related deaths in the age 19 and under group are suicides. Incidents involving suicide or firearms injuries involving children are often kept confidential by law enforcement. The Department of Safety has told me that it doesn't collect or report this data in a centralized way. Depending on jurisdiction, incidents may be handled by state police, county sheriffs, or local police. This makes it extremely difficult to examine New Hampshire incidents from a data-driven perspective. It's also hard to get anecdotal information because newspapers and media outlets are very protective of the privacy of minors and their parents. Many times if we hear of an incident at all, we tend to hear of it as an unreported shooting where a child might be involved, and that's the last we hear of it. The bottom line is unsecured firearms pose significant safety risks, especially to children. The American Journal of the Journal of the American Medical Association reported that 70% of parents surveyed reported their children had no independent access to firearms in their household, but over a third of the children actually living in those households reported being able to access a firearm in less than 5 minutes. So what this bill does is it requires that firearms sold or transferred commercially or privately be accompanied by a locking safety device that's specifically designed or manufactured for the purpose of allowing the owner to temporarily disable or safely store the firearm. The bill also gives the buyer the option of complying with the law by bringing their own locking safety device when they take ownership of the firearm. The bill also strengthens New Hampshire's existing firearm storage negligence law, that's RSA 650C1, by doing several things. It expands the scope of the law to cover unattended firearms that are unloaded, but where unsecured ammunition is also available to the child. The current law only addresses loaded weapons. It broadens the circumstances that constitute an offense. Currently, a gun owner who allows a child to gain access to an unsecured weapon is only charged if the child uses the gun in a reckless manner, uses it in the commission of a crime, or negligently or recklessly discharges it. Under HB 351, a child displaying a firearm to others would also constitute an offense. Additionally, an offense would take place if the child brings the weapon onto the grounds of any facility, public or private, that's accessible to members of the public where other people are present. The bottom line is we have a plague of kids bringing unsecured firearms into situations where they're not only endangering themselves, they're endangering other children, they're endangering adults, and they're endangering the public. And there's no reason for this. This is not an issue of taking anybody's guns away. This is an issue of, frankly, helping more people understand what a responsibility it is to own a firearm, especially if you have a child. I think the bill is also very clear about exceptions, which you can read yourself in the bill. It doesn't restrict access to firearms. It doesn't penalize any responsible law-abiding gun owners. Negligence is actually already a crime in our state. What it would do is offer additional protection for New Hampshire children. And something to think about is it would save gun owners from the horror and the liability that is a risk whenever an unsecured firearm is left around a child. In a state where guns are part of our culture, responsibility in protecting our kids from the very real danger that unsecured firearms can present really needs to also be part of our culture and a stronger part of our culture. And hopefully HB 351 will make it a stronger part of New Hampshire law as well. Please give HB 351 an ought to pass recommendation. Thank you.
Thank you for your testimony. The chair calls James Gaffney.
Thanks for the opportunity to testify. This bill, like previous bills, attempts to reclassify what a private sale is. This is well established. It's a theme or a problem that exists in several bills today. This bill isn't going to accomplish anything. It's a cable lock. Why are we we're painting with a broad brush. We're just applying additional requirements to a problem that doesn't currently exist. Nobody's brought forth examples where cable lock would solve a problem in this state. I live in other states where they've had these laws and it accomplishes nothing. So thank you very much. I urge you to vote this ITL.
Thank you for your testimony. And the chair calls Kimberly Moran.
I just want to note that the CDC stats include children up to the age of 19 years old. The majority of children that are killed with firearms are gangbangers. It would be really, really actually useful if gun controllers were concerned with getting illegal guns off the street, because there would be less dead children according to ages 19 and under. Also, once again, this is another out-of-state gun control organization that seeks to change existing laws in New Hampshire. These out-of-state organizations attempt to solve problems that don't exist in one of the safest states in the country. Please vote inexpedient to legislate on HB 351. There's no need to change the law. There's especially no need to change the law to satisfy gun control organizations located in states that aren't nearly as safe as New Hampshire. Thank you.
Thank you for your testimony. The chair recognizes William Rogers.
Thank you again. I grew up in a household where the shotgun was stored in the corner. We knew where it was. Nobody ever touched it. We knew better. We just knew better. We were all familiar with firearms. Nobody ever touched it until we were 14 and able to take an NRA hunting course. Then, but it still was there. Again, the people's lack of understanding how firearm purchases work is every gun I've ever bought probably in the last 20 years comes with a lock. It comes with a lock. We don't need to legislate. You cannot legislate common sense. You cannot legislate good behavior. All you can do is make good citizens violators. I keep guns in my house. I have grandchildren. I have children. When they come over, believe me, there's no way they can get it. But I don't need a law to tell me to do that because I have half a brain. Thank you very much.
Thank you for your testimony. The chair calls Dr. Leonard Korn.
Thank you for hearing my testimony again on this bill. Let me start with just a couple of comments first, since I've sat here and listened to all the testimony today. First of all, in terms of mental health, people say, do something about mental health. I'm a psychiatrist. I'm interested in doing something about mental health. But when we present possible laws to do something about mental health, you say, no, don't want to do that. So I'm not sure really how we can do something about mental health if when we present reasonable ideas about mental health, the answer seems to always be no. And let me talk about something about the Constitution. Nothing in New Hampshire law says anything about gun law, about ghost guns. As far as I know, nothing about New Hampshire law says anything about turning in the names of people who are committed to the state hospital to the National Data Bank. So it's not a constitutional issue. It's just a reasonable issue that we're interested in. And these have to do with mental health. Now, in terms of negligent storage of firearms, it's reasonable for people who have a license to drive a car for them to do it reasonably. It's reasonable for people who have guns to store them reasonably, especially if they have children in the house. Now, it used to be that the most incidents of death for kids were car accidents. But that's no longer, because we have a lot of good laws to do something about child safety in cars and safety in cars in general.
That's your time, Doctor.
So please, let's do something about negligent storage of firearms. Thank you very much.
Thank you for your testimony. The chair calls Timothy Wolf.
Thank you. I have more comments just on my testimony on this. One is that I can't think of any newer manufactured firearm that you would purchase that doesn't already come with a cable lock. So I think a lot of this is already happening anyhow. My observation with that is you can pass a law on it. You can pass all the laws you want, but somebody has to use that cable lock. So if you get a cable lock, somebody doesn't use it, you still don't have the means of making the firearm inoperable to, essentially, I'm assuming this is, primarily quite a bit aimed at preventing children from getting a hold of these firearms. The other thing that comes to mind is there is already a law, it's a federal law through the ATF and the problem with the gun dealers, who can probably speak better of it to me than I can. I don't know it intimately, but you are federally, under federal law, already responsible. I think it's called, I think I wrote it down here, to the best of my memory. It's like the Child Safety, I don't know if it's Protection Act or something like that, but quite often you'll get a flyer if you buy a firearm and they'll give it to you. And so there is federal regulation that makes you accountable if somebody who underage gets a hold of your gun. So again, it's a law. Are we doing anything about it? Are we prosecuting anybody because a child get harmed or damaged? Are we going to pass another law that we're not going to prosecute somebody for if something bad happens? So I would say we may already have the tools to do what this is intended. I don't know if we need another law to achieve what is wanted here. And lastly, I'll just state personally, I think education is important here. Education of parents, adults, and children. How that happens, there's a lot of ways to do it. I know personally, my kindergarten, my parents' kids' kindergarten teacher came over to me and said, "Boy, you boys are so well behaved. All the other kids are running around making things into guns and shooting each other with them. Your kids don't do that." And, I taught them, my youngest son, I taught him at age 5 how to shoot under my supervision. My next son, I actually taught him at 6 because he thought he knew more than I did at 5. So we waited and said, this is going to happen another day when he was 6. And they have always been very respectful. I feel safer with them than I do just about anybody I know who keeps and bears a firearm. And so I will just leave you with that. But when
Thank you.
I know
That's your
that's not
time.
relevant. Thank you.
Thank you. The chair calls Representative Granger.
Thank you, Mr. Chair and members of the committee. I'd like to share a sad story about a horrific act of violence where a safe storage techniques led to a fatality. I'd like to share the story of the fate of Mrs. Orpington. On a gorgeous autumn night in New Hampshire, a loud noise was heard outside a rural New Hampshire home while a family was sleeping. Sensing danger, the man of the house looked outside to see Mrs. Orpington's home under invasion. Thinking quickly, the man ran to his office and started unlocking his rifle, a Ruger 1022. It was dark and he had to punch in the code multiple times for the mechanism to work correctly. But finally he did open the safe, and once he had it, he found the rifle unloaded. He searched around for the magazine and found it on the floor. He loaded the rifle and headed outside. Nothing could prepare him for the carnage that awaited him. The once beautiful blonde and buff hen, affectionately called Mrs. Orpington, lay dead on the ground, surrounded by feathers. The culprit was a skunk who had already long gone. She was only 1 year old and had the potential to lay hundreds of eggs before retirement, but due to the inaccessibility of a tool capable of saving her life, she never laid those eggs. In the current economy, those extras represented a $500 retail value. This bill would enable more tragic stories like this to occur. For centuries, those who had poultry and livestock stored their rifles above the door to their home. This allowed them and their family the ability to handle critters that would attack their homesteads without having to jump through hoops. This bill would endanger farm animals by taking away the protections of the farmers. Foxes do their damage quick, raccoons as well. Chickens, even well-guarded flock with a rooster present, are always at risk from critters who attack swiftly and often for fun. Seconds count. This bill also puts unreasonable age restrictions in. Annie Oakley was 8 when she began to hunt to feed her family. She was winning competitions at 15. In New Hampshire, if this bill is signed, her widow mother would be guilty of a misdemeanor. I ask you to please vote ITL on this bill. Thank you.
Thank you for your testimony. Chair calls Andrew Schuler.
Thank you for letting me testify. One of the issues I have with the quick analysis here, where it says there has to be locking and safety device accompanying all private and commercial firearms. This bill requires infringing on the right to privacy as outlined in the Bill of Rights. And therefore, I suggest we ITL this bill. Thank you.
Thank you for your testimony. Chair calls Dr. Hannan.
Good early evening to everyone. Joe Hannon, Gun Owners, New Hampshire. We're in opposition to HB 351. There are several reasons, obviously. One, I mean you're requiring a citizen to purchase something commercially. So we've talked about commercial sales and all this stuff. I don't know of any laws that mandate you buy something. Well, there's one, but we won't get into that here. It's a federal thing. So as far besides health insurance, you have this. You're going to mandate that they buy a lock. I've never bought a firearm from a dealer that didn't have one available or didn't have a big bag or a bucket or a bin somewhere that said take one. I've rarely seen a gun show without them around or everywhere. Private sales, like you heard earlier, you can't really dictate what's happening at a private sale. You don't know if they have it. You'd think that people would have it. The other thing is you can't mandate having them locked up either. They did a study last year that talked about interviewed 55,000 firearms owners in states that had child access laws, and we are one of those states. We have child access laws currently, and states that didn't have them. And most people didn't even know the difference. If it didn't affect greatly whether they locked them or not. So as far as mandatory locking them, they're not even doing that when it's required by law sometimes, or even know what the law was. Real quick. This takes a violation and makes it a misdemeanor. We already have a lot of exceptions for safety for firearm storage. You heard hunter safety course. Parental permission is one thing. If you say I'm giving my child permission to have access, that can be an exception to the law currently. So what's going to happen? They're going to get in trouble for this, and they're going to say, the kid might have had permission. Now the parent's going to go to jail possibly, and they're going to say, well, I didn't give that kid permission. They're not going to lock up the kid, but now it's a bad position to put people in. And they added also, lastly, firearms is exhibited or displayed to others. That's not recklessly threatening. That's not using the commission of a misdemeanor or not negligently or recklessly discharging it. It's just showing it to someone. Now, I don't want to encourage that. I don't think it's a good idea. I think it's bad parenting. It's a bad kid in some senses if they don't know better. But just the mere exhibiting of something should not rise to the level of a crime for the parent. And what if the parent of the other child doesn't like guns in general? If I know that and this is a law, I'm not going to let those kids come to my house. Just they're locked up, they're safe, but I don't want to have the risk of them even making that accusation.
It's your time.
Yep, thank you. That's good. You get the idea.
Thank you for your testimony. Chair recognizes Linda Haskins.
Good afternoon, Linda Haskins, Rockingham 11, representing Exeter. Thank you for your forbearance and kind attention this afternoon. I'm a retired school counselor, and Dr. Horn has said it better than I. Gun rights advocates always talk about mental health. It's a problem of mental health. We are here today with the opportunity to do something. It's not everything, but it's something. And I think with all the bipartisan talk I hear in the hall, This is one bill that we could agree on. It's not about taking anybody's guns away. It's about preserving life. It's about giving us an opportunity to intervene when there are only very good reasons. And let's have some confidence in the judges in our court system to be able to distinguish when it is a critical need. It's not willy-nilly. They're not going to go along with a protective order. I am the proud daughter of a dad who spent my entire childhood in law enforcement. The only time I ever saw his gun was when he was in uniform. I have no idea where he kept it in the house. But this is not 1980. This is 2023. And we have to acknowledge there are many more guns, and parents are very busy, and even the most well-intentioned parent could neglect to put the gun safely where it belongs. We've got to do this for our kids. And as I say, this is an opportunity for us to have a bipartisan agreement to help save our kids. Thank you.
Thank you for your testimony. The chair calls J.E. Simkin. J.E. Simkin, going once, going twice. Chair calls Penny Dean.
I will ask that you ITL this bill, please. I will go through again the bad parts quickly. 351. We start at the beginning. I think this is a cute little backdoor trick. Nice try to get us to redefine again commercial sales of firearms and get it through the back door so that all firearms get checked through the system and personal sales are not allowed. Because if you look at the first lines in 1A, it's on page 1, 8, 9, and 10. Public sale or exchange, including but not limited to. And then when you look at the next page, which is page 2, lines 3, seller means a person offering a firearm for commercial sale, private sale, or barter. We're getting back to the fact that they want all guns to be checked through the system, that no private sales will be allowed. That's really what this is coming down to. And second, when someone says, oh, they can access the firearm in 5 minutes, that's about 4.5 minutes too late. In most instances, not quick enough. The next thing that we talk about is specifically on page 2, lines 29, 30, 31, 32. Okay, so without the supervision or permission of the child's parent. So if the child's parents are supervising, what does that mean? Does that mean that they're out at the pool watching? What does supervision mean? But when it comes to parent, I'm the step parent. Is that good enough? I'm the parent without custody. Is that good enough? Does it have to be written? Is that good enough? What if mom and father differ and they're divorced? Is that good enough? These type of things really become to matter. Next, you're looking about gross negligence. That necessarily has it on page 3, lines 4. We're going back to the fact that you're basically saying the kid can't defend themselves in the house. We've had 6-year-olds, 7-year-olds, 8-year-olds competent in firearms defend their family, defend their siblings, defend their mother, and save lives. So you're going to punish these people? That's just plain old crazy. But the other thing when we look at this, and we have to look at this as someone said we're
That's
going
your
to.
time.
Oh, one line?
One line.
We're going to trust our judges. They're unelected judges. You can't unelect them. They're appointed judges. That's a big deal.
Thank you for your testimony. Last try for J.E. Simkin. Have you returned to the room? At this point, I'm closing the public hearing on House Bill 351, and I'm opening the public hearing on House Bill 444. And I recognize Representative Muse to introduce his bill. Excuse me, that looks like what it
I
is.
showed up in person, and I gratefully thank Representative Muse for filling in for me. We have a long executive session in Judiciary, and I'm eager to get back to that. We've got an even more.
Representative Harrington will be introducing his bill.
What? And although he certainly would have been prepared, done a great job of introducing it, and probably would have been prepared to answer any questions. So I'm hoping this issue has come up before. Most recently in 2022, Representative Muse actually sponsored 1096, which was a very good bill that fell a little short. I think this one is similar. I think it's a little bit simpler. It creates fewer problems for the gun owners, because I know there's always the issue of keeping track of where your gun is welcome and where it isn't, where you can carry it, where you can't. And I think this makes it easier. It bans guns and other deadly weapons with 100 feet of the polling place. And I'm just using the commonly understood definition of polling place, which is well understood, appears in many other places in both state and federal law and rules too. And it's the place where the election activities are taking place. Polling places are very clearly marked. There's very specific requirements for how to mark them. In addition, there's signs marking the 100-foot radius around the entrance. Even if the signs are missing, I think most people, maybe not everyone, but most of us can reasonably have a pretty good idea of like how long a distance 100 feet is. And unless the turnout is extremely low or it's just not a very controversial issue at the election, there's going to be a few individuals holding political signs 101 feet from the entrance. And I'll say too here, I have enough confidence in our law enforcement, our judiciary here, that they're not going to be like swooping in and nabbing somebody who accidentally carries his gun, finds himself 99 feet from the entrance of the high school or wherever else, whatever place where the polls are taking place. And if you're worried about, running into bad guys, bears, whatever, while you're trying to vote, she takes solace in the fact that there's always law enforcement officers on duty at the polling place. Mine in Durham is a pretty large one. You usually have about at least 5 or 6 armed officers in the polling place, some even out in the parking lot, mostly directing traffic. But if there's an attack on the polling place, they would be our first line of defense. And actually, originally, when I put it in the LSR, I was originally planning just put in open carry, but I decided to go ahead and just make it all weapons, so simpler. As a practical matter, if you're concealing your weapon, they're not going to know you're carrying a concealed weapon anyway, so the issue is not going to come up. And I've got a specific carve out for unloaded weapons secured in motor vehicles, even if your parking place is less than 100 feet from the door, and also for law enforcement officers, not just those who are specifically at duty at the polling place, but also those who are, voting on their way to work and the way to back work and happen to be wearing the uniform of which the gun is an integral part. I know I have a neighbor who's a member, lives in Durham, but she's a member of a force in another town. I think it's Northampton. She showed up on the last election day with her Northampton Police Department uniform, including her service revolver, and I had no problem with that. And also the penalty is a Class A misdemeanor, which usually it could theoretically result in a year in jail, but once again, I have confidence in our criminal judiciary. They're not going around. I don't think they're going around prosecuting someone who somehow accidentally manages to carry the gun into the polling place. And in most cases, a good moderator would probably just tell them to lock it up in their car and go back and vote. So I urge the committee to ought to pass. I'm pretty eager to get back to my own executive session, but I suppose I have to open it up for any questions. Bear in mind, Representative Muse probably would have done a better job of testifying to me, but I guess he'll have to save his observations for the exec session unless you want to recognize him as a speaker, but thank you.
Thank you for your testimony.
Good, thank you.
Chair recognizes Honorable John Burke.
Thank you, Mr. Chairman and fine committee members. I do oppose this bill. I have fought this bill many times and luckily been successful at killing it each time, and let me tell you why. I open carry a lot. I like open carrying. Today I'm concealed carrying. But what I believe is I have the right to do either. So in Goffstown, when I go to Home Depot, Hannaford's, anywhere I go, I'm carrying my 9mm on my hip. Bartlett School is within 100 feet of the polling place, where we stand with our political signs. So that means I'm not going to be able to stand there. And also, this disenfranchises me from voting because I feel I have a right, a constitutional right, to bring my gun to the polling place to make sure I'm protected while I'm voting. And I just don't see why we need this. Up in Ware, when I was a state rep, and at some point I will return, when up in Ware, we're within 20 feet of the polling place. Here's the door. Here we are, right outside the door, saying hi to the voters as they come in. And most of us are carrying. So this isn't going to work. So I hope you ITL it, and please do the right thing to make sure that the people that decide to carry a gun, constitutionally, they have a right, they can still vote, or you're disenfranchising them. And I know how one party does not want to disenfranchise anybody. So I hope that you will do this. Thank you.
Thank you for your testimony. And the chair recognizes Kimberly Moran.
So while we're practicing our right to vote, this bill makes it so we aren't allowed to practice our fundamental human right to self-defense protected by the Second Amendment. Again, just like with the school zone bill, this bill creates a gun-free zone that enables criminals to easily prey on victims, especially women who choose to protect themselves and their children with a firearm. Once again, this is legislation looking to solve a problem that doesn't exist in New Hampshire. Please vote inexpedient to legislate on HB 444. All of these gun control bills we've heard today do nothing but make Granite Staters less safe. Thank you.
Thank you for your testimony. And the chair calls James Gaffney.
I'd urge you to vote this ITL. The sponsor didn't offer any problem that it's looking to solve. Do we have a problem with people carrying guns quietly, silently, not obviously when they go to vote? Again, solution in search of a problem, it creates a mess. Second Amendment, both, at the state level and the federal level, doesn't say except at a polling place. This is silly. I can't believe that somebody's suggesting we should suspend one constitutionally protected right in order to exercise another one. Please vote this ITL.
Thank you for your testimony, and the chair recognizes Timothy Wolf.
Now it's on. Red light. Okay. Again, this is just I oppose this bill. It's basically just another gun-free zone, and which I do not agree with. And again, I have to reiterate what some of these other folks have said. Why do we have a problem with this? I don't usually, if you want to legislate something like this, it's because you've had a problem. I don't think, haven't heard of any problems with this in New Hampshire. I don't really see it being necessary. I don't think we're having an issue. It seems kind of ridiculous to me that I can be 101 feet outside of a polling site with a firearm that has an effective range farther than that. But if I step inside that circle, it's a problem. Kind of silly, especially if I am intent on harming people, which I'm not. But if somebody is, I don't really think they care about this gun-free zone. I do feel what we're trying to achieve here is going to have the opposite effect. If anything, I think it would empower people who are intent on this sort of harm simply because they know nobody in there is armed. Nobody in that circle is armed. So I can be more effective and do more damage and harm because that's what I want to do. That said, it just doesn't make sense to me on a basic logical level. And I would just ask that you oppose this as well. Thank you.
Thank you for your testimony. Oh. The chair recognizes Andrew Schiller.
So thank you. I recommend you ITL this bill. Every person has a right to be safe while they're voting, and this is an infringement on the right to vote. The bill's sponsor suggested that some assumptions on behavior of law, and I don't think we can really do that. And so it's better to err on the side of caution and err on the side of innocence, and therefore this bill should not pass. Thank you.
Thank you for your testimony, and the chair recognizes Dr. Leonard Korn.
So again, it seems like for some people, the Constitution does not allow any restrictions on guns, and the gun violence then in our country will just get greater and greater. Now, this is a bill to make polling places less threatening for some people. Now, obviously, some people who want to carry guns don't find that threatening, but other people do. And intimidation and threatened or actual violence at voting places is so detrimental to our democracy that we'd like this limited restriction to be in place at our voting booths. Thank you very much.
Thank you for your testimony. The chair calls J.E. Simkin in case he's come back. Could someone check on J.E. Simkin for me? Okay. And the chair recognizes Brian Blackton.
I ask you to please ITL this bill. I have a license to carry concealed firearms. I am a federal firearms licensee. I have a constitutional right to carry a firearm. I should not be threatened with incarceration for exercising my right to carry. And don't forget, nobody likes guns until the wolf is knocking on your door. Thank you.
Thank you for your testimony. The chair recognizes William Reyes. Is that Rogers? I'm sorry.
Still can't read it, huh? I apologize for that. Thank you again. My firearm on my side, or rather, I am never a threat when I carry my firearm. My firearm is not a threat at the polling place. It's not a threat at the registry. It's not a threat in the supermarket. It's not a threat at the sidewalk. It's not a threat anywhere because it's on me. The one place I would take exception and where I would not take a gun is to leave it in my car while I go someplace else, because now the potential is there for it to become a threat if someone steals it from my car. And that's not talk. I don't leave my gun in my car ever. And yet, this is the solution. When I go to vote, I put my gun in my car and lock it up and hold. No solution. Thank you.
Thank you for your testimony. And the chair calls Joanne Brown. She's gone. Aldo Axelman. Oh, there he is.
Hi, my name is Alu Axelman. I live in Hooksett with my great wife and son. Speaking in opposition to House Bill 444, I think it should get a quick, swift ITL on consent calendar, hopefully. It's a simple bill that violates the natural right to own property, in this case, the property made of steel and polymer, and it violates the natural right to self-defense. Both those natural rights are also protected by the New Hampshire and U.S. constitutions. I do not know of any place in the New Hampshire or U.S. constitutions that it says we have a right to own firearms except at polling places. There's no exception. As I said on an earlier bill, the founders knew what exceptions were. The Fourth and Fifth Amendments have exceptions. The Second does not. So if you want to amend the Second Amendment or the New Hampshire Constitution to have some exceptions, that's fine. There's a process in the state and federally to amend constitutions. So we can work on a constitutional amendment to add, you have a right to keep firearms except at polling places or except as deemed necessary by the legislature or anytime anything is dangerous ever. You know, that would be a broad amendment. At least then it wouldn't violate the Constitution. So it just infringes on my natural right to be safe at all times, including when I do my civic duty and vote. So thank you very much.
Thank you for your testimony. Dr. Hannon?
Thank you again, Joe Hannon, Gun Owners of New Hampshire. We stand in opposition to House Bill 444. It's a little peculiar. I mean, I understand some of the about carrying a loaded firearm. Carrying an unloaded pistol or revolver firearm is it's still a firearm, but it's more of a paperweight. So it's not something that's dangerous. Whether it's concealed or not, we've had tens of thousands of people carrying concealed or even open carrying firearms for many years in New Hampshire, and I can't think of an incident that has occurred. I mean, there may have, but I just don't know about it. Also, and something that's very concerning is carrying, within 100 feet. You know, I stood at the polls like many of you for years, and we were about 100 feet away where I was because they made us stand back. That's where most, conversations and political dialogue would occur. There's very little happening when people go inside. So it's almost an arbitrary number, and it's not like a bullet can't go 100 feet. So I don't know why 100 feet was picked. If someone has the intent to hurt someone, that's not going to really do anything. And the most dangerous thing is you're allowed to unload a firearm in your car in the parking lot of a polling place. And people that are not very familiar with firearms should know that that is one of the most dangerous times to have a firearm. Carrying it on your hip or even in your safe or on your shelf. You know, if that's my gun, I can leave it there all day. It's not going to do anything. I pick it up and I start messing with it in a parking lot in a cramped space. I'm wearing a winter coat because it's November, election time. It's more dangerous. I don't want to have to do that. If I unload a firearm, it's usually at a range or at a safe place in my home that I have a bulletproof backstop for. I don't want to do that in a parking lot. And that's what would be required for people that normally carry on a daily basis for personal protection and safety. And if they go to vote, that's something you're going to subject not just them to, but the other people in that parking lot. So this bill is actually more dangerous than it first appears at first look. So I'd ask you to please not pass this. You know, we don't want to make a crime and potentially put someone in jail for just under a year for the mere fact that they carried something that was okay here at 101 feet and 100 feet. Now they have to go to jail for almost a year. That's the difference we're talking about. And that makes no sense. I'd be happy to take any questions, but I see your faces, so thank you.
Thank you for your testimony. The chair calls Joshua El Bari, or El Barawe.
Hello, my name is Josh El-Bahraoui. It's close enough. I reside in Manchester, and I am speaking in opposition to this bill. I wanted to note, I believe this is already a non-issue at the most recent state election that I voted in. I saw plenty of people open carrying and most likely concealing firearms at schools. To restrict this in any capacity, I think, as Alu had mentioned, is a violation of natural rights and constitutional rights. So furthermore, I personally would feel extremely unsafe if I'm singled out amongst my peers in any venue, regardless of whether it's a school or not. If it's known that I'm not carrying or legally carrying a firearm, I feel like a sitting duck. So I potentially see this bill as only violating rights and violating my potential safety. If the fear is security, you know, you can increase the security, add more cops, whatever you need to do, but don't violate my rights. Thank you.
Thank you for your testimony. And the chair recognizes Penny Dean.
I am exhibit one of why we need firearms at polling places and everywhere I go. I ask that you ITL this bill. Unfortunately, I'm not the spry young woman that ran distance that I used to be. Some days I hobble around pretty darn bad with a crutch. I gotta tell you, I don't stand a chance against some of the larger boys and more agile people. There's a couple of problems with this bill that I find offensive. Number one, on line 11, law enforcement individuals in uniform are exempt from it. That's not fair. Their life is worth no more than mine is. And it isn't like ones that are working there. We're talking people, they could leave their gun in the car just like the rest of us do. It doesn't say coming and going to work. It doesn't say any of those things. They're just treated special. But the next issue, which I think is larger, is those people talk about what makes them feel uncomfortable. There are people who bikers make them feel uncomfortable. Young kids wearing dreads make them feel uncomfortable. Kid throwing gang signs make them feel uncomfortable. Where do we stop? The bottom line here is there's no proven issues that we've heard about. And you are asking people to give up a constitutional right that is clear on its face in order to exercise the right to vote, which is something that people in this country have spilled blood over. They're both important rights. People shouldn't have to choose. And I'd ask you ITL it, please.
Thank you for your testimony. This bill. Chair recognizes Representative Granger.
Thank you, Mr. Chair and members of the committee. I'll make it very quick. I stand outside of polling places quite a bit. I think we all have done that before. And I really don't want to get shot and not have the ability to shoot back. So for the security of everybody who is a representative, please ITL this bill. Thank you.
Thank you for your testimony. Is anyone holding a pink card who has not turned it in yet? Seeing none, I hereby close the public hearing on HB 444. I hereby open the public hearing on HB 474 and recognize the prime sponsor.
Thank you, Mr. Chair, members of the committee. My name is Tom Minion. I represent Hillsborough 1 Pelham. I'm here to introduce HB 474 relative to enforcement of federal firearms laws and establishment of penalties. Last year, we had a fantastic bill, HB 1178, courtesy of our John Burt. It came through this committee and ultimately was signed into law. It is commonly referred to as gun sanctuary bill, and its language is modeled after immigration sanctuary provisions in other states and cities across the United States. The difference being, this one solidified New Hampshire's dedication to protected citizens' rights against federal overreach. This law was already covered in the hearings all during the day. We've mentioned it many times, so I'll focus on HB 474. During the testimony for a sanctuary bill, one of the chief complaints from our citizens was the lack of penalties or teeth to any law enforcement that decided to ignore this New Hampshire law and aid the feds in trampling our natural rights to keep and bear arms. This bill corrects for that. I consider it a government accountability bill. It waives qualified immunity and permits a wronged individual to have their day in court. Furthermore, I do not believe our state could benefit from employing federal agents that have disregarded our natural rights and bars them from employment if they have a history of doing so. This type of insidious perversion from within would ultimately diminish the quality of law enforcement in the state, dragging them down to the levels of the rights trampling federal agents. We should be ostracizing individuals with this mindset, not allowing them to train alongside or manage police departments and or manage police departments with granted staters that respect the rights of our citizens. The militarization of police, which has caused disharmony and strife in our communities, traces back to federal programs, doctrines, and enforcement of their laws. If we hope to mend the distrust of law enforcement, bills like HB 474 are a path towards it. We should not be employing individuals that consider our rights an obstacle for them to overcome. and create arbitrary rules on the fly with no congressional feedback, only to eventually be struck down by courts after the harm has already been done. I asked the committee to OTP HB 474, and I'm willing to take any questions.
Thank you for your testimony introducing your bill. And the chair recognizes William Rogers. I got it.
Read that one? Thank you again. I'm glad to see a common sense gun control bill on the floor finally. I support this bill. Federal overreach is only getting worse as the federal government becomes more and more politicized, more and more weaponized. We need to protect the Granite State people from the federal laws. I firmly support this bill. Thank you.
Thank you for your testimony. And the chair recognizes Brian Blackman.
The question of self-protection keeps coming up today. I support this bill. The Supreme Court in 1989 in Deshay v. Winnebago County of Social Services stated the police had no duty to protect. In 1981, Warren v. District of Columbia Appeals Court held police have a general duty, but no specific legal duty exists to protect. In 2005, Castle Rock v. Gonzalez sued the police for failing to protect her from her husband after he abducted and killed her 3 children. Justices said police had no such duty to protect them. In 2018, the 11th Circuit upheld the police were not liable for not protecting students in Parkland, Florida, where 17 lives were lost. This simply means we can protect ourselves, and we should. Thank you.
Thank you for your testimony. Chair recognizes the Honorable John Burt.
Thank you, Mr. Chairman. Again, my name is my name is John Burt, but I was a former representative. I support and thank the prime sponsor of this bill. It would enhance my House Bill 1178, where the police cannot be used for a federal unconstitutional gun law. So what I'm hoping for you guys to please do is support House Bill 474 and ITL, the other bill of House Bill 78. And then that way New Hampshire will be even a stronger and more safe. And I trust me in that. We will be the safest state if we can pass this. Thank you.
Thank you for your testimony. And the chair recognizes James Gaffney.
I'm here today to urge you to support this bill. I don't understand why there wouldn't be penalties for a person violating the law under the auspices of their official duties. The construction of the New Hampshire and the federal constitutions are such that the Second Amendment and Article 2 are there to guarantee our rights. And the way they guarantee our rights is to restrict government. Government is the infringer, officially or unofficially, on our natural rights. So restrictions are good. Consequences are similarly good. Thank you very much. I hope you support this bill.
Thank you for your testimony. The chair recognizes Andrew Schuler. Is he still here? Okay, we'll set his card aside. Representative Granger?
Thank you, Mr. Chair and members of the committee. Thank you for the opportunity to testify on this bill. Police accountability is a hot issue on today's heated political climate. This bill is a small step towards ensuring those who protect us don't abuse that trust. The law requires that the state police do not cooperate with federal enforcement. Without penalties, this is merely a polite request. This bill would fix that and send a message that police are not above the law merely because they enforce the law. I wish to remind the committee why this law was required in the first place. The ATF has become a rogue agency, one that arbitrarily changes the rules in drastic ways that render thousands upon thousands of people into being felons for owning firearms that the ATF themselves have approved of. The rules they enforce and frequently change are not the result of changes in law made in Washington. They are mere rule changes put in place by unelected bureaucrats. The ATF is not a simple regulatory body. Their primary purpose is tax collection. When you make a short-barreled shotgun, you are not a felon for possession of a shotgun. It is perfectly legal to have a short-barreled shotgun. This is America. No, you only become a felon if you don't pay the tax on the shotgun. The tax is $200. The ATF just changed the rules and made a wide variety of commonly owned pistols into short-barreled rifles, which are taxed. Short-barreled rifles get taxed, pistols do not. Despite nothing about the firearms themselves being changed, the ATF decided these firearms are taxable, and the punishment for not paying the tax is potentially fatal. Remember, the Ruby Ridge Massacre was started over the potential sale of a short-barreled shotgun without the paying of the appropriate tax. What happens to the people who didn't get the memo that the ATF changed their mind? What is their fate when it is discovered that they didn't pay the tax on a short-barreled rifle they thought was a pistol? Why should everyday gun owners be required to become legal experts in order to exercise basic rights? The least we can do is bar our police from helping the ATF. This bill puts in reasonable penalties for cooperation with a rogue agency. Please OTP HB 474. Thank you for your time.
Thank you for your testimony. Chair recognizes Dr. Leonard Korn.
Thank you again for listening to my testimony. I guess according to some people, it's a natural right to die, and close to 50,000 people in this country die from gun violence, slightly more from suicide than homicide. It's reasonable, again, as I've stated before, to pass common sense laws. And it's reasonable for the state to follow reasonable federal laws. And this type of statute takes us in the wrong direction. Thank you very much.
Thank you for your testimony. The chair recognizes Dr. Johannan.
Hi, Joe Henning, Gunners, New Hampshire. House Bill, I'm opposed. I'm for this one, sorry. It's been after 9 or 10 in a row. We've already heard some arguments. I'm not going to make the same ones, but there's a few good things that I can bring up that haven't been brought up already. We just heard about reasonableness and, we want reasonable laws. Well, wouldn't it be reasonable that if someone violates your rights that they should actually have to pay some consequence for doing so? That is one of the most reasonable things that legislators could possibly come up with. It's accountability. And I think that this does provide that. We have the laws that do protect us from overreach of, the things that are mentioned in here. But, one example in particular is a recent rule. You might have heard about pistol braces now being considered short barrel rifles, and they're now going to require a tax stamp and a long process to go through. Millions of people have them. I even know a few that have them. And now those people are going to be felons if they don't get the tax stamp to pay for something they already had. Something interesting about these things, they're not more lethal if someone holds a short barrel rifle. They're actually a little less strong because the shorter the barrel, the less energy the bullet has when it comes out. So not necessarily more lethal. They might be more maneuverable, but that is actually something that is very useful in a home situation for home defense. It is also very helpful for people with physical disabilities, handicaps, people of smaller stature. The reason why the braces were developed is because some people have maybe a physical difficulty holding it up. Now you might say they don't deserve to have, they shouldn't have a firearm, but there's some people that just need a reasonable accommodation. And that's something we allow people for all things in society, including surgery. I was a surgeon. I knew doctors that couldn't do certain things without having a reasonable accommodation. And they were allowed to operate on people if they were given a stool or a certain prosthetic to use of some sort. This is something that's very important to people, and I think it's important to have a reasonable consequence to violating someone's rights. So please pass this bill, and I'm not taking any questions. It's late. Thanks.
Thank you for your testimony. Andrew Schuler.
Thank you for your patience. Just heading in my car. Anyways, so I would like to support this bill. There are too many infringements generally with when the government, like the Fed, isn't serving the people. There's little incentive to change laws to serve the people, and this law is used to force the government to serve us and allow for firearms as a natural right as a citizen of the United States. And the idea here was to force, or I support the forcing of the public officials to be served, and by allowing other public servants like police to force the public official to, take the punishment for having not served the people. Thanks, that's all.
Thank you for your testimony. The chair recognizes Alu Exelman.
Hi, my name is still Lou Axelman. I still live in Hooksett. I'm speaking in support of House Bill 474. I think it's a great common sense bill that would use a state law to protect our natural rights to property and self-defense. And I think it's great that Representative Mannion put in some punishments. In this bill, it's in the form of a civil cause of action as opposed to criminal penalties. I think it's great. I don't think it's too strong at all. I think it's really appropriate that if law enforcement agents violate their oath of office, violate the natural rights of the citizens they're sworn to protect, that there should be a civil cause of action to sue them in court for violating our rights. So I urge you all to please support this OTP. Thank you very much. I'm happy to take questions.
Thank you for your testimony. Chair recognizes Penny Dean.
Thank you, Chair and members of the committee. This bill also, although I support the concept, I do not support the language. It also gets a black ribbon. And here's the problems that I see. In the law, we have a saying, it's called sauce for the goose, sauce for the gander, which means each side needs to be treated equally. There are certainly a lot of bad law enforcement. I've had some retaliate against me personally, but this does not make it clear to a person of average intelligence what is prohibited. And just like we have to have speed limit lines on the highway before we get pulled over for a ticket, law enforcement needs to know what they can and can't do. And I think what's most important to me here, if any of you have followed the exculpatory evidence schedule or the Lori list, there are certainly a lot of officers that were put on it that I'm not sure belonged on it, and it was politics because your supervisor could put you on it. There are also a ton of officers that need to be on it that aren't. And so when you look at, for example, 159E, which is page 3, line 30, I want bad law enforcement law more than anybody, way more than anybody probably, but they get hearings, they get due process just like we do. And I think all of us, in order to have good law enforcement, you have to treat them fairly. And I think this bill is a wonderful concept, but it needs to be retained and it needs to have a whole lot of work done to it. Because we need more specifics as to what you're prohibiting and what you consider to be a violation of our rights. And I think there's a whole list that can be put together. But when you look at this, the way it is now, the other and most important thing, which prosecutor is going to be assigned to do this? Because if you don't assign them, prosecutors have absolute prosecutorial discretion. You won't have anybody bringing charges, and that's a problem. And I can think of Catherine Rogers when she was the county attorney, and she and I agreed on little. But one particular time when Brian Blackton's camera was wrongfully seized, she ordered the state police to return it to him. They refused. Her answer is, who's going to be bringing your felony cases in Merrimack County, boys? And so you have to look at that and you have to say who specifically is going to be responsible for that, and will that be a person who's willing to buck the boys in blue? and do whatever the right thing is. But this is not clear. It's not fair to the police, quite frankly. And coming out of my mouth, people say Penny Dean saying that, but I'm like, I'm for fairness. And I just don't think this is fair and clear. Thank you.
Thank you for your testimony. To be clear, on your card, you marked support. Are you?
With amendments, support with amendments.
So as is, non-support.
And as is, I would not support, but support the concept and support with amendments. Because I support it, but not in this language, because I don't think it's workable.
And I would suggest the sponsor, wherever he is, take advantage of free legal advice and speak to
Yeah,
Penny Dean.
and again, it's thank you to the sponsor, and it's a good concept, because we all need to be treated fairly, but I just don't think it'll do what he wants it to do.
There he stands. Anyone else? Anyone holding a pink card who hasn't turned it in yet? There being none, I hereby close the public hearing on HB 474, and we are going to take a 9-minute break. Huh? We are, but some people had to.
You ain't kidding.
Jonah.
At this time, I call or open the public hearing on HB 512 and recognize Representative Gerhard to introduce this bill.
Thank you, Chairman, members of the committee. You guys are definitely putting in overtime tonight. Bill 512 would allow any firearm or accessory that's made within, and ammunition, it covers a lot of things, made within the confines of the state of New Hampshire to not be subject to federal jurisdiction. So I was going to take a different tack because I have a feeling that the people behind me are going to cover the whole gun rights aspect of this and just go into how the federal government actually claims ownership over things that happen within a state. So in 1940, 1942 to be specific, there was a farmer in Ohio, Roscoe Filburn. He produced a greater quantity of wheat than what Congress had allowed under the Agricultural Adjustment Act. They were trying to stabilize the price of wheat. So he grew 23 acres, which was double what he was allotted by the powers that ought not be. So writing through unanimous Supreme Court, they found that the Commerce Clause gives Congress the power to regulate prices in the industry, and this law was rationally related to that legitimate goal. Okay. He pointed out that Filburn would not have needed to buy wheat if he had not used his own wheat for personal consumption. So this man did not sell any wheat over state lines. He simply fed it to his livestock. And they claimed, well, I'll finish up. He pointed out Filburn would have needed to buy wheat if he had not used his own wheat for personal consumption. So his choice still affected the national economy and interstate commerce by removing a buyer from the market. So my whole argument would be, it's absurd. Why does the federal government have the ability to tell us what we can own in this state? If we, as a legislature, choose to outlaw certain guns or accessories or whatever it may be, let's do it. Fine. Let's have the debate here and figure it out. But to delegate that authority to a bunch of unelected bureaucrats, because what's been going on with the ATF, they say, oh, this is legal today, that's not illegal. Then they want to go raid people's houses with no-knock warrants. That bill is coming up tomorrow. But the point being is, I think we need to really, well, first off, read the New Hampshire State Constitution, Article 7, state sovereignty, and just say, okay, this is our state. People within the state, they want to produce a gun within the confines of this state. It's subject to this state's jurisdiction, not the federales. So I had probably not going to have any questions, but I'll take some. Okay.
Thank you for your testimony. The chair recognizes Tom Mannion.
Thank you, Mr. Chair, members of the committee. My name is Tom Minion, Hillsborough 1, Pelham. I'm here to speak in support of HB 512. The one thing we did cover, my testimony is covering a lot of the exact same ground with the Filburn case. I do believe that that's the impetus of a lot of the problems that we're seeing from the federal government, where they just assume that because anything could potentially ever be sold across state lines, it is now covered by the Interstate Commerce Clause. I completely disagree with this interpretation. I think it's important now that we states with the current makeup of the SCOTUS that we do begin to reevaluate this activist judge behavior from almost a century ago that has given us the monster behemoth that is the federal government that we see today. So I'm here speaking in support, OTP, HB 512, and I'm willing to take any of your questions.
Thank you for your testimony. The chair calls William Rogers. I finally got his name right. The chair calls Dr. Leonard Korn. The chair calls Andrew Schuller.
Thank you again for inviting me. So I think I support this bill. I think that the federal firearms laws, especially NFA, are arbitrarily enforced. See the recent ruling with the pistol brace rule. And I think that New Hampshire citizens should have an option to opt out of interstate commerce and therefore these federal regulations, as long as they the full use of the Second Amendment, or reserving right to use the Second Amendment if within the state of New Hampshire shouldn't use federal regulations. And the current regulations, because they're so arbitrarily enforced, it creates felons out of your neighbors and friends and family, and there's nothing you can do about it. And I'd also like to say that one part of the NFA it mentions all other weapons. Well, anything can become a weapon with some creativity and intent. So instead of trying to just immediately make everything government regulated, free New Hampshire residents from this overregulation. Thanks. That's all I had to say.
Thank you for your testimony. Chair calls Dr. Johannan.
Thank you for hearing me today. Joe, Gun Owners New Hampshire. This is at my after 5 o'clock version of testifying. We're in support of the bill. I think it's very important that we realize that this is, as needed as this bill is, it's going to be a very limited scope. It's got to be manufactured in New Hampshire for actual firearms. Accessories are a little different in the bill, but it's, we're not going to have to pull the iron out of the ground ourselves and get the ore, but you're going to have to make everything from the raw materials. That's a very intensive process, but it's actually a very exciting process for New Hampshire. There's a lot of potential business and development opportunities this could bring about. And made in New Hampshire is something that we're very proud of. I'm wearing Limber boots from up in the White Mountains. They're the oldest boot in the country. You should try them. But anyway, I think you should really consider passing this. The only comment I would make is, and I'm not against it, but I think I'd be willing to bend on the penalty parts of Class A misdemeanor and Class B felony. I think, like I said before, punishments are definitely something that are needed. But I'm not sure 7 years in prison is the acceptable response. Some people may differ, but there should be some penalties. But I'm up for negotiation if these are something that would be sticking points for some members. Thank you, and good night.
Thank you for your testimony. And the chair calls William Rogers.
Thank you again. I support this bill. I think New Hampshire-made firearms would be a great thing, and that we should regulate it in state and completely out of federal control. Thank you.
Thank you. The chair calls Dr. Corn.
Thank you again for being here for this long day. So I don't think we should give a free pass to any manufacturer, whether due to faulty guns or faulty cars or anything that's faulty, nor should we allow any manufacturer to falsely advertise and promote products that malfunction and cause harm. And so I don't think we should give a pass to a company that makes a firearm or a firearm accessory in New Hampshire if it's malfunctions. We should insist that all products made in New Hampshire function properly. Guns kill, and it's obviously important that gun manufacturers produce safe guns and safe devices. And this law would allow great exceptions to that basic principle. Thank you very much.
Thank you for that testimony. Representative Granger.
Thank you, Mr. Chair and members of the committee. The Interstate Commerce Clause has been abused for a very long time. This bill does something very small to help granite state businesses operate smoothly in an area where federal government tries its darndest to usurp the power of the states. It wields the Interstate Commerce Clause like a sledgehammer. Everything that can potentially be bought or sold may, apparently, be regulated by the federal government. Their army of bureaucrats stands ready to tell everyone what to do at all times unless states come in and protect their citizens and their businesses. This bill would protect New Hampshire firearm manufacturers from an enormous amount of bureaucracy. We love our local businesses. Every dollar they spend on compliance is another dollar they can't spend on our workforce. This bill doesn't spare them the wrath of regulators when the manufacturers export their products to other states. Therefore, any firearms company that wishes to have safe products that are sold in other states, they will be making sure that their products are safe. You guys are probably eager to get out of Dodge, so I'll leave it at that. Thank you very much.
Thank you for your testimony. The chair calls Alo Axelman.
Hi, thank you. My name is still Lou Axelman. I still live in Hooksett. I'm speaking in support of House Bill 512. I think it's a simple bill that just reasserts our 10th Amendment type states' rights, that the state is supposed to be sovereign as per Article 7 of the New Hampshire Constitution. Like a few others alluded to today, the federal government for decades now, maybe 100 years, has been using the Commerce Clause in the Constitution to say they can control everything in the universe. And here's how. The Supreme Court ruled in Wickard versus Filburn, like 80 years ago, that even if a person grows grain, wheat on his own property, feeds it to his own cows, because theoretically he's feeding his cows from his own grow and not buying it from the neighboring state because he lived on the border of Iowa and Nebraska or something, technically the price of the market of wheat could be affected because he's growing his own. Therefore, anything in the universe that could affect any price of anything ever could be interstate commerce because it affects prices. And I think Wickard versus Filburn, which might have been the most broad and terrible Supreme Court case in the history of existence, but there are a lot to choose from. That was one of the worst things, and that's what allowed the federal government to say anything is commerce. If I grow something, if I collect my own rainwater and I buy less Poland Spring from Maine, I'm affecting the price, and it's interstate from New Hampshire to Maine. So it's obviously preposterous. Any 3-year-old with 12 brain cells understands that it's way too far, and this pushes back a little bit on this Commerce Clause by saying things made in the state by Ruger or Sig Sauer, kept in the state and carried by me, my SIG on my hip, the federal government should have zero involvement at all. There's no justification for it, and it will be a violation of the 10th Amendment and under the use of their Commerce Clause, which I reject. So thank you very much. I'm happy to take questions.
Thank you for your testimony.
Thank you.
Chair calls Joshua Elabrare.
Thank you. Take two, and my name was much better this time. I am speaking in support of this House Bill 512. And I wanted to say, generally on principle, it is my firm belief that any laws restricting guns, accessories, etc., is a violation of the Constitution. But let's think even more just practically for a moment. As many of others have alluded already, a lot of federal gun laws are ill-informed at best and schizophrenic at worst. You know, a law can be passed with no grandfathering clause that turns millions of law-abiding people suddenly into criminals. They can't even go and, address the law themselves. Already they are a criminal. There are all sorts of laws that are not based in any real science or reason. For example, silencers have all sorts of restrictions and rules on them and are outright illegal in many places. Silencers realistically are a tool to preserve people's hearing when they're shooting. I don't know if people think that Hollywood and video game rules apply to these things, where you can simply shoot somebody and someone 5 feet away has no clue. That is certainly ridiculous to me. And there's all sorts of things like this in the legal code if you look. So I think the people of New Hampshire pride themselves on being free. There is certainly a culture of freedom vis-a-vis guns and other things in this state. It's one of the reasons that I moved 6 months ago. And I simply do not wish to be under the purvey of the federal government that can arbitrarily impose whatever they like at any time. It's ridiculous. I'm a little surprised it's taken this long to kind of bring this up. So I very much support this bill. Thank you for your time.
Thank you for your testimony. Chair calls James Gaffney. For the last time today, I believe.
I hope so. Until Friday, I guess. I support the bill. I won't belabor the points over and over again. Enough's been said. Thank you.
Thank you for your testimony. And the chair calls Penny Dean.
I support this bill and I ask you vote ought to pass. This is fundamental fairness for gun owners, gun manufacturers, and dealers. Let me tell you just about 3 basic things. Native Americans had a term, he speak with forked tongue. And what that basically means is people lied and changed their mind and went back on their deals. Here's why that matters. There's 3 recent things in our lifetime that's happened to gun owners in this state with the ATF. Street sweepers, FRT triggers, and bump stocks. The man who initially, or men and companies who initially marketed each one of those got what I call a good boy letter from the ATF. They submitted it to the ATF, and the ATF said, this is how we characterize it. And then the next thing you know, the ATF said, for example, when it came to bump stocks, you can thank anti-gun President Trump for this one. They said, when it came to bump stocks, oh no, these are full autos now. They had a letter, an opinion, nothing didn't change on them other than politics. They have the FRT triggers right now. People paid $300 to $500 for those triggers. Yeah, and anyone who has one lately has been getting letters from the ATF that says either forfeit them or we're going to come arrest you and seize them. I have plenty of clients with those letters because they went to the manufacturer and the seller of those and seized all their records. So they knew they sent them to person A and person B and person C, sent them letters. And if you don't do the right thing when you turn them over to the ATF, meaning the proper legal things, you lose your right to get them back if there's any lawsuits or anything. That matters. I have several cases of those going right now, and the clients know freedom isn't free. And to handle each case, you're talking thousands of dollars for a $350 or $340 thing. But for those clients, it's principle. They're not going to turn over products without having a chance to get them back. But if you see the ATF at your door and they say, you give it to us now, or we're coming to your house, we're taking it, and we're charging you with a felony. That's pretty scary. And you're just like, wait a minute, here's a letter. Yeah, we rescinded that letter years later. Oh, is there a trickery? No, we just rescinded it. There's no explanation. It's called tough luck Chuck. Those are just 3 examples. Street sweepers, they gave people 30 days to register them, which they went from a Title I, Title III. And thank you very much. So please vote this ought to pass.
Thank you. Anyone else with a pink card who wasn't testified? Did you want to? With that, I will close the public hearing on HB 512. I'd like to, first of all, thank the members for staying so late. I'd like to thank the legislative staff who have stayed here to ensure this video keeps working and the lights are on and that we are here safe. And I'd like to thank all the citizens who took time out of their day to come here today and exercise their civil rights. And I wish you all a good night.